Part 1 of Dred Scott v. Sandford. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Dred Scott v. Sandford. An Opinion of the United States Supreme Court. Part 1. Decided on March 6, 1857. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or any concurring or dissenting opinion. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Chief Justice Taney delivered the opinion of the court. This case has been twice argued. After the argument at the last term, differences of opinion were found to exist among the members of the court, and as the questions in controversy are of the highest importance, and the court was at that time much pressed by the ordinary business of the term, it was deemed advisable to continue the case and direct a re-argument on some of the points, in order that we might have an opportunity of giving to the whole subject a more deliberate consideration. It has accordingly been again argued by counsel and considered by the court, and I now proceed to deliver its opinion. There are two leading questions presented by the record. Number 1. Had the Circuit Court of the United States jurisdiction to hear and determine the case between these parties? And number 2, if it had jurisdiction, is the judgment it has given erroneous or not? The plaintiff in error, who was also the plaintiff in the court below, was, with his wife and children, held as slaves by the defendant in the state of Missouri, and he brought this action in the Circuit Court of the United States for that district to assert the title of himself and his family to freedom. The declaration is in the form usually adopted in that state to try questions of this description, and contains the averment necessary to give the court jurisdiction, that he and the defendant are citizens of different states, that is, that he is a citizen of Missouri and the defendant a citizen of New York. The defendant pleaded in abatement to the jurisdiction of the court that the plaintiff was not a citizen of the state of Missouri, as alleged in his declaration, being a Negro of African descent, whose ancestors were of pure African blood, and who were brought into this country and sold as slaves. To this plea the plaintiff demurred, and the defendant joined in demurrer. The court overruled the plea and gave judgment that the defendant should answer over, and he thereupon put in sundry pleas in bar, upon which issues were joined, and at the trial the verdict and judgment were in his favor, whereupon the plaintiff brought this writ of error. Before we speak of the pleas in bar, it will be proper to dispose of the questions which have arisen on the plea in abatement. That plea denies the right of the plaintiff to sue in a court of the United States for the reasons therein stated. If the question raised by it is legally before us, and the court should be of opinion that the facts stated in it disqualify the plaintiff from becoming a citizen, in the sense in which that word is used in the Constitution of the United States, then the judgment of the Circuit Court is erroneous and must be reversed. It is suggested, however, that this plea is not before us, and that as the judgment in the court below on this plea was in favor of the plaintiff, he does not seek to reverse it, or bring it before the court for revision by his writ of error, and also that the defendant waived this defense by pleading over, and thereby admitted the jurisdiction of the court. But, in making this objection, we think the peculiar and limited jurisdiction of courts of the United States has not been averted to. This peculiar and limited jurisdiction has made it necessary, in these courts, to adopt different rules and principles of pleading, so far as jurisdiction is concerned, from those which regulate courts of common law in England and in the different states of the Union which have adopted the common law rules. In these last mentioned courts, where their character and rank are analogous to that of a Circuit Court of the United States, in other words, where they are what the law terms courts of general jurisdiction, they are presumed to have jurisdiction unless the contrary appears. No averment in the pleadings of the plaintiff is necessary in order to give jurisdiction. If the defendant objects to it, he must plead it specially, and unless the fact on which he relies is found to be true by a jury, or admitted to be true by the plaintiff, the jurisdiction cannot be disputed in an appellate court. Now, it is not necessary to inquire whether, in courts of that description, a party who pleads over in bar, when a plea to the jurisdiction has been ruled against him, does or does not waive his plea. nor whether, upon a judgment in his favor on the pleas in bar, and a writ of error brought by the plaintiff, the question upon the plea in abatement would be open for revision in the appellate court. Cases that may have been decided in such courts, or rules that may have been laid down by common law pleaders, can have no influence in the decision in this court, because under the Constitution and laws of the United States, the rules which govern the pleadings in its courts in questions of jurisdiction stand on different principles and are regulated by different laws. This difference arises, as we have said, from the peculiar character of the government of the United States, for although it is sovereign and supreme in its appropriate sphere of action, yet it does not possess all the powers which usually belong to the sovereignty of a nation. Certain specified powers enumerated in the Constitution have been conferred upon it, and neither the legislative, executive, nor judicial departments of the government can lawfully exercise any authority beyond the limits marked out by the Constitution. And in regulating the judicial department, the cases in which the courts of the United States shall have jurisdiction are particularly and specifically enumerated and defined, and they are not authorized to take cognizance of any case which does not come within the description therein specified. Hence, when a plaintiff sues in a court of the United States, it is necessary that he should show, in his pleading, that the suit he brings is within the jurisdiction of the court, and that he is entitled to sue there. And if he omits to do this, and should, by any oversight of the circuit court, obtain a judgment in his favor, the judgment would be reversed in the appellate court for want of jurisdiction in the court below. The jurisdiction would not be presumed, as in the case of a common law English or state court, unless the contrary appeared. But the record, when it comes before the appellate court, must show affirmatively that the inferior court had authority under the Constitution to hear and determine the case. And if the plaintiff claims a right to sue in a circuit court of the United States, under that provision of the Constitution which gives jurisdiction in controversies between citizens of different states, he must distinctly aver in his pleading that they are citizens of different states, and he cannot maintain his suit without showing that fact in the pleadings. This point was decided in the case of Bingham v. Cabot, and ever since adhered to by the court. And in Jackson v. Ashton, it was held that the objection to which it was open could not be waived by the opposite party, because consent of parties could not give jurisdiction. It is needless to accumulate cases on this subject. Those already referred to, and the cases of Capron v. Van Noorden and Montalais v. Murray, are sufficient to show the rule of which we have spoken. The case of Capron v. Van Noorden strikingly illustrates the difference between a common law court and a court of the United States. If, however, the fact of citizenship is averred in the declaration, and the defendant does not deny it, and put it in issue by plea and abatement, he cannot offer evidence at the trial to disprove it, and consequently cannot avail himself of the objection in the appellate court, unless the defect should be apparent in some other part of the record. For if there is no plea and abatement, and the want of jurisdiction does not appear in any other part of the transcript brought up by the writ of error, the undisputed averment of citizenship in the declaration must be taken in this court to be true. In this case, the citizenship is averred, but it is denied by the defendant in the manner required by the rules of pleading, and the fact upon which the denial is based is admitted by the demurrer. And if the plea and the demurrer and judgment of the court below upon it are before us upon this record, the question to be decided is whether the facts stated in the plea are sufficient to show that the plaintiff is not entitled to sue as a citizen in a court of the United States. We think they are before us. The plea and abatement and the judgment of the court upon it are a part of the judicial proceedings in the circuit court, and are there recorded as such, and a writ of error always brings up to the superior court the whole record of the proceedings in the court below. And in the case of the United States v. Smith, this court said that the case being brought up by writ of error, the whole record was under the consideration of this court, and this being the case, in the present instance, the plea and abatement is necessarily under consideration, and it becomes, therefore, our duty to decide whether the facts stated in the plea are or are not sufficient to show that the plaintiff is not entitled to sue as a citizen in a court of the United States. This is certainly a very serious question, and one that now for the first time has been brought for decision before this court. but it is brought here by those who have a right to bring it, and it is our duty to meet it and decide it. The question is simply this: can a Negro, whose ancestors were imported into this country and sold as slaves, become a member of the political community formed and brought into existence by the Constitution of the United States, and as such become entitled to all the rights and privileges and immunities guaranteed by that instrument to the citizen, one of which rights is the privilege of suing in a court of the United States in the cases specified in the Constitution? It will be observed that the plea applies to that class of persons only whose ancestors were Negroes of the African race and imported into this country and sold and held as slaves. The only matter in issue before the court, therefore, is whether the descendants of such slaves, when they shall be emancipated, or who are born of parents who have become free before their birth, are citizens of a state in the sense in which the word citizen is used in the Constitution of the United States. And this being the only matter in dispute on the pleadings, the court must be understood as speaking in this opinion of that class only, that is, of those persons who are the descendants of Africans who were imported into this country and sold as slaves. The situation of this population was altogether unlike that of the Indian race. The latter, it is true, formed no part of the colonial communities, and never amalgamated with them in social connections or in government. But although they were uncivilized, they were yet a free and independent people, associated together in nations or tribes and governed by their own laws. Many of these political communities were situated in territories to which the white race claimed the ultimate right of dominion, but that claim was acknowledged to be subject to the right of the Indians to occupy it as long as they thought proper, and neither the English nor colonial governments claimed or exercised any dominion over the tribe or nation by whom it was occupied, nor claimed the right to the possession of the territory until the tribe or nation consented to cede it. These Indian governments were regarded and treated as foreign governments, as much so as if an ocean had separated the red man from the white, and their freedom has constantly been acknowledged from the time of the first emigration to the English colonies to the present day by the different governments which succeeded each other. Treaties have been negotiated with them and their alliance sought for in war, and the people who compose these Indian political communities have always been treated as foreigners, not living under our government. It is true that the course of events has brought the Indian tribes within the limits of the United States under subjection to the white race, and it has been found necessary for their sake as well as our own to regard them as in a state of pupilage, and to legislate to a certain extent over them and the territory they occupy. But they may, without doubt, like the subjects of any other foreign government, be naturalized by the authority of Congress and become citizens of a state and of the United States, and if an individual should leave his nation or tribe and take up his abode among the white population, he would be entitled to all the rights and privileges which would belong to an emigrant from any other foreign people. We proceed to examine the case as presented by the pleadings. The words people of the United States and citizens are synonymous terms and mean the same thing. They both describe the political body who, according to our republican institutions, form the sovereignty and who hold the power and conduct the government through their representatives. They are what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of the sovereignty. The question before us is whether the class of persons described in the plea and abatement compose a portion of this people and are constituent members of the sovereignty. We think they are not, and that they are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and, whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and the government might choose to grant them. It is not the province of the court to decide upon the justice or injustice, the policy or impolicy of these laws. The decision of that question belonged to the political or lawmaking power, to those who formed the sovereignty and framed the Constitution. The duty of the court is to interpret the instrument they have framed with the best lights we can obtain on the subject, and to administer it as we find it, according to its true intent and meaning when it was adopted. In discussing this question, we must not confound the rights of citizenship which a state may confer within its own limits and the rights of citizenship as a member of the Union. It does not by any means follow, because he has all the rights and privileges of a citizen of a state, that he must be a citizen of the United States. He may have all of the rights and privileges of the citizen of a state, and yet not be entitled to the rights and privileges of a citizen in any other state. For previous to the adoption of the Constitution of the United States, every state had the undoubted right to confer on whomsoever it pleased the character of citizen, and to endow him with all its rights. But this character, of course, was confined to the boundaries of the state, and gave him no rights or privileges in other states beyond those secured to him by the laws of nations and the comity of states. Nor have the several states surrendered the power of conferring these rights and privileges by adopting the Constitution of the United States. Each state may still confer them upon an alien or anyone it thinks proper, or upon any class or description of persons, yet he would not be a citizen in the sense in which that word is used in the Constitution of the United States, nor entitled to sue as such in one of its courts, nor to the privileges and immunities of a citizen in the other states. The rights which he would acquire would be restricted to the state which gave them. The Constitution has conferred on Congress the right to establish a uniform rule of naturalization, and this right is evidently exclusive and has always been held by this court to be so. Consequently, no state, since the adoption of the Constitution, can, by naturalizing an alien, invest him with the rights and privileges secured to a citizen of a state under the federal government, although, so far as the state alone was concerned, he would undoubtedly be entitled to the rights of a citizen and clothed with all the rights and immunities which the Constitution and laws of the state attach to that character. It is very clear, therefore, that no state can, by an act or law of its own, passed since the adoption of the Constitution, introduce a new member into the political community created by the Constitution of the United States. It cannot make him a member of this community by making him a member of its own, and for the same reason it cannot introduce any person or description of persons who were not intended to be embraced in this new political family, which the Constitution brought into existence, but were intended to be excluded from it. The question then arises whether the provisions of the Constitution, in relation to the personal rights and privileges to which the citizen of a state should be entitled, embraced the Negro African race at that time in this country, or who might afterwards be imported, who had then or should afterwards be made free in any state, and to put it in the power of a single state to make him a citizen of the United States and endue him with the full rights of citizenship in every other state without their consent. Does the Constitution of the United States act upon him whenever he shall be made free under the laws of a state, and raised there to the rank of a citizen, and immediately clothe him with all the privileges of a citizen in every other state and in its own courts? The court think the affirmative of these propositions cannot be maintained, and if it cannot, the plaintiff in error could not be a citizen of the state of Missouri within the meaning of the Constitution of the United States, and consequently was not entitled to sue in its courts. It is true, every person in every class and description of persons who were at the time of the adoption of the Constitution recognized as citizens in the several states became also citizens of this new political body, but none other. It was formed by them and for them and their posterity, but for no one else. And the personal rights and privileges guaranteed to citizens of this new sovereignty were intended to embrace those only who were then members of the several state communities, or who should afterwards by birthright or otherwise become members, according to the provisions of the Constitution and the principles on which it was founded. It was the union of those who were at that time members of distinct and separate political communities into one political family, whose power, for certain specified purposes, was to extend over the whole territory of the United States, and it gave to each citizen rights and privileges outside of his state which he did not before possess, and placed him in every other state upon a perfect equality, with its own citizens as to rights of person and rights of property, it made him a citizen of the United States. It becomes necessary, therefore, to determine who were citizens of the several states when the Constitution was adopted. And in order to do this, we must recur to the governments and institutions of the 13 colonies when they separated from Great Britain and formed new sovereignties and took their places in the family of independent nations. We must inquire who at that time were recognized as the people or citizens of a state, whose rights and liberties had been outraged by the English government, and who declared their independence and assumed the powers of government to defend their rights by force of arms. In the opinion of the court, the legislation and histories of the times, and the language used in the Declaration of Independence show that neither the class of persons who had been imported as slaves, nor their descendants, whether they had become free or not, were then acknowledged as a part of the people, nor intended to be included in the general words used in that memorable instrument. It is difficult at this day to realize the state of public opinion in relation to that unfortunate race, which prevailed in the civilized and enlightened portions of the world at the time of the Declaration of Independence, and when the Constitution of the United States was framed and adopted. But the public history of every European nation displays it in a manner too plain to be mistaken. They had, for more than a century before, been regarded as beings of an inferior order, and altogether unfit to associate with the white race, either in social or political relations, and so far inferior they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. He was bought and sold, and treated as an ordinary article of merchandise and traffic whenever a profit could be made by it. This opinion was at that time fixed and universal in the civilized portion of the white race. It was regarded as an axiom, in morals as well as in politics, which no one thought of disputing, or supposed to be open to dispute. And men in every grade and position in society daily and habitually acted upon it in their private pursuits, as well as in matters of public concern, without doubting for a moment the correctness of this opinion. And in no nation was this opinion more firmly fixed or more uniformly acted upon than by the English government and English people. They not only seized them on the coast of Africa and sold them or held them in slavery for their own use, but they took them as ordinary articles of merchandise to every country where they could make a profit on them, and were far more extensively engaged in this commerce than any other nation in the world. The opinion thus entertained and acted upon in England was naturally impressed upon the colonies they founded on this side of the Atlantic, and accordingly a Negro of the African race was regarded by them as an article of property, and held, and bought and sold as such, in every one of the 13 colonies which united in the Declaration of Independence and afterwards formed the Constitution of the United States. The slaves were more or less numerous in the different colonies, as slave labor was found more or less profitable, but no one seems to have doubted the correctness of the prevailing opinion of the time. The legislation of the different colonies furnishes positive and indisputable proof of this fact. It would be tedious in this opinion to enumerate the various laws they passed upon this subject. It will be sufficient as a sample of the legislation which then generally prevailed throughout the British colonies to give the laws of two of them, one being still a large slaveholding state, and the other the first state in which slavery ceased to exist. The province of Maryland in 1717 passed a law declaring that if any free Negro or mulatto intermarry with any white woman, or if any white man shall intermarry with any Negro or mulatto woman, such Negro or mulatto shall become a slave during life, excepting mulattoes born of white women, who for such intermarriage shall only become servants for 7 years, to be disposed of as the justices of the county court, where such marriage so happens, shall think fit, to be applied by them towards the support of a public school within the said county. And any white man or white woman who shall intermarry as aforesaid with any Negro or mulatto, such white man or white woman shall become servants during the term of 7 years, and shall be disposed of by the justices as aforesaid, and be applied to the uses aforesaid. The other colonial law to which we refer was passed by Massachusetts in 1705. It is entitled An Act for the Better Preventing of a Spurious and Mixed Issue, and it provides that if any Negro or mulatto shall presume to smite or strike any person of the English or other Christian nation, such Negro or mulatto shall be severely whipped at the discretion of the justices before whom the offender shall be convicted, and that none of Her Majesty's English or Scottish subjects, nor of any other Christian nation within this province, shall contract matrimony with any Negro or mulatto, nor shall any person duly authorized to solemnize marriage presume to join any such in marriage, on pain of forfeiting the sum of £50, one moiety thereof to Her Majesty, for and towards the support of the government within this province, and the other moiety to him or them that shall inform and sue for the same, in any of Her Majesty's courts of record within the province, by bill, plaint, or information. We give both of these laws in the words used by the respective legislative bodies, because the language in which they are framed, as well as the provisions contained in them, show too plainly to be misunderstood the degraded condition of this unhappy race. They were still in force when the Revolution began, and are a faithful index to the state of feeling towards the class of persons of whom they speak, and of the position they occupied throughout the 13 colonies, in the eyes and thoughts of the men who framed the Declaration of Independence and established the state constitutions and governments. They show that a perpetual and impassable barrier was intended to be erected between the white race and the one which they had reduced to slavery, and governed as subjects with absolute and despotic power, and which they then looked upon as so far below them in the scale of created beings that intermarriages between white persons and Negroes or mulattoes were regarded as unnatural and immoral and punished as crimes, not only in the parties, but in the person who joined them in marriage. And no distinction in this respect was made between the free Negro or mulatto and the slave, but this stigma of the deepest degradation was fixed upon the whole race. We refer to those historical facts for the purpose of showing the fixed opinions concerning that race, upon which the statesmen of that day spoke and acted. It is necessary to do this in order to determine whether the general terms used in the Constitution of the United States as to the rights of man and the rights of the people was intended to include them, or to give to them or their posterity the benefit of any of its provisions. The language of the Declaration of Independence is equally conclusive. It begins by declaring that when in the course of human events it becomes necessary for one people to dissolve the political bands which have connected them with another, and to assume among the powers of the earth the separate and equal station to which the laws of nature and nature's God entitle them, a decent respect for the opinions of mankind requires that they should declare the causes which impel them to the separation. It then proceeds to say, we hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among them is life, liberty, and the pursuit of happiness, that to secure these rights governments are instituted deriving their just powers from the consent of the governed. The general words above quoted would seem to embrace the whole human family, and if they were used in a similar instrument at this day, would be so understood. But it is too clear for dispute that the enslaved African race were not intended to be included, and formed no part of the people who framed and adopted this declaration. For if the language as understood in that day would embrace them, the conduct of the distinguished men who framed the Declaration of Independence would have been utterly and flagrantly inconsistent with the principles they asserted, and instead of the sympathy of mankind to which they so confidently appealed, they would have deserved and received universal rebuke and reprobation. Yet the men who framed this declaration were great men, high in literary acquirements, high in their sense of honor, and incapable of asserting principles inconsistent with those on which they were acting. They perfectly understood the meaning of the language they used, and how it would be understood by others, and they knew that it would not in any part of the civilized world be supposed to embrace the Negro race, which by common consent had been excluded from civilized governments and the family of nations, and doomed to slavery. They spoke and acted according to the then established doctrines and principles, and in the ordinary language of the day, and no one misunderstood them. The unhappy black race were separated from the white by indelible marks, and laws long before established, and were never thought of or spoken of except as property, and when the claims of the owner or the profit of the trader were supposed to need protection. This state of public opinion had undergone no changes when the Constitution was adopted, as is equally evident from its provisions and language. The brief preamble sets forth by whom it was formed, for what purposes, and for whose benefit and protection. It declares that it is formed by the people of the United States, that is to say, by those who were members of the different political communities in the several states, and its great object is declared to be to secure the blessings of liberty to themselves and their posterity. It speaks in general terms of the people of the United States and of citizens of the several states, when it is providing for the exercise of the powers granted or the privileges secured to the citizen. It does not define what description of persons are intended to be included under these terms, or who shall be regarded as a citizen and one of the people. It uses them as terms so well understood that no further description or definition was necessary. But there are two clauses in the Constitution which point directly and specifically to the Negro race as a separate class of persons, and show clearly that they were not regarded as a portion of the people or citizens of the government then formed. One of these clauses reserves to each of the 13 states the right to import slaves until the year 1808, if it thinks proper. And the importation which it thus sanctions was unquestionably of persons of the race of which we are speaking, as the traffic in slaves in the United States had always been confined to them. And by the other provision, the states pledged themselves to each other to maintain the right of property of the master by delivering up to him any slave who may have escaped from his service and be found within their respective territories. By the first above-mentioned clause, therefore, the right to purchase and hold this property is directly sanctioned and authorized for 20 years by the people who framed the Constitution. And by the second, they pledged themselves to maintain and uphold the right of the master in the manner specified, as long as the government they then formed should endure. And these two provisions show conclusively that neither the description of persons therein referred to, nor their descendants, were embraced in any of the other provisions of the Constitution, for certainly these two clauses were not intended to confer on them or their posterity the blessings of liberty, or any of the personal rights so carefully provided for the citizen. No one of that race had ever migrated to the United States voluntarily. All of them had been brought here as articles of merchandise. The number that had been emancipated at that time were but few in comparison with those held in slavery, and they were identified in the public mind with the race to which they belonged, and regarded as a part of the slave population rather than the free. It is obvious that they were not even in the minds of the framers of the Constitution when they were conferring special rights and privileges upon the citizens of a state in every other part of the Union. Indeed, when we look to the condition of this race in the several states at the time, it is impossible to believe that these rights and privileges were intended to be extended to them. It is very true that in that portion of the Union where the labor of the Negro race was found to be unsuited to the climate and unprofitable to the master, but few slaves were held at the time of the Declaration of Independence. And when the Constitution was adopted, it had entirely worn out in one of them, and measures had been taken for its gradual abolition in several others. But this change had not been produced by any change of opinion in relation to this race, but because it was discovered from experience that slave labor was unsuited to the climate and productions of these states. For some of the states, where it had ceased or nearly ceased to exist, were actively engaged in the slave trade, procuring cargoes on the coast of Africa and transporting them for sale to those parts of the Union where their labor was found to be profitable and suited to the climate and productions. And this traffic was openly carried on, and fortunes accumulated by it without reproach from the people of the states where they resided. And it can hardly be supposed that in the states where it was then countenanced in its worst form, that is, in the seizure and transportation, the people could have regarded those who were emancipated as entitled to equal rights with themselves. And we may here again refer, in support of this proposition, to the plain and unequivocal language of the laws of the several states, some passed after the Declaration of Independence and before the Constitution was adopted, and some since the government went into operation. We need not refer on this point particularly to the laws of the present slaveholding states. Their statute books are full of provisions in relation to this case, in the same spirit with the Maryland law which we have before quoted. They have continued to treat them as an inferior class and to subject them to strict police regulations, drawing a broad line of distinction between the citizen and the slave races, and legislating in relation to them upon the same principle which prevailed at the time of the Declaration of Independence. As relates to these states, it is too plain for argument that they have never been regarded as a part of the people or citizens of the state, nor supposed to possess any political rights which the dominant race might not withhold or grant at their pleasure. And as long ago as 1822, the Court of Appeals of Kentucky decided that free Negroes and mulattoes were not citizens within the meaning of the Constitution of the United States, and the correctness of this decision is recognized and the same doctrine affirmed in 1 Meigs's Tennessee Reports, 331. And if we turn to the legislation of the states where slavery had worn out, or measures taken for its speedy abolition, we shall find the same opinions and principles equally fixed and equally acted upon. Thus, Massachusetts in 1786 passed a law similar to the colonial one of which we have spoken. The law of 1786, like the law of 1705, forbids the marriage of any white person with any Negro, Indian, or mulatto, and inflicts a penalty of £50 upon anyone who shall join them in marriage, and declares all such marriage absolutely null and void, and degrades thus the unhappy issue of the marriage by fixing upon it the stain of bastardy. And this mark of degradation was renewed and again impressed upon the race in the careful and deliberate preparation of their revised code published in 1836. This code forbids any person from joining in marriage any white person with any Indian, Negro, or mulatto, and subjects the party who shall offend in this respect to imprisonment not exceeding 6 months in the common jail or to hard labor, and to a fine of not less than $50, no more than $200, and, like the law of 1786, it declares the marriage to be absolutely null and void. It will be seen that the punishment is increased by the code upon the person who shall marry them by adding imprisonment to a pecuniary penalty. So, too, in Connecticut. We refer more particularly to the legislation of this state because it was not only among the first to put an end to slavery within its own territory, but was the first to fix a mark of reprobation upon the African slave trade. The law last mentioned was passed in October 1788, about 9 months after the state had ratified and adopted the present Constitution of the United States. And by that law it prohibited its own citizens, under severe penalties, from engaging in the trade, and declared all policies of insurance on the vessel or cargo made in the state to be null and void. But, up to the time of the adoption of the Constitution, there is nothing in the legislation of the state indicating any change of opinion as to the relative rights and position of the white and black races in this country, or indicating that it meant to place the latter, when free, upon a level with its citizens, and certainly nothing which would have led the slaveholding states to suppose that Connecticut designed to claim for them, under the new Constitution, the equal rights and privileges and rank of citizens in every other state. The first step taken by Connecticut upon this subject was as early as 1774, when it passed an act forbidding the further importation of slaves into the state. But the section containing the prohibition is introduced by the following preamble. And whereas the increase of slaves in this state is injurious to the poor and inconvenient, this recital would appear to have been carefully introduced in order to prevent any misunderstanding of the motive which induced the legislature to pass the law, and places it distinctly upon the interest and convenience of the white population, excluding the inference that it might have been intended in any degree for the benefit of the other. And in the Act of 1784, by which the issue of slaves born after the time therein mentioned were to be free at a certain age, the section is again introduced by a preamble, assigning a similar motive for the act. It is in these words: whereas sound policy requires that the abolition of slavery should be effected as soon as may be consistent with the rights of individuals and the public safety and welfare, showing that the right of property in the master was to be protected, and that the measure was one of policy, and to prevent the injury and inconvenience to the whites of a slave population in the state. And still further pursuing its legislation, we find that in the same statute passed in 1774, which prohibited the further importation of slaves into the state, there is also a provision by which any Negro, Indian, or mulatto servant who was found wandering out of the town or place to which he belonged, without a written pass such as is therein described, was made liable to be seized by anyone and taken before the next authority to be examined and delivered up to his master, who was required to pay the charge which had accrued thereby. And a subsequent section of the same law provides that if any free Negro shall travel without such pass, and shall be stopped, seized, or taken up, he shall pay all charges arising thereby. And this law was in full operation when the Constitution of the United States was adopted, and was not repealed till 1797, so that up to that time free Negroes and mulattoes were associated with servants and slaves in the police regulations established by the laws of the state. And again, in 1833, Connecticut passed another law which made it penal to set up or establish any school in that state for the instruction of persons of the African race, not inhabitants of the state, or to instruct or teach in any such school or institution, or board or harbor for that purpose, any such person without the previous consent in writing of the civil authority of the town in which such school or institution might be. And it appears by the case of Crandall versus the state that upon an information filed against Prudence Crandall for a violation of this law, one of the points raised in the defense was that the law was a violation of the Constitution of the United States, and that the persons instructed, although of the African race, were citizens of other states, and therefore entitled to the rights and privileges of citizens in the state of Connecticut. But Chief Justice Daggett, before whom the case was tried, held that persons of that description were not citizens of a state, within the meaning of the word citizen in the Constitution of the United States, and were not therefore entitled to the privileges and immunities of citizens in other states. The case was carried up to the Supreme Court of Errors of the state, and the question fully argued there, but the case went off upon another point, and no opinion was expressed on this question. We have made this particular examination into the legislative and judicial action of Connecticut because, from the early hostility it displayed to the slave trade on the coast of Africa, we may expect to find the laws of that state as lenient and favorable to the subject race as those of any other state in the Union. And if we find that at the time the Constitution was adopted, they were not even there raised to the rank of citizens, but were still held and treated as property, and the laws relating to them passed with reference altogether to the interest and convenience of the white race, we shall hardly find them elevated to a higher rank anywhere else. A brief notice of the laws of two other states, and we shall pass on to other considerations. By the laws of New Hampshire, collected and finally passed in 1815, no one was permitted to be enrolled in the militia of the state but free white citizens, and the same provision is found in a subsequent collection of the laws made in 1855. Nothing could more strongly mark the entire repudiation of the African race. The alien is excluded because, being born in a foreign country, he cannot be a member of the community until he is naturalized. But why are the African race, born in the state, not permitted to share in one of the highest duties of the citizen? The answer is obvious. He is not, by the institutions and laws of the state, numbered among its people. He forms no part of the sovereignty of the state, and is not therefore called on to uphold and defend it. Again, in 1822, Rhode Island, in its revised code, passed a law forbidding persons who were authorized to join persons in marriage from joining in marriage any white person with any Negro, Indian, or mulatto, under the penalty of $200, and declaring all such marriages absolutely null and void. And the same law was again reenacted in its revised code of 1844, so that, down to the last mentioned period, the strongest mark of inferiority and degradation was fastened upon the African race in that state. End of Part 1. Part 2 of Dred Scott vs. Sandford. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Dred Scott vs. Sandford, an opinion of the United States Supreme Court. Part 2. It would be impossible to enumerate and compress in the space usually allotted to an opinion of a court the various laws marking the condition of this race, which were passed from time to time after the Revolution and before and since the adoption of the Constitution of the United States. In addition to those already referred to, it is sufficient to say that Chancellor Kent, whose accuracy and research no one will question, states in the 6th edition of his Commentaries that in no part of the country except Maine did the African race, in point of fact, participate equally with the whites in the exercise of civil and political rights. The legislation of the states therefore shows, in a manner not to be mistaken, the inferior and subject condition of that race at the time the Constitution was adopted, and long afterwards, throughout the 13 states by which that instrument was framed, and it is hardly consistent with the respect due to these states to suppose that they regarded at that time, as fellow citizens and members of the sovereignty, a class of beings whom they had thus stigmatized, whom, as we are bound, out of respect to the state sovereignties, to assume they had deemed it just and necessary thus to stigmatize, and upon whom they had impressed such deep and enduring marks of inferiority and degradation, or that when they met in convention to form the Constitution they looked upon them as a portion of their constituents, or designed to include them in the provisions so carefully inserted for the security and protection of the liberties and rights of their citizens. It cannot be supposed that they intended to secure to them rights and privileges and rank in the new political body throughout the Union, which every one of them denied within the limits of its own dominion. More especially, it cannot be believed that the large slaveholding states regarded them as included in the word citizens, or would have consented to a constitution which might compel them to receive them in that character from another state. For if they were so received and entitled to the privileges and immunities of citizens, it would exempt them from the operation of the special laws and from the police regulations which they considered to be necessary for their own safety. It would give to persons of the Negro race who were recognized as citizens in any one state of the Union the right to enter every other state whenever they pleased, singly or in companies, without pass or passport, and without obstruction, to sojourn there as long as they pleased, to go where they pleased at every hour of the day or night without molestation, unless they committed some violation of law for which a white man would be punished. And it would give them the full liberty of speech in public and in private upon all subjects upon which its own citizens might speak, to hold public meetings upon political affairs, and to keep and carry arms wherever they went. And all of this would be done in the face of the subject race of the same color, both free and slaves, and inevitably producing discontent and insubordination among them, and endangering the peace and safety of the state. It is impossible, it would seem, to believe that the great men of the slaveholding states, who took so large a share in framing the Constitution of the United States and exercised so much influence in procuring its adoption, could have been so forgetful, or regardless of their own safety and the safety of those who trusted and confided in them. Besides, this want of foresight and care would have been utterly inconsistent with the caution displayed in providing for the admission of new members into this political family. For, when they gave to the citizens of each state the privileges and immunities of citizens in the several states, they at the same time took from the several states the power of naturalization and confined that power exclusively to the federal government. No state was willing to permit another state to determine who should or should not be admitted as one of its citizens and entitled to demand equal rights and privileges with their own people within their own territories. The right of naturalization was therefore, with one accord, surrendered by the states and confided to the federal government, and this power granted to Congress to establish a uniform rule of naturalization is, by the well understood meaning of the word, confined to persons born in a foreign country, under a foreign government. It is not a power to raise to the rank of a citizen any one born in the United States, who from birth or parentage by the laws of the country belongs to an inferior and subordinate class. And when we find the states guarding themselves from the indiscreet or improper admission by other states of emigrants from other countries, by giving the power exclusively to Congress, we cannot fail to see that they could never have left with the states a much more important power, that is, the power of transforming into citizens a numerous class of persons, who in that character would be much more dangerous to the peace and safety of a large portion of the Union than the few foreigners one of the states might improperly naturalize. The Constitution, upon its adoption, obviously took from the states all power by any subsequent legislation to introduce as a citizen into the political family of the United States anyone, no matter where he was born or what might be his character or condition, and it gave to Congress the power to confer this character upon those only who were born outside of the dominions of the United States. And no law of a state, therefore, passed since the Constitution was adopted, can give any right of citizenship outside of its own territory. A clause similar to the one in the Constitution, in relation to the rights and immunities of citizens of one state in the other states, was contained in the Articles of Confederation. But there is a difference of language which is worthy of note. The provision in the Articles of Confederation was that the free inhabitants of each of the states, paupers, vagabonds, and fugitives from justice, excepted, should be entitled to all the privileges and immunities of free citizens in the several states. It will be observed that under this confederation each state had the right to decide for itself, and in its own tribunals, whom it would acknowledge as a free inhabitant of another state. The term free inhabitant, in the generality of its terms, would certainly include one of the African race who had been manumitted. But no example, we think, can be found of his admission to all the privileges of citizenship in any state of the Union after these articles were formed, and while they continued in force. And notwithstanding the generality of the words free inhabitants, it is very clear that, according to their accepted meaning in that day, they did not include the African race, whether free or not. For the 5th section of the 9th article provides that Congress should have the power to agree upon the number of land forces to be raised, and to make requisitions from each state for its quota in proportion to the number of white inhabitants in such state, which requisition should be binding. Words could hardly have been used which more strongly mark the line of distinction between the citizen and the subject, the free and the subjugated races. The latter were not even counted when the inhabitants of a state were to be embodied in proportion to its numbers for the general defense. And it cannot for a moment be supposed that a class of persons thus separated and rejected from those who formed the sovereignty of the states were yet intended to be included under the words free inhabitants in the preceding article, to whom privileges and immunities were so carefully secured in every state. But although this clause of the Articles of Confederation is the same in principle with that inserted in the Constitution, yet the comprehensive word inhabitant, which might be construed to include an emancipated slave, is omitted, and the privilege is confined to citizens of the state. And this alteration in words would hardly have been made unless a different meaning was intended to be conveyed or a possible doubt removed. The just and fair inference is that as this privilege was about to be placed under the protection of the general government and the words expounded by its tribunals, and all power in relation to it taken from the state and its courts, it was deemed prudent to describe with precision and caution the persons to whom this high privilege was given, and the word citizen was on that account substituted for the words free inhabitant. The word citizen excluded, and no doubt intended to exclude, foreigners who had not become citizens of some one of the states when the Constitution was adopted, and also every description of persons who were not fully recognized as citizens in the several states. This, upon any fair construction of the instruments to which we have referred, was evidently the object and purpose of this change of words. To all this mass of proof we have still to add that Congress has repeatedly legislated upon the same construction of the Constitution that we have given. 3 laws, 2 of which were passed almost immediately after the government went into operation, will be abundantly sufficient to show this. The 2 first are particularly worthy of notice because many of the men who assisted in framing the Constitution and took an active part in procuring its adoption were then in the halls of legislation, and certainly understood what they meant when they used the words people of the United States and citizen in that well-considered instrument. The first of these acts is the Naturalization Law, which was passed at the second session of the First Congress, March 26, 1790, and confines the right of becoming citizens to aliens being free white persons. Now, the Constitution does not limit the power of Congress in this respect to white persons, and they may, if they think proper, authorize the naturalization of anyone, of any color, who was born under allegiance to another government. But the language of the law above quoted shows that citizenship at that time was perfectly understood to be confined to the white race, and that they alone constituted the sovereignty in the government. Congress might, as we before said, have authorized the naturalization of Indians because they were aliens and foreigners. But in their then untutored and savage state, no one would have thought of admitting them as citizens in a civilized community. And, moreover, the atrocities they had but recently committed when they were the allies of Great Britain in the Revolutionary War were yet fresh in the recollection of the people of the United States, and they were even then guarding themselves against the threatened renewal of Indian hostilities. No one supposed then that any Indian would ask for, or was capable of enjoying, the privileges of an American citizen, and the word white was not used with any particular reference to them. Neither was it used with any reference to the African race imported into or born in this country, because Congress had no power to naturalize them, and therefore there was no necessity for using particular words to exclude them. It would seem to have been used merely because it followed out the line of division which the Constitution has drawn between the citizen race, who formed and held the government, and the African race, which they held in subjection and slavery, and governed at their own pleasure. Another of the early laws of which we have spoken is the first militia law, which was passed in 1792 at the first session of the Second Congress. The language of this law is equally plain and significant with the one just mentioned. It directs that every free, able-bodied white male citizen shall be enrolled in the militia. The word white is evidently used to exclude the African race, and the word citizen to exclude unnaturalized foreigners, the latter forming no part of the sovereignty, owing it no allegiance, and therefore under no obligation to defend it. The African race, however, born in the country, did owe allegiance to the government, whether they were slave or free, but it is repudiated and rejected from the duties and obligations of citizenship in marked language. The third act to which we have alluded is even still more decisive. It was passed as late as 1813, and it provides that from and after the termination of the war in which the United States are now engaged with Great Britain, it shall not be lawful to employ, on board of any public or private vessels of the United States, any person or persons except citizens of the United States or persons of color, natives of the United States. Here the line of distinction is drawn in express words. Persons of color, in the judgment of Congress, were not included in the word citizens, and they are described as another and different class of persons, and authorized to be employed if born in the United States. And even as late as 1820, in the charter to the city of Washington, the corporation is authorized to restrain and prohibit the nightly and other disorderly meetings of slaves, free Negroes, and mulattoes, thus associating them together in its legislation, and after prescribing the punishment that may be inflicted on the slaves, proceeds in the following words: and to punish such free Negroes and mulattoes by penalties not exceeding $20 for any one offense, and in case of the inability of any such free Negro or mulatto to pay any such penalty and cost thereon, to cause him or her to be confined to labor for any time not exceeding 6 calendar months. And in a subsequent part of the same section, the Act authorizes the corporation to prescribe the terms and conditions upon which free Negroes and mulattoes may reside in the city. This law, like the laws of the states, shows that this class of persons were governed by special legislation directed expressly to them, and always connected with provisions for the government of slaves, and not with those for the government of free white citizens. And after such a uniform course of legislation as we have stated, by the colonies, by the states, and by Congress, running through a period of more than a century, it would seem that to call persons thus marked and stigmatized citizens of the United States, fellow citizens, a constituent part of the sovereignty, would be an abuse of terms, and not calculated to exalt the character of an American citizen in the eyes of other nations. The conduct of the executive department of the government has been in perfect harmony upon this subject with this course of legislation. The question was brought officially before the late William Wirt, when he was the Attorney General of the United States in 1821, and he decided that the words citizens of the United States were used in the acts of Congress in the same sense as in the Constitution, and that free persons of color were not citizens within the meaning of the Constitution and laws. And this opinion has been confirmed by that of the late Attorney General, Caleb Cushing, in a recent case, and acted upon by the Secretary of State, who refused to grant passports to them as citizens of the United States. And it is said that a person may be a citizen and entitled to that character, although he does not possess all the rights which may belong to other citizens, as, for example, the right to vote or to hold particular offices, and that yet, when he goes into another state, he is entitled to be recognized there as a citizen, although the state may measure his rights by the rights which it allows to persons of a like character or class resident in the state, and refuse to him the full rights of citizenship. This argument overlooks the language of the provision in the Constitution of which we are speaking. Undoubtedly, a person may be a citizen, that is, a member of the community, who form the sovereignty, although he exercises no share of the political power and is incapacitated from holding particular offices. Women and minors who form a part of the political family cannot vote, and when property qualification is required to vote or hold a particular office, those who have not the necessary qualification cannot vote or hold the office, yet they are citizens. So too, a person may be entitled to vote by the law of the state, who is not a citizen, even of the state itself. And in some of the states of the Union, foreigners not naturalized are allowed to vote. And the state may give the right to free Negroes and mulattoes, but that does not make them citizens of the state, and still less of the United States. And the provision in the Constitution giving privileges and immunities in other states does not apply to them. Neither does it apply to a person who, being the citizen of a state, migrates to another state, for then he becomes subject to the laws of the state in which he lives, and he is no longer a citizen of the state from which he removed. And the state in which he resides may then unquestionably determine his status or condition, and and place him among the class of persons who are not recognized as citizens, but belong to an inferior and subject race, and may deny him the privileges and immunities enjoyed by its citizens. But so far as mere rights of person are concerned, the provision in question is confined to citizens of a state who are temporarily in another state without taking up their residence there. It gives them no political rights in the state as to voting or holding office, or in any other respect, for a citizen of one state has no right to participate in the government of another. But if he ranks as a citizen in the state to which he belongs, within the meaning of the Constitution of the United States, then, whenever he goes into another state, the Constitution clothes him as the rights of person with all the privileges and immunities which belong to citizens of the state. And if persons of the African race are citizens of a state and of the United States, they would be entitled to all of these privileges and immunities in every state, and the state could not restrict them, for they would hold these privileges and immunities under the paramount authority of the federal government, and its courts would be bound to maintain and enforce them, the Constitution and laws of the state to the contrary notwithstanding. And if the states could limit or restrict them, or place the party in an inferior grade, this clause of the Constitution would be unmeaning, and could have no operation, and would give no rights to the citizen when in another state. He would have none but what the state itself chose to allow him. This is evidently not the construction or meaning of the clause in question. It guarantees rights to the citizen, and the state cannot withhold them, and these rights are of a character and would lead to consequences which make it absolutely certain that the African race were not included under the name of citizens of a state, and were not in the contemplation of the framers of the Constitution when these privileges and immunities were provided for the protection of the citizen in other states. The case of Legrand versus Darnall has been referred to for the purpose of showing that this court has decided that the descendant of a slave may sue as a citizen in a court of the United States, but the case itself shows that the question did not arise and could not have arisen in the case. It appears from the report that Darnall was born in Maryland and was the son of a white man by one of his slaves, and his father executed certain instruments to manumit him and devised to him some landed property in the state. This property Darnall afterwards sold to Legrand, the appellant, who gave his notes for the purchase money. But becoming afterwards apprehensive that the appellee had not been emancipated according to the laws of Maryland, he refused to pay the notes until he could be better satisfied as to Darnall's right to convey. Darnall, in the meantime, had taken up his residence in Pennsylvania and brought suit on the notes, and recovered judgment in the Circuit Court for the District of Maryland. The whole proceeding, as appears by the report, was an amicable one, Legrand being perfectly willing to pay the money if he could obtain a title, and Darnall not wishing him to pay unless he could make him a good one. In point of fact, the whole proceeding was under the direction of the counsel who argued the case for the appellee, who was the mutual friend of the parties, and confided in by both of them, and whose only object was to have the rights of both parties established by judicial decision in the most speedy and least expensive manner. Legrand, therefore, raised no objection to the jurisdiction of the court in the suit at law, because he was himself anxious to obtain the judgment of the court upon his title. Consequently, there was nothing in the record before the court to show that Darnall was of African descent, and the usual judgment and award of execution was entered, and Legrand thereupon filed his bill on the equity side of the Circuit Court, stating that Darnall was born a slave and had not been legally emancipated, and could not therefore take the land devised to him, nor make Legrand a good title, and praying an injunction to restrain Darnall from proceeding to execution on the judgment which was granted. Darnall answered, averring in his answer that he was a free man and capable of conveying a good title. Testimony was taken on this point, and at the hearing the Circuit Court was of opinion that Darnall was a free man and his title good, and dissolved the injunction and dismissed the bill, and that decree was affirmed here upon the appeal of Legrand. Now, it is difficult to imagine how any question about the citizenship of Darnall or his right to sue in that character can be supposed to have arisen or been decided in that case. The fact that he was of African descent was first brought before the court upon the bill in equity. The suit at law had then passed into judgment, an award of execution, and the circuit court as a court of law had no longer any authority over it. It was a valid and legal judgment, which the court that rendered it had not the power to reverse or set aside, and unless it had jurisdiction as a court of equity to restrain him from using its process as a court of law, Darnall, if he thought proper, would have been at liberty to proceed on his judgment and compel the payment of the money, although the allegations in the bill were true and he was incapable of making a title. No other court could have enjoined him, for certainly no state equity court could interfere in that way with the judgment of a circuit court of the United States. But the circuit court, as a court of equity, certainly had equity jurisdiction over its own judgment as a court of law, without regard to the character of the parties, and had not only the right, but it was its duty, no matter who were the parties in the judgment, to prevent them from proceeding to enforce it by execution, if the court was satisfied that the money was not justly and equitably due. The ability of Darnall to convey did not depend upon his citizenship, but upon his title to freedom. And if he was free, he could hold and convey property by the laws of Maryland, although he was not a citizen. But if he was by law still a slave, he could not. It was therefore the duty of the court sitting as a court of equity in the latter case to prevent him from using its process as a court of common law to compel the payment of the purchase money when it was evident that the purchaser might lose the land. But if he was free and could make a title, it was equally the duty of the court not to suffer Legrand to keep the land and refuse the payment of the money upon the ground that Darnall was incapable of suing or being sued as a citizen in a court of the United States. The character or citizenship of the parties had no connection with the question of jurisdiction, and the matter in dispute had no relation to the citizenship of Darnall, nor is such a question alluded to in the opinion of the court. Besides, we are by no means prepared to say that there are not many cases, civil as well as criminal, in which a circuit court of the United States may exercise jurisdiction, although one of the African race is a party. That broad question is not before the court. The question with which we are now dealing is whether a person of the African race can be a citizen of the United States and become thereby entitled to a special privilege by virtue of his title to that character, and which, under the Constitution, no one but a citizen can claim. It is manifest that the case of Legrand and Darnall has no bearing on that question and can have no application to the case now before the court. This case, however, strikingly illustrates the consequences that would follow the construction of the Constitution, which would give the power contended for to a state. It would in effect give it also to an individual, for if the father of young Darnall had manumitted him in his lifetime and sent him to reside in a state which recognized him as a citizen, he might have visited and sojourned in Maryland when he pleased, and as long as he pleased, as a citizen of the United States, and the state officers and tribunals would be compelled, by the paramount authority of the Constitution, to receive him and treat him as one of its citizens, exempt from the laws and police of the state in relation to a person of that description, and allow him to enjoy all the rights and privileges of citizenship without respect to the laws of Maryland, although such laws were deemed by it absolutely essential to its own safety. The only two provisions which point to them and include them treat them as property and make it the duty of the government to protect it. No other power in relation to this race is to be found in the Constitution, and as it is a government of special delegated powers, no authority beyond these two provisions can be constitutionally exercised. The government of the United States had no right to interfere for any other purpose but that of protecting the rights of the owner, leaving it altogether with the several states to deal with this race, whether emancipated or not, as each state may think justice, humanity, and the interests and safety of society require. The states evidently intended to reserve this power exclusively to themselves. No one, we presume, supposes that any change in public opinion or feeling in relation to this unfortunate race in the civilized nations of Europe or in this country should induce the court to give to the words of the Constitution a more liberal construction in their favor than they were intended to bear when the instrument was framed and adopted. Such an argument would be altogether inadmissible in any tribunal called on to interpret it. If any of its provisions are deemed unjust, there is a mode prescribed in the instrument itself by which it may be amended, but while it remains unaltered, it must be construed now as it was understood at the time of its adoption. It is not only the same in words, but the same in meaning, and delegates the same powers to the government, and reserves and secures the same rights and privileges to the citizen. And as long as it continues to exist in its present form, it speaks not only in the same words, but with the same meaning and intent with which it spoke when it came from the hands of its framers, and was voted on and adopted by the people of the United States. Any other rule of construction would abrogate the judicial character of this court and make it the mere reflex of the popular opinion or passion of the day. This court was not created by the Constitution for such purposes. Higher and graver trusts have been confided to it, and it must not falter in the path of duty. What the construction was at that time, we think can hardly admit of doubt. We have the language of the Declaration of Independence and of the Articles of Confederation, in addition to the plain words of the Constitution itself. We have the legislation of the different states, before, about the time, and since the Constitution was adopted. We have the legislation of Congress, from the time of its adoption to a recent period, and we have the constant and uniform action of the executive department, all concurring together and leading to the same result. And if anything in relation to the construction of the Constitution can be regarded as settled, it is that which we now give to the word citizen and the word people. And upon a full and careful consideration of the subject, the court is of the opinion that, upon the facts stated in the plea in abatement, Dred Scott was not a citizen of Missouri within the meaning of the Constitution of the United States, and not entitled as such to sue in its courts, and consequently that the circuit court had no jurisdiction of the case, and that the judgment on the plea in abatement is erroneous. We are aware that doubts are entertained by some of the members of the court whether the plea in abatement is legally before the court upon this writ of error, but if that plea is regarded as waived, or out of the case upon any other ground, yet the question as to the jurisdiction of the circuit court is presented on the face of the bill of exception itself, taken by the plaintiff at the trial, for he admits that he and his wife were born slaves, but endeavors to make out his title to freedom and citizenship by showing that they were taken by their owner to certain places, hereinafter mentioned, where slavery could not by law exist, and that they thereby became free, and upon their return to Missouri became citizens of that state. Now, if the removal of which he speaks did not give them their freedom, then by his own admission he is still a slave, and whatever opinions may be entertained in favor of the citizenship of a free person of the African race, no one supposes that a slave is a citizen of the state or of the United States. If, therefore, the acts done by his owner did not make them free persons, he is still a slave and certainly incapable of suing in the character of a citizen. The principle of law is too settled to be disputed, that a court can give no judgment for either party where it has no jurisdiction. And if, upon the showing of Scott himself, it appears that he was still a slave, the case ought to have been dismissed, and the judgment against him and in favor of the defendant for costs is, like that on the plea in abatement, erroneous, and the suit ought to have been dismissed by the circuit court for want of jurisdiction in that court. But before we proceed to examine this part of the case, it may be proper to notice an objection taken to the judicial authority of this court to decide it. And it has been said that as this court has decided against the jurisdiction of the circuit court on the plea in abatement, it has no right to examine any question presented by the exception, and that anything it may say upon that part of the case will be extrajudicial and mere obiter dicta. This is a manifest mistake. There can be no doubt as to the jurisdiction of this court to revise the judgment of a circuit court, and to reverse it for any error apparent on the record, whether it be the error of giving judgment in a case over which it had no jurisdiction, or any other material error, and this too whether there is a plea in abatement or not. The objection appears to have arisen from confounding writs of error to a state court with writs of error to a circuit court of the United States. Undoubtedly, upon a writ of error to a state court, unless the record shows a case that gives jurisdiction, the case must be dismissed for want of jurisdiction in this court. And if it is dismissed on that ground, we have no right to examine and decide upon any question presented by the bill of exceptions, or any other part of the record. But writs of error to a state court and to a circuit court of the United States are regulated by different laws and stand upon entirely different principles. And in a writ of error to a circuit court of the United States, the whole record is before this court for examination and decision. And if the sum in controversy is large enough to give jurisdiction, it is not only the right, but it is the judicial duty of the court to examine the whole case as presented by the record. And if it appears upon its face that any material error or errors have been committed by the court below, it is the duty of this court to reverse the judgment and remand the case. And certainly an error in passing a judgment upon the merits in favor of either party, in a case which it was not authorized to try, and over which it had no jurisdiction, is as grave an error as a court can commit. The plea in abatement is not a plea to the jurisdiction of this court, but to the jurisdiction of the circuit court, and it appears by the record before us that the circuit court committed an error in deciding that it had jurisdiction upon the facts in the case, admitted by the pleadings. It is the duty of the appellate tribunal to correct this error, but that could not be done by dismissing the case for want of jurisdiction here, for that would leave the erroneous judgment in full force, and the injured party without remedy. And the appellate court therefore exercises the power for which alone appellate courts are constituted, by reversing the judgment of the court below for this error. It exercises its proper and appropriate jurisdiction over the judgment and proceedings of the circuit court, as they appear upon the record brought up by the writ of error. The correction of one error in the court below does not deprive the appellate court of the power of examining further into the record and correcting any other material errors which may have been committed by the inferior court. There is certainly no rule of law, nor any practice, nor any decision of a court, which even questions this power in the appellate tribunal. On the contrary, it is the daily practice of this court and of all appellate courts where they reverse the judgment of an inferior court for error, to correct by its opinions whatever errors may appear on the record material to the case. And they have always held it to be their duty to do so where the silence of the court might lead to misconstruction or future controversy, and the point has been relied on by either side and argued before the court. In the case before us, we have already decided that the circuit court erred in deciding that it had jurisdiction upon the facts admitted by the pleadings. And it appears that, in the further progress of the case, it acted upon the erroneous principle it had decided on the pleadings, and gave judgment for the defendant, where, upon the facts admitted in the exception, it had no jurisdiction. We are at a loss to understand upon what principle of law, applicable to appellate jurisdiction, it can be supposed that this court has not judicial authority to correct the last mentioned error, because they had before corrected the former, or by what process of reasoning it can be made out that the error of an inferior court in actually pronouncing judgment for one of the parties, in a case in which it had no jurisdiction, cannot be looked into or corrected by this court, because we have decided a similar question presented in the pleadings. The last point is distinctly presented by the facts contained in the plaintiff's own bill of exceptions, which he himself brings here by this writ of error. It was the point which chiefly occupied the attention of the counsel on both sides in the argument, and the judgment which this court must render upon both errors is precisely the same. It must, in each of them, exercise jurisdiction over the judgment and reverse it for the errors committed by the court below, and issue a mandate to the circuit court to conform its judgment to the opinion pronounced by this court by dismissing the case for want of jurisdiction in the circuit court. This is the constant and invariable practice of this court, where it reverses a judgment for want of jurisdiction in the circuit court. It can scarcely be necessary to pursue such a question further. The want of jurisdiction in the court below may appear on the record without any plea in abatement. This is familiarly the case where a court of chancery has exercised jurisdiction in a case where the plaintiff had a plain and adequate remedy at law, and it so appears by the transcript when brought here by appeal. So also where it appears that a court of admiralty has exercised jurisdiction in a case belonging exclusively to a court of common law. In these cases there is no plea in abatement, and for the same reason and upon the same principles, where the defect of jurisdiction is patent on the record, this court is bound to reverse the judgment, although the defendant has not pleaded in abatement to the jurisdiction of the inferior court. The cases of Jackson v. Ashton and of Capron v. Van Noorden to which we have referred in a previous part of this opinion, are directly in point. In the last mentioned case, Capron brought an action against Van Noorden in a circuit court of the United States without showing, by the usual averments of citizenship, that the court had jurisdiction. There was no plea in abatement put in, and the parties went to trial upon the merits. The court gave judgment in favor of the defendant with costs. The plaintiff thereupon brought his writ of error, and this court reversed the judgment given in favor of the defendant and remanded the case with directions to dismiss it because it did not appear by the transcript that the circuit court had jurisdiction. The case before us still more strongly imposes upon this court the duty of examining whether the court below has not committed an error in taking jurisdiction and giving a judgment for costs in favor of the defendant. For in Capron versus Van Noorden, the judgment was reversed because it did not appear that the parties were citizens of different states. They might or might not be, but in this case it does appear that the plaintiff was born a slave, and if the facts upon which he relies have not made him free, then it appears affirmatively on the record that he is not a citizen, and consequently his suit against Sandford was not a suit between citizens of different states, and the court had no authority to pass any judgment between the parties. The suit ought, in this view of it, to have been dismissed by the circuit court, and its judgment in favor of Sandford is erroneous and must be reversed. It is true that the result either way, by dismissal or by a judgment for the defendant, makes very little, if any, difference in a pecuniary or personal point of view to either party. But the fact that the result would be very nearly the same to the parties in either form of judgment would not justify this court in sanctioning an error in the judgment which is patent on the record, and which, if sanctioned, might be drawn into precedent and lead to serious mischief and injustice in some future suit. We proceed, therefore, to inquire whether the facts relied on by the plaintiff entitled him to his freedom. The case, as he himself states it, on the record brought here by his writ of error, is this. The plaintiff was a Negro slave belonging to Dr. Emerson, who was a surgeon in the Army of the United States. In the year 1834, he took the plaintiff from the state of Missouri to the military post at Rock Island, in the state of Illinois, and held him there as a slave until the month of April or May, 1836. At the time last mentioned, said Dr. Emerson removed the plaintiff from said military post at Rock Island to the military post at Fort Snelling, situate on the west bank of the Mississippi River in the territory known as Upper Louisiana, acquired by the United States of France, and situate north of the latitude of 36 degrees 30 minutes north and north of the state of Missouri. Said Dr. Emerson held the plaintiff in slavery at said Fort Snelling from said last mentioned date until the year 1838. In the year 1835, Harriet, who was named in the second count of the plaintiff's declaration, was the Negro slave of Major Taliaferro, who belonged to the Army of the United States. In that year, 1835, said Major Taliaferro took said Harriet to said Fort Snelling, a military post, situated as hereinbefore stated, and kept her there as a slave until the year 1836, and then sold and delivered her as a slave at said Fort Snelling unto the said Dr. Emerson, hereinbefore named. Said Dr. Emerson held said Harriet in slavery at said Fort Snelling until the year 1838. In the year 1836, the plaintiff and Harriet intermarried at Fort Snelling with the consent of Dr. Emerson, who then claimed to be their master and owner. Eliza and Lizzie, named in the third count of the plaintiff's declaration, are the fruit of that marriage. Eliza is about 14 years old and was born on board the steamboat Gypsy, north of the north line of the state of Missouri, and upon the river Mississippi. Lizzie is about 7 years old and was born in the state of Missouri at the military post called Jefferson Barracks. In the year 1838, said Dr. Emerson removed the plaintiff and said Harriet and their said daughter Eliza from said Fort Snelling to the state of Missouri, where they have ever since resided. Before the commencement of this suit, said Dr. Emerson sold and conveyed the plaintiff and Harriet, Eliza and Lizzie, to the defendant as slaves, and the defendant has ever since claimed to hold them and each of them as slaves. In considering this part of the controversy, two questions arise. Number one, was he, together with his family, free in Missouri by reason of the stay in the territory of the United States hereinbefore mentioned? And number 2, if they were not, is Scott himself free by reason of his removal to Rock Island in the state of Illinois, as stated in the above admissions? We proceed to examine the first question. The act of Congress upon which the plaintiff relies declares that slavery and involuntary servitude, except as a punishment for crime, shall be forever prohibited in all that part of the territory ceded by France under the name of Louisiana, which lies north of the 36 degrees 30 minutes north latitude, and not included within the limits of Missouri. And the difficulty which meets us at the threshold of this part of the inquiry is, whether Congress was authorized to pass this law under any of the powers granted to it by the Constitution. For if the authority is not given by that instrument, it is the duty of this court to declare it void and inoperative, and incapable of conferring freedom upon anyone who is held as a slave under the halve of any one of the states. The counsel for the plaintiff has laid much stress upon the article in the Constitution which confers on Congress the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. But, in the judgment of the court, that provision has no bearing on the present controversy, and the power there given, whatever it may be, is confined and was intended to be confined to the territory which at that time belonged to or was claimed by the United States, and was within their boundaries as settled by the treaty with Great Britain, and can have no influence upon a territory afterwards acquired from a foreign government. It was a special provision for a known and particular territory, and to meet a present emergency and nothing more. A brief summary of the history of the times, as well as the careful and measured terms in which the article is framed, will show the correctness of this proposition. It will be remembered that, from the commencement of the Revolutionary War, serious difficulties existed between the states in relation to the disposition of large and unsettled territories which were included in the chartered limits of some of the states. And some of the other states, and more especially Maryland, which had no unsettled lands, insisted that, as the unoccupied lands, if wrested from Great Britain, would owe their preservation to the common purse and the common sword, the money arising from them ought to be applied in just proportion among the several states to pay the expenses of the war, and ought not to be appropriated to the use of the state in whose chartered limits they might happen to lie, to the exclusion of the other states, by whose combined efforts and common expense the territory was defended and preserved against the claim of the British government. These difficulties caused much uneasiness during the war, while the issue was in some degree doubtful, and the future boundaries of the United States yet to be defined by treaty, if we achieved our independence. The majority of the Congress of the Confederation obviously concurred in opinion with the state of Maryland, and desired to obtain from the states which claimed it a cession of this territory in order that Congress might raise money on this security to carry on the war. This appears by the resolution passed on the 6th of September, 1780, strongly urging the states to cede these lands to the United States, both for the sake of peace and union among themselves and to maintain the public credit. And this was followed by the resolution of October 10th, 1780, by which Congress pledged itself that if the lands were ceded, as recommended by the resolution above mentioned, they should be disposed of for the common benefit of the United States, and be settled and formed into distinct republican states, which should become members of the Federal Union and have the same rights of sovereignty and freedom and independence as other states. But these difficulties became much more serious after peace took place and the boundaries of the United States were established. Every state at that time felt severely pressure of its war debt, but in Virginia and some other states, there were large territories of unsettled lands, the sale of which would enable them to discharge their obligations without much inconvenience, while other states, which had no such resource, saw before them many years of heavy and burdensome taxation, and the latter insisted, for the reasons before stated, that these unsettled lands should be treated as the common property of the states, and the proceeds applied to their common benefit. The letters from the statesmen of that day will show how much this controversy occupied their thoughts, and the dangers that were apprehended from it. It was the disturbing element of the time, and fears were entertained that it might dissolve the confederation by which the states were then united. These fears and dangers were, however, at once removed when the state of Virginia in 1784 voluntarily ceded to the United States the immense tract of land lying northwest of the river Ohio, and which was within the acknowledged limits of the state. The only object of the state in making this cession was to put an end to the threatening and exciting controversy, and to enable the Congress of that time to dispose of the lands and appropriate the proceeds as a common fund for the common benefit of the states. It was not ceded because it was inconvenient to the state to hold and govern it, nor from any expectation that it could be better or more conveniently governed by the United States. The example of Virginia was soon afterwards followed by other states, and at the time of the adoption of the Constitution, all of the states similarly situated had ceded their unappropriated lands, except North Carolina and Georgia. The main object for which these cessions were desired and made was on account of their money value, and to put an end to a dangerous controversy as to who was justly entitled to the proceeds when the lands should be sold. It is necessary to bring this part of the history of these cessions thus distinctly into view, because it will enable us the better to comprehend the phraseology of the article in the Constitution, so often referred to in the argument. Undoubtedly, the powers of sovereignty in the eminent domain were ceded with the land. This was essential in order to make it effectual and to accomplish its objects. But it must be remembered that at that time there was no government of the United States in existence with enumerated and limited powers. What was then called the United States were 13 separate, sovereign, independent states which had entered into a league or confederation for their mutual protection and advantage, and the Congress of the United States was composed of the representatives of these separate sovereignties, meeting together as equals to discuss and decide on certain measures which the states, by the Articles of Confederation, had agreed to submit to their decision. But this confederation had none of the attributes of sovereignty in legislative, executive, or judicial power. It was little more than a Congress of ambassadors, authorized to represent separate nations in matters in which they had a common concern. End of Part 2. Part 3 of Dred Scott versus Sandford. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Dred Scott versus Sandford. An opinion of the United States Supreme Court. Part 3. It was this Congress that accepted the cession from Virginia. They had no power to accept it under the Articles of Confederation, but they had an undoubted right, as independent sovereignties, to accept any cession of territory for their common benefit, which all of them assented to. And it is equally clear that as their common property, and having no superior to control them, they had the right to exercise absolute dominion over it, subject only to the restrictions which Virginia had imposed in her act of cession. There was, as we have said, no government of the United States then in existence, with special enumerated and limited powers. The territory belonged to sovereignties, who, subject to the limitations above mentioned, had a right to establish any form of government they pleased, by compact or treaty among themselves, and to regulate rights of person and rights of property in the territory as they might deem proper. It was by a Congress representing the authority of these several and separate sovereignties, and acting under their authority and command, but not from any authority derived from the Articles of Confederation, that the instrument usually called the Ordinance of 1787 was adopted, regulating in much detail the principles and the laws by which this territory should be governed. And among other provisions, slavery is prohibited in it. We do not question the power of the states, by agreement among themselves, to pass this ordinance, nor its obligatory force in the territory, while the Confederation or League of the States in their separate sovereign character continued to exist. This was the state of things when the Constitution of the United States was formed. The territory ceded by Virginia belonged to the several confederated states as common property, and they had united in establishing in it a system of government and jurisprudence in order to prepare it for admission as states, according to the terms of the cession. They were about to dissolve this federative union and to surrender a portion of their independent sovereignty to a new government, which, for certain purposes, would make the people of the several states one people, and which was to be supreme and controlling within its sphere of action throughout the United States. But this government was to be carefully limited in its powers, and to exercise no authority beyond those expressly granted by the Constitution, or necessarily to be implied from the language of the instrument and the objects it was intended to accomplish. And as this League of States would, upon the adoption of the new government, cease to have any power over the territory, and the ordinance they had agreed upon be incapable of execution and a mere nullity, it was obvious that some provision was necessary to give the new government sufficient power to enable it to carry into effect the objects for which it was seated, and the compacts and agreements which the states had made with each other in the exercise of their powers of sovereignty. It was necessary that the lands should be sold to pay the war debt, that a government and system of jurisprudence should be maintained in it to protect the citizens of the United States who should migrate to the territory in their rights of person and of property. It was also necessary that the new government about to be adopted should be authorized to maintain the claim of the United States to the unappropriated lands in North Carolina and Georgia, which had not then been ceded, but the cession of which was confidently anticipated upon some terms that would be arranged between the general government and these two states. And, moreover, there were many articles of value besides this property in land, such as arms, military stores, munitions, and ships of war, which were the common property of the states, when acting in their independent characters as confederates, which neither the new government nor anyone else would have a right to take possession of or control without authority from them. And it was to place these things under the guardianship and protection of the new government, and to clothe it with the necessary powers, that the clause was inserted in the Constitution which gives Congress the power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States. It was intended for a specific purpose, to provide for the common by the states, to provide for the things we have mentioned. It was to transfer to the new government the property then held in common by the states, and to give to that government power to apply it to the objects for which it had been destined by mutual agreement among the states before their league was dissolved. It applied only to the property which the states held in common at that time, and has no reference whatever to any territory or other property which the new sovereignty might afterwards itself acquire. The language used in the clause, the arrangement and combination of the powers, and the somewhat unusual phraseology it uses when it speaks of the political power to be exercised in the government of the territory, all indicate the design and meaning of the clause to be such as we have mentioned. It does not speak of any territory, nor of territories, but uses language which, according to its legitimate meaning, points to a particular thing. The power is given in relation only to the territory of the United States, that is, to a territory then in existence, and then known or claimed as the territory of the United States. It begins its enumeration of powers by that of disposing, in other words, making sale of the lands, or raising money from them, which, as we have already said, was the main object of the cession, and which is accordingly the first thing provided for in the article. It then gives the power which was necessarily associated with the disposition and sale of the lands, that is, the power of making needful rules and regulations respecting the territory. And whatever construction may now be given to these words, every one, we think, must admit that they are not the words usually employed by statesmen in giving supreme power of legislation. They are certainly very unlike the words used in the power granted to legislate over territory which the new government might afterwards itself obtain by cession from a state, either for its seat of government or for forts, magazines, arsenals, dockyards, and other needful buildings. And the same power of making needful rules respecting the territory is, in precisely the same language, applied to the other property belonging to the United States, associating the power over the territory in this respect with the power over movable or personal property, that is, the ships, arms, and munitions of war, which then belonged in common to the state sovereignties. And it will hardly be said that this power in relation to the last mentioned objects was deemed necessary to be thus specially given to the new government, in order to authorize it to make needful rules and regulations respecting the ships it might itself build, or arms and munitions of war it might itself manufacture or provide for the public service. No one, it is believed, would think a moment of deriving the power of Congress to make needful rules and regulations in relation to property of this kind from this clause of the Constitution, nor can it upon any fair construction be applied to any property but that which the new government was about to receive from the Confederated States. And if this be true as to this property, it must be equally true and limited as to the territory, which is so carefully and precisely coupled with it, and like it referred to as property in the power granted. The concluding words of the clause appear to render this construction irresistible. For after the provisions we have mentioned, it proceeds to say that nothing in the Constitution shall be so construed as to prejudice any claims of the United States or of any particular state. Now, as we have before said, all of the states except North Carolina and Georgia had made the cession before the Constitution was adopted, according to the resolution of Congress of October 10, 1780. The claims of other states that the unappropriated lands in these two states should be applied to the common benefit in like manner was still insisted on but refused by the states, and this member of the clause in question evidently applies to them and can apply to nothing else. It was to exclude the conclusion that either party by adopting the Constitution would surrender what they deemed their rights, and when the latter provision relates so obviously to the unappropriated lands not yet ceded by the states, and the first clause makes provision for those then actually ceded, it is impossible by any just rule of construction to make the first provision general and extend to all territories which the federal government might in any way afterwards acquire, when the latter is plainly and unequivocally confined to a particular territory, which was a part of the same controversy and involved in the same dispute and depended upon the same principles. The union of the two provisions in the same clause shows that they were kindred subjects, and that the whole clause is local and relates only to lands within the limits of the United States, which had been or then were claimed by a state, and that no other territory was in the mind of the framers of the Constitution or intended to be embraced in it. Upon any other construction, it would be impossible to account for the insertion of the last provision in the place where it is found, or to comprehend why, or for what object it was associated with the previous provision. This view of the subject is confirmed by the manner in which the present government of the United States dealt with the subject as soon as it came into existence. It must be borne in mind that the same states that formed the Confederation also formed and adopted the new government, to which so large a portion of their former sovereign powers were surrendered. It must also be borne in mind that all of these same states, which had then ratified the new Constitution, were represented in the Congress which passed the first law for the government of this territory, and many of the members of that legislative body had been deputies from the states under the Confederation, had united in adopting the ordinance of 1787, and assisted in forming the new government under which they were then acting, and whose powers they were then exercising. And it is obvious from the law they passed to carry into effect the principles and provisions of the ordinance that they regarded it as the act of the states done in the exercise of their legitimate powers at the time. The new government took the territory as it found it, and in the condition in which it was transferred, and did not attempt to undo anything that had been done. And among the earliest laws passed under the new government is one reviving the ordinance of 1787, which had become inoperative and a nullity upon the adoption of the Constitution. This law introduced no new form or principles for its government, but recites in the preamble that it is passed in order that this ordinance may continue to have full effect, and proceeds to make only those rules and regulations which were needful to adapt it to the new government, into whose hands the power had fallen. It appears, therefore, that this Congress regarded the purposes to which the land in this territory was to be applied, and the form of government and principles of jurisprudence which were to prevail there, while it remained in the territorial state, as already determined on by the states when they had full power and right to make the decision. and that the new government, having received it in this condition, ought to carry substantially into effect the plans and principles which had been previously adopted by the states, and which no doubt the states anticipated when they surrendered their power to the new government. And if we regard this clause of the Constitution as pointing to this territory, with a territorial government already established in it, which had been ceded to the states for the purposes hereinbefore mentioned, every word in it is perfectly appropriate and easily understood, and the provisions it contains are in perfect harmony with the objects for which it was ceded, and with the condition of its government as a territory at the time. We can, then, easily account for the manner in which the first Congress legislated on the subject, and can also understand why this power over the territory was associated in the same clause with the other property of the United States, and subjected to the like power of making needful rules and regulations. But if the clause is construed in the expanded sense contended for, so as to embrace any territory acquired from a foreign nation by the present government, and to give it in such territory a despotic and unlimited power over persons and property, such as the Confederated States might exercise in their common property, it would be difficult to account for the phraseology used when compared with other grants of power, and also for its association with the other provisions in the same clause. The Constitution has always been remarkable for the felicity of its arrangement of different subjects and the perspicuity and appropriateness of the language it uses. But if this clause is construed to extend to territory acquired by the present government from a foreign nation, outside of the limits of any charter from the British government to a colony, it would be difficult to say why it was deemed necessary to give the government the power to sell any vacant lands belonging to the sovereignty which might be found within it. And if this was necessary, why the grant of this power should precede the power to legislate over it and establish a government there. And still more difficult to say why it was deemed necessary so specially and particularly to grant the power to make needful rules and regulations in relation to any personal or movable property. And still more difficult to say why it was deemed necessary so specially and particularly to grant the power to make needful rules and regulations in relation to any personal or movable property it might acquire there. For the words other property necessarily, by every known rule of interpretation, must mean property of a different description from territory or land, and the difficulty would perhaps be insurmountable in endeavoring to account for the last member of the sentence, which provides that nothing in this Constitution shall be so construed as to prejudice any claims of the United States or any particular state, or to say how any particular state could have claims in or to a territory ceded by a foreign government, or to account for associating this provision with the preceding provisions of the clause, with which it would appear to have no connection. The words needful rules and regulations would seem almost to have been cautiously used for some definite object. They are not the words usually employed by statesmen when they mean to give the powers of sovereignty, or to establish a government, or to authorize its establishment. Thus, in the law to renew and keep alive the Ordinance of 1787 and to reestablish the government, the title of the law is An Act to Provide for the Government of the Territory Northwest of the River Ohio. And in the Constitution, when granting the power to legislate over the territory that may be selected for the seat of government independently of a state, it does not say Congress shall have power to make all needful rules and regulations respecting the territory, but it declares that Congress shall have power to exercise exclusive legislation in all cases whatsoever over such district not exceeding 10 miles square, as may, by cession of particular states and the acceptance of Congress, become the seat of the government of the United States. The words rules and regulations are usually employed in the Constitution in speaking of some particular specified power, which it means to confer on the government, and not, as we have seen, when granting general powers of legislation, as, for example, in the particular power to Congress to make rules for the government and regulation of the land and naval forces, or the particular and specific power to regulate commerce, to establish a uniform rule of naturalization, to coin money and regulate the value thereof. and to construe the words of which we are speaking as a general and unlimited grant of sovereignty over territories which the government might afterwards acquire, is to use them in a sense and for a purpose for which they were not used in any other part of the instrument. But if confined to a particular territory in which a government and laws had already been established, but which would require some alterations to adapt it to the new government, the words are peculiarly applicable and appropriate for that purpose. The necessity of this special provision in relation to property and the rights or property held in common by the Confederated States is illustrated by the first clause of the 6th article. This clause provides that all debts, contracts, and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this government as under the Confederation. This provision, like the one under consideration, was indispensable if the new Constitution was adopted. The new government was not a mere change in a dynasty or in a form of government, leaving the nation or sovereignty the same, and clothed with all the rights and bound by all the obligations of the preceding one. But when the present United States came into existence under the new government, it was a new political body, a new nation, then for the first time taking its place in the family of nations. It took nothing by succession from the Confederation. It had no right, as its successor, to any property or rights of property which it had acquired, and was not liable for any of its obligations. It was evidently viewed in this light by the framers of the Constitution, and as the several states would cease to exist in their former confederated character upon the adoption of the Constitution, and could not in that character again assemble together, special provisions were indispensable to transfer to the new government the property and rights which at that time they held in common, and at the same time to authorize it to lay taxes and appropriate money to pay the common debt which they had contracted. And this power could only be given to it by special provisions in the Constitution. The clause in relation to the territory and other property of the United States provided for the first, and the clause last quoted provided for the other. They have no connection with the general powers and rights of sovereignty delegated to the new government, and can neither enlarge nor diminish them. They were inserted to meet a present emergency and not to regulate its powers as a government. Indeed, a similar provision was deemed necessary in relation to treaties made by the Confederation. And when in the clause next succeeding the one of which we have last spoken, it is declared that treaties shall be the supreme law of the land, care is taken to include, by express words, the treaties made by the Confederated States. The language is, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. Whether, therefore, we take the particular clause in question by itself or in connection with the other provisions of the Constitution, we think it clear that it applies only to the particular territory of which we have spoken, and cannot, by any just rule of interpretation, be extended to territory which the new government might afterwards obtain from a foreign nation. Consequently, the power which Congress may have lawfully exercised in this territory while it remained under a territorial government, and which may have been sanctioned by judicial decision, can furnish no justification and no argument to support a similar exercise of power over territory afterwards acquired by the federal government. We put aside, therefore, any argument drawn from precedents showing the extent of the power which the general government exercised over slavery in this territory, as altogether inapplicable to the case before us. But the case of the American and Ocean Insurance Companies versus Cantor has been quoted as establishing a different construction of this clause of the Constitution. There is, however, not the slightest conflict between the opinion now given and the one referred to, and it is only by taking a single sentence out of the latter and separating it from the context that even an appearance of conflict can be shown. We need not comment on such a mode of expounding an opinion of the court. Indeed, it most commonly misrepresents instead of expounding it, and this is fully exemplified in the case referred to, where if one sentence is taken by itself, the opinion would appear to be in direct conflict with that now given, but the words which immediately follow that sentence show that the court did not mean to decide the point, but merely affirmed the power of Congress to establish a government in the territory, leaving it an open question whether that power was derived from this clause in the Constitution or was to be necessarily inferred from a power to acquire territory by cession from a foreign government. The opinion on this part of the case is short, and we give the whole of it to show how well the selection of a single sentence is calculated to mislead. The passage referred to is in page 542, in which the court, in speaking of the power of Congress to establish a territorial government in Florida until it should become a state, uses the following language. In the meantime, Florida continues to be a territory of the United States, governed by that clause of the Constitution which empowers Congress to make all needful rules and regulations respecting the territory or other properties of the United States. Perhaps the power of governing a territory belonging to the United States, which has not, by becoming a state, acquired the means of self-government, may result necessarily from the facts that it is not within the jurisdiction of any particular state, and is within the power and jurisdiction of the United States. The right to govern may be the inevitable consequence of the right to acquire territory. Whichever may be the source from which the power is derived, the possession of it is unquestionable. It is thus clear from the whole opinion on this point that the court did not mean to decide whether the power was derived from the clause in the Constitution or was the necessary consequence of the right to acquire. They do decide that the power in Congress is unquestionable, and in this we entirely concur, and nothing will be found in this opinion to the contrary. The power stands firmly on the latter alternative put by the court, that is, as the inevitable consequence of the right to acquire territory. And what still more clearly demonstrates that the court did not mean to decide the question, but leave it open for future consideration, is the fact that the case was decided in the Circuit Court by Mr. Justice Johnson, and his decision was affirmed by the Supreme Court. His opinion at the circuit is given in full in a note to the case, and in that opinion he states, in explicit terms, that the clause of the Constitution applies only to the territory then within the limits of the United States and not to Florida, which had been acquired by cession from Spain. This part of his opinion will be found in the note in page 517 of the report, but he does not dissent from the opinion of the Supreme Court, thereby showing that, in his judgment, as well as that of the court, the case before them did not call for a decision on that particular point, and the court abstained from deciding it. And in a part of its opinion subsequent to the passage we have quoted, where the courts speak of the legislative power of Congress in Florida, they still speak with the same reserve. And in page 546, speaking of the power of legislative courts created in virtue, and in page 546, speaking of the power of Congress to authorize the territorial legislature to establish courts there, the courts say, they are legislative courts created in virtue of the general right of sovereignty which exists in the government, or in virtue of that clause which enables Congress to make all needful rules and regulations respecting the territory belonging to the United States. And it has been said that the construction given to this clause is new, and now for the first time brought forward. The case of which we are speaking, and which has been so much discussed, shows that the fact is otherwise. It shows that precisely the same question came before Mr. Justice Johnson at his circuit 30 years ago, was fully considered by him, and the same construction given to the clause in the Constitution which is now given by this court, and that upon an appeal from his decision the same question was brought before this court, but was not decided because a decision upon it was not required by the case before the court. There is another sentence in the opinion which has been commented on, which even in a still more striking manner shows how one may mislead or be misled by taking out a single sentence from the opinion of a court and leaving out of view what precedes and follows. It is in page 546, near the close of the opinion, in which the courts say, in legislating for them, the territories of the United States, Congress exercises the combined powers of the general and of a state government, and it is said that as a state may unquestionably prohibit slavery within its territory. This sentence decides, in effect, that Congress may do the same in a territory of the United States, exercising there the powers of a state, as well as the power of the general government. The examination of this passage in the case referred to would be more appropriate when we come to consider in another part of this opinion what power Congress can constitutionally exercise in a territory over the rights of person or rights of property of a citizen. But as it is in the same case with the passage we have before commented on, we dispose of it now, as it will save the court from the necessity of referring again to the case. And it will be seen upon reading the page in which this sentence is found that it has no reference whatever to the power of Congress over rights of person or rights of property, but relates altogether to the power of establishing judicial tribunals to administer the laws constitutionally passed and defining the jurisdiction they may exercise. The law of Congress establishing a territorial government in Florida provided that the legislature of the territory should have legislative powers over all rightful objects of legislation, but no law should be valid which was inconsistent with the laws and Constitution of the United States. Under the power thus conferred, the legislature of Florida passed an act erecting a tribunal at Key West to decide cases of salvage. And in the case of which we are speaking, the question arose whether the territorial legislature could be authorized by Congress to establish such a tribunal with such powers. And one of the parties, among other objections, insisted that Congress could not, under the Constitution, authorize the legislature of the territory to establish such a tribunal with such powers, but that it must be established by Congress itself, and that a sale of cargo made under its order to pay salvors was void, as made without legal authority and passed no property to the purchaser. It is in disposing of this objection that the sentence relied on occurs, and the court begins that part of the opinion by stating with great precision the point which they are about to decide. They say, "It has been contended that by the Constitution of the United States, the judicial power of the United States extends to all cases of admiralty and maritime jurisdiction, and that the whole of the judicial power must be vested in one Supreme Court, and in such inferior courts as Congress shall from time to time ordain and establish. Hence it has been argued that Congress cannot vest admiralty jurisdiction in courts created by the territorial legislature." And after thus clearly stating the point before them, and which they were about to decide, they proceed to show that these territorial tribunals were not constitutional courts, but merely legislative, and that Congress might, therefore, delegate the power to the territorial government to establish the court in question. And they conclude that part of the opinion in the following words: "Although admiralty jurisdiction can be exercised in the states in those courts only which are established in pursuance of the 3rd article of the Constitution, the same limitation does not extend to the territories. In legislating for them, Congress exercises the combined powers of the general and state governments." Thus it will be seen by these quotations from the opinion that the court, after stating the question it was about to decide in a manner too plain to be misunderstood, proceeded to decide it, and announced as the opinion of the tribunal that in organizing the judicial department of the government in a territory of the United States, Congress does not act under and is not restricted by the 3rd article in the Constitution, and is not bound in a territory to ordain and establish courts in which the judges hold their offices during good behavior, but may exercise the discretionary power which a state exercises in establishing its judicial department and regulating the jurisdiction of its courts, and may authorize the territorial government to establish, or may itself establish, courts in which the judges hold their offices for a term of years only, and may vest in them judicial power upon subjects confided to the judiciary of the United States. And in doing this, Congress undoubtedly exercises the combined power of the general and a state government. It exercises the discretionary power of a state government in authorizing the establishment of a court in which the judges hold their appointments for a term of years only, and not during good behavior, and it exercises the power of the general government in investing that court with admiralty jurisdiction, over which the general government had exclusive jurisdiction in the territory. No one, we presume, will question the correctness of that opinion, nor is there anything in conflict with it in the opinion now given. The point decided in the case cited has no relation to the question now before the court. That depended on the construction of the third article of the Constitution in relation to the judiciary of the United States and the power which Congress might exercise in a territory in organizing the judicial department of the government. The case before us depends upon other and different provisions of the Constitution, altogether separate and apart from the one above mentioned. The question as to what courts Congress may ordain or establish in a territory to administer laws which the Constitution authorizes it to pass, and what laws it is or is not authorized by the Constitution to pass, are widely different, are regulated by different and separate articles of the Constitution, and stand upon different principles. And we are satisfied that no one who reads attentively the page in Peter's reports to which we have referred can suppose that the attention of the court was drawn for a moment to the question now before this court, or that it meant in that case to say that Congress had a right to prohibit a citizen of the United States from taking any property which he lawfully held into a territory of the United States. This brings us to examine by what provision of the Constitution the present federal government, under its delegated and restricted powers, is authorized to acquire territory outside of the original limits of the United States, and what powers it may exercise therein over the person or property of a citizen of the United States, while it remains a territory and until it shall be admitted as one of the states of the Union. There is certainly no power given by the Constitution to the federal government to establish or maintain colonies bordering on the United States or at a distance, to be ruled and governed at its own pleasure, nor to enlarge its territorial limits in any way, except by the admission of new states. That power is plainly given, and if a new state is admitted, it needs no further legislation by Congress, because the Constitution itself defines the relative rights and powers and duties of the state and the citizens of the state and the federal government. But no power is given to acquire a territory to be held and governed permanently in that character. And indeed, the power exercised by Congress to acquire territory and establish a government there, according to its own unlimited discretion, was viewed with great jealousy by the leading statesmen of the day. And in the Federalist, number 38, written by Mr. Madison, he speaks of the acquisition of the Northwestern Territory by the Confederated States, by the cession from Virginia, and the establishment of a government there, as an exercise of power not warranted by the Articles of Confederation, and dangerous to the liberties of the people. And he urges the adoption of the Constitution as a security and safeguard against such an exercise of power. We do not mean, however, to question the power of Congress in this respect. The power to expand the territory of the United States by the admission of new states is plainly given, and in the construction of this power by all the departments of the government, it has been held to authorize the acquisition of territory, not fit for admission at the time, but to be admitted as soon as its population and situation would entitle it to admission. It is acquired to become a state, and not to be held as a colony and governed by Congress with absolute authority. And as the propriety of admitting a new state is committed to the sound discretion of Congress, the power to acquire territory for that purpose, to be held by the United States until it is in a suitable condition to become a state upon an equal footing with the other states, must rest upon the same discretion. It is a question for the political department of the government and not the judicial, and whatever the political department of the government shall recognize as within the limits of the United States, the judicial department is also bound to recognize and to administer in it the laws of the United States, so far as they apply, and to maintain in the territory the authority and rights of the government, and also the personal rights and rights of property of individual citizens, as secured by the Constitution. All we mean to say on this point is that as there is no express regulation in the Constitution defining the power which the general government may exercise over the person or property of a citizen in a territory thus acquired, the court must necessarily look to the provisions and principles of the Constitution and its distribution of powers for the rules and principles by which its decision must be governed. Taking this rule to guide us, it may be safely assumed that citizens of the United States who migrate to a territory belonging to the people of the United States cannot be ruled as mere colonists, dependent upon the will of the general government, and to be governed by any laws it may think proper to impose. The principle upon which our governments rest, and upon which alone they continue to exist, is the union of states, sovereign and independent within their own limits in their internal and domestic concerns, and bound together as one people by a general government, possessing certain enumerated and restricted powers, delegated to it by the people of the several states, and exercising supreme authority within the scope of the powers granted to it throughout the dominion of the United States. A power, therefore, in the general government to obtain and hold colonies and dependent territories, over which they might legislate without restriction, would be inconsistent with its own existence in its present form. Whatever it acquires for the benefit of the people of the several states who created it. It is their trustee acting for them, and charged with the duty of promoting the interests of the whole people of the Union in the exercise of the powers specifically granted. At the time when the territory in question was obtained by cession from France, it contained no population fit to be associated together and admitted as a state, and it therefore was absolutely necessary to hold possession of it as a territory belonging to the United States until it was settled and inhabited by a civilized community, capable of self-government, and in a condition to be admitted on equal terms with the other states as a member of the Union. But, as we have before said, it was acquired by the general government as the representative and trustee of the people of the United States, and it must therefore be held in that character for their common and equal benefit. For it was the people of the several states, acting through their agent and representative, the federal government, who in fact acquired the territory in question, and the government holds it for their common use until it shall be associated with the other states as a member of the Union. But until that time arrives, it is undoubtedly necessary that some government should be established in order to organize society and to protect the inhabitants in their persons and property. And as the people of the United States could act in this manner only through the government which represented them, and through which they spoke and acted when the territory was obtained, it was not only within the scope of its powers, but it was its duty to pass such laws and establish such a government as would enable those by whose authority they acted to reap the advantages anticipated from its acquisition, and to gather there a population which would enable it to assume the position to which it was destined among the states of the Union. The power to acquire necessarily carries with it the power to preserve and apply to the purposes for which it was acquired. The form of government to be established necessarily rested in the discretion of Congress. It was their duty to establish the one that would be best suited for the protection and security of the citizens of the United States and other inhabitants who might be authorized to take up their abode there, and that must always depend upon the existing condition of the territory as to the number and character of its inhabitants and their situation in the territory. In some cases, a government consisting of persons appointed by the federal government would best subserve the interests of the territory, when the inhabitants were few and scattered and new to one another. In other instances, it would be more advisable to commit the powers of self-government to the people who had settled in the territory, as being the most competent to determine what was best for their own interests. But some form of civil authority would be absolutely necessary to organize and preserve civilized society, and prepare it to become a state. And what is the best form must always depend on the condition of the territory at the time, and the choice of the mode must depend upon the exercise of a discretionary power by Congress, acting within the scope of its constitutional authority and not infringing upon the rights of persons or rights of property of the citizen who might go there to reside, or for any other lawful purpose. It was acquired by the exercise of this discretion, and it must be held and governed in like manner until it is fitted to be a state. But the power of Congress over the person or property of a citizen can never be a mere discretionary power under our Constitution and form of government. Powers of the government and the rights and privileges of the citizen are regulated and plainly defined by the Constitution itself. And when the territory becomes a part of the United States, the federal government enters into possession in the character impressed upon it by those who created it. It enters upon it with its powers over the citizen strictly defined and limited by the Constitution, from which it derives its own existence, and by virtue of which alone it continues to exist and act as a government and sovereignty. It has no power of any kind beyond it, and it cannot, when it enters a territory of the United States, put off its character and assume discretionary or despotic powers, which the Constitution has denied to it. It cannot create for itself a new character separated from the citizens of the United States and the duties it owes them under the provisions of the Constitution. The territory being a part of the United States, the government and the citizen both enter it under the authority of the Constitution, with their respective rights defined and marked out, and the federal government can exercise no power over his person or property beyond what that instrument confers, nor lawfully deny any right which it has reserved. A reference to a few of the provisions of the Constitution will illustrate this proposition. For example, no one, we presume, will contend that Congress can make any law in a territory respecting the establishment of religion, or the free exercise thereof, or abridging the freedom of speech, or of the press, or the right of the people of the territory peaceably to assemble and to petition the government for the redress of grievances. Nor can Congress deny to the people the right to keep and bear arms, nor the right to trial by jury, nor compel anyone to be a witness against himself in a criminal proceeding. These powers and others in relation to rights of person, which it is not necessary here to enumerate, are, in express and positive terms, denied to the general government, and the rights of private property have been guarded with equal care. Thus the rights of property are united with the rights of person, and placed on the same ground by the Fifth Amendment to the Constitution, which provides that no person shall be deprived of life, liberty, and property without due process of law. And an act of Congress which deprives a citizen of the United States of his liberty or property merely because he came himself or brought his property into a particular territory of the United States, and who had committed no offense against the laws, could hardly be dignified with the name of due process of law. So, too, it will hardly be contended that Congress could by law quarter a soldier in a house in a territory without the consent of the owner in time of peace, nor in time of war, but in a manner prescribed by law. Nor could they by law forfeit the property of a citizen in a territory who was convicted of treason for a longer period than the life of the person convicted, nor take private property for public use without just compensation. The powers over person and property of which we speak are not only not granted to Congress, but are in express terms denied, and they are forbidden to exercise them. And this prohibition is not confined to the states, but the words are general and extend to the whole territory over which the Constitution gives it power to legislate, including those portions of it remaining under territorial government, as well as that covered by states. It is a total absence of power everywhere within the dominion of the United States, and places the citizens of a territory, so far as these rights are concerned, on the same footing with citizens of the states, and guards them as firmly and plainly against any inroads which the general government might attempt under the plea of implied or incidental powers. And if Congress itself cannot do this, if it is beyond the powers conferred on the federal government, it will be admitted, we presume, that it could not authorize a territorial government to exercise them. It could confer no power on any local government established by its authority to violate the provisions of the Constitution. It seems, however, to be supposed that there is a difference between property in a slave and other property, and that different rules may be applied to it in expounding the Constitution of the United States, and the laws and usages of nations, and the writings of eminent jurists upon the relation of master and slave, and their mutual rights and duties, and the powers which governments may exercise over it, have been dwelt upon in the argument. But in considering the question before us, it must be borne in mind that there is no law of nations standing between the people of the United States and their government, and interfering with their relation to each other. The powers of the government and the rights of the citizen under it are positive and practical regulations plainly written down. The people of the United States have delegated to it certain enumerated powers, and forbidden it to exercise others. It has no power over the person or property of a citizen but what the citizens of the United States have granted, and no laws or usages of other nations or reasoning of statesmen or jurists upon the relations of master and slave can enlarge the powers of the government, or take from the citizens the rights they have reserved. And if the Constitution recognizes the right of property of the master in a slave, and makes no distinction between that description of property and other property owned by a citizen, no tribunal acting under the authority of the United States, whether it be legislative, executive, or judicial, has a right to draw such a distinction or deny to it the benefit of the provisions and guarantees which have been provided for the protection of private property against the encroachments of the government. Now, as we have already said in an earlier part of this opinion upon a different point, the right of property in a slave is distinctly and expressly affirmed in the Constitution. The right to traffic in it, like an ordinary article of merchandise and property, was guaranteed to the citizens of the United States in every state that might desire it for 20 years, and the government in express terms is pledged to protect it in all future time if the slave escapes from his owner. This is done in plain words, too plain to be misunderstood, and no word can be found in the Constitution which gives Congress a greater power over slave property, or which entitles property of that kind to less protection than property of any other description. The only power conferred is the power coupled with the duty of guarding and protecting the owner in his rights. Upon these considerations, it is the opinion of the Court that the act of Congress which prohibited a citizen from holding and owning property of this kind in the territory of the United States north of the line therein mentioned is not warranted by the Constitution and is therefore void, and that neither Dred Scott himself nor any of his family were made free by being carried into this territory, even if they had been carried there by the owner with the intention of becoming a permanent resident. We have so far examined the case as it stands under the Constitution of the United States and the powers thereby delegated to the federal government. But there is another point in the case which depends on state power and state law, and it is contended on the part of the plaintiff that he is made free by being taken to Rock Island in the state of Illinois, independently of his residence in the territory of the United States, and being so made free, he was not again reduced to a state of slavery by being brought back to Missouri. Our notice of this part of the case will be very brief, for the principle on which it depends was decided in this court upon much consideration in the case of Strauder versus Graham, reported in 10th Howard 82. In that case, the slaves had been taken from Kentucky to Ohio with the consent of the owner and afterwards brought back to Kentucky, and this court held that their status or condition as free or slave depended upon the laws of Kentucky when they were brought back into that state and not of Ohio, and that this court had no jurisdiction to revise the judgment of a state court upon its own laws. This was the point directly before the court, and the decision that this court had not jurisdiction turned upon it, as will be seen by the report of the case. So in this case, as Scott was a slave when taken into the state of Illinois by his owner, and was there held as such, and brought back in that character, his status as free or slave depended on the laws of Missouri and not of Illinois. It has, however, been urged in the argument that by the laws of Missouri he was free on his return, and that this case, therefore, cannot be governed by the case of Strauder versus Graham, where it appeared by the laws of Kentucky that the plaintiffs continued to be slaves on their return from Ohio. But whatever doubts or opinions may at one time have been entertained upon this subject, we are satisfied upon a careful examination of all the cases decided in the state courts of Missouri referred to, that it is now firmly settled by the decisions of the highest court in the state that Scott and his family, upon their return, were not free, but were, by the laws of Missouri, the property of the defendant, and that the Circuit Court of the United States had no jurisdiction when, by the laws of the state, the plaintiff was a slave and not a citizen. Moreover, the plaintiff, it appears, brought a similar action against the defendant in the state court of Missouri, claiming the freedom of himself and his family upon the same grounds and the same evidence upon which he relies in the case before the court. The case was carried before the Supreme Court of the state, was fully argued there, and that court decided that neither the plaintiff nor his family were entitled to freedom and were still the slaves of the defendant, and reversed the judgment of the inferior state court, which had given a different decision. If the plaintiff supposed that this judgment of the Supreme Court of the state was erroneous, and that this court had jurisdiction to revise and reverse it, the only mode by which he could legally bring it before this court was by writ of error directed to the Supreme Court of the state, requiring it to transmit the record to this court. If this had been done, it is too plain for argument that the writ must have been dismissed for want of jurisdiction in this court. The case of Strauder and others versus Graham is directly in point. And indeed, independent of any decision, the language of the 25th section of the Act of 1789 is too clear and precise to admit of controversy. But the plaintiff did not pursue the mode prescribed by law for bringing the judgment of a state court before this court for revision, but suffered the case to be remanded to the inferior state court, where it is still continued, and is by agreement of parties to await the judgment of this court on the point. All of this appears on the record before us and by the printed report of the case. And while the case is yet open and pending in the inferior state court, plaintiff goes into the Circuit Court of the United States upon the same case and the same evidence and against the same party, and proceeds to judgment, and then brings here the same case from the Circuit Court, which the law would not have permitted him to bring directly from the state court. And if this court takes jurisdiction in this form, the result, so far as the rights of the respective parties are concerned, is in every respect substantially the same as if it had, in open violation of law, entertained jurisdiction over the judgment of the state court upon a writ of error, and revised and reversed its judgment upon the ground that its opinion upon the question of law was erroneous. It would ill become this court to sanction such an attempt to evade the law, or to exercise an appellate power in this circuitous way, which it is forbidden to exercise in the direct and regular and invariable forms of judicial proceedings. Upon the whole, therefore, it is the judgment of this court that it appears by the record before us that the plaintiff in error is not a citizen of Missouri in the sense in which that word is used in the Constitution, and that the Circuit Court of the United States, for that reason, had no jurisdiction in the case and could give no judgment in it. Its judgment for the defendant must, consequently, be reversed and a mandate issued directing the suit to be dismissed for want of jurisdiction. End of Part 3. End of Dred Scott versus Sandford, an opinion of the United States Supreme Court. Strauder versus West Virginia. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Strauder versus West Virginia, an opinion of the United States Supreme Court. Decided in the October term, 1879. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or Justice Field's dissent. For ease of listening, this reading omits legal citations found within the text of the court's opinion. Mr. Justice Strong delivered the opinion of the court. The plaintiff in error, a colored man, was indicated for murder in the Circuit Court of Ohio County in West Virginia on the 20th of October, 1874, and upon trial was convicted and sentenced. The record was then removed to the Supreme Court of the state, and there the judgment of the Circuit Court was affirmed. The present case is a writ of error to that court, and it is now, in substance, averred that at the trial in the state court, the defendant, now plaintiff in error, was denied rights to which he was entitled under the Constitution and laws of the United States. In the Circuit Court of the state, before the trial of the indictment was commenced, the defendant presented his petition, verified by his oath, praying for a removal of the cause into the Circuit Court of the United States, assigning as ground for the removal that, by virtue of the laws of the state of West Virginia, no colored man was eligible to be a member of the grand jury or to serve on the petty jury in the state. that white men are so eligible, and that by reason of his being a colored man and having been a slave, he had reason to believe, and did believe, he could not have the full and equal benefit of all laws and proceedings in the state of West Virginia for the security of his person as is enjoyed by white citizens, and that he had less chance of enforcing in the courts of the state his rights on the prosecution as a citizen of the United States, and that the probabilities of a denial of them to him as such citizen on every trial which might take place on the indictment in the courts of the state were much more enhanced than if he was a white man. This petition was denied by the state court, and the cause was forced to trial. Motions to quash the venire, because the law under which it was issued was unconstitutional, null, and void, and successive motions to challenge the array of the panel for a new trial and an arrest of judgment were then made, all of which were overruled and made by exceptions parts of the record. The law of the state to which reference was made in the petition for removal and in the several motions was enacted on the 12th of March, 1873, and it is as follows. All white male persons who are 21 years of age and who are citizens of this state shall be liable to serve as jurors, except as herein provided. The persons excepted are state officials. In this court, several errors have been assigned, and the controlling questions underlying them all are, first, whether, by the Constitution and laws of the United States, every citizen of the United States has a right to a trial of an indictment against him by a jury selected and impaneled without discrimination against his race or color, because of race or color, and second, if he has such a right and is denied its enjoyment by the state in which he is indicted, may he cause the case to be removed into the Circuit Court of the United States. It is to be observed that the first of these questions is not whether a colored man, when an indictment has been preferred against him, has a right to a grand or petty jury composed in whole or in part of persons of his own race or color, but it is whether in the composition or selection of jurors by whom he is to be indicted or tried, all persons of his race or color may be excluded by law solely because of their race or color, so that by no possibility can any colored man sit upon the jury. The questions are important, for they demand a construction of the recent amendments of the Constitution. If the defendant has a right to have a jury selected for the trial of his case without discrimination against all persons of his race or color, because of their race or color, the right, if not created, is protected by those amendments and the legislation of Congress under them. The 14th Amendment ordains that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. This is one of a series of constitutional provisions having a common purpose, namely securing to a race recently emancipated, a race that through many generations had been held in slavery, all the civil rights that the superior race enjoy. The true spirit and meaning of the amendments, as we said in the slaughterhouse cases, cannot be understood without keeping in view the history of the times when they were adopted and the general objects they plainly sought to accomplish. At the time when they were incorporated into the Constitution, it required little knowledge of human nature to anticipate that those who had long been regarded as an inferior and subject race would, when suddenly raised to the rank of citizenship, be looked upon with jealousy and positive dislike, and that state laws might be enacted or enforced to perpetuate the distinctions that had before existed. Discriminations against them had been habitual. It was well known that in some states laws making such discriminations then existed, and others might well be expected. The colored race, as a race, was abject and ignorant, and in that condition was unfitted to command the respect of those who had superior intelligence. Their training had left them mere children, and as such they needed the protection which a wise government extends to those who are unable to protect themselves. They especially needed protection against unfriendly action in the states where they were resident. It was in view of these considerations the 14th Amendment was framed and adopted. It was designed to assure to the colored race the enjoyment of all the civil rights that under the law are enjoyed by white persons, and to give to that race the protection of the general government in that enjoyment, whenever it should be denied by the states. It not only gave citizenship and the privileges of citizenship to persons of color, but it denied to any state the power to withhold from them the equal protection of the laws, and authorized Congress to enforce its provisions by appropriate legislation. To quote the language used by us in the slaughterhouse cases, no one can fail to be impressed with the one pervading purpose found in all the amendments, lying at the foundation of each, and without which none of them would have been suggested. We mean the freedom of the slave race, the security and firm establishment of that freedom, and the protection of the newly made free man and citizen from the oppressions of those who had formerly exercised unlimited dominion over them. So again, the existence of laws in the states where the newly emancipated Negroes resided, which discriminated with gross injustice and hardship against them as a class, was the evil to be remedied, and by it, the 14th Amendment, such laws were forbidden. If, however, the states did not conform their laws to its requirements, then, by the 5th section of the Article of Amendment, Congress was authorized to enforce it by suitable legislation. And it was added, we doubt very much whether any action of a state not directed by way of discrimination against the Negroes as a class will ever be held to come within the purview of this provision. If this is the spirit and meaning of the amendment, whether it means more or not, it is to be construed liberally, to carry out the purposes of its framers. It ordains that no state shall make or enforce any laws which shall abridge the privileges or immunities of citizens of the United States, evidently referring to the newly made citizens, who, being citizens of the United States, are declared to be also citizens of the state in which they reside. It ordains that no state shall deprive any person of life, liberty, or property without due process of law, or deny to any person within its jurisdiction the equal protection of the laws. What is this but declaring that the law in the states shall be the same for the black as for the white, that all persons, whether colored or white, shall stand equal before the laws of the states, and in regard to the colored race, for whose protection the amendment was primarily designed, that no discrimination shall be made against them by law because of their color? The words of the amendment, it is true, are prohibitory, but they contain a necessary implication of a positive immunity, or right, most valuable to the colored race, the right to exemption from unfriendly legislation against them distinctively as colored, exemption from legal discriminations, implying inferiority in civil society, lessening the security of their enjoyment of the rights which others enjoy, and discriminations which are steps towards reducing them to the condition of a subject race. That the West Virginia statute respecting juries, the statute that controlled the selection of the grand and petty jury in the case of the plaintiff in error, is such a discrimination ought not to be doubted, nor would it be if the persons excluded by it were white men. If in those states where the colored people constitute a majority of the entire population, a law should be enacted excluding all white men from jury service, thus denying them the privilege of participating equally with the blacks in the administration of justice, we apprehend no one would be heard to claim that it would not be a denial to white men of the equal protection of the laws. Nor, if a law should be passed excluding all naturalized Celtic Irishmen, would there be any doubt of its inconsistency with the spirit of the amendment. The very fact that colored people are singled out and expressly denied by a statute all right to participate in the administration of the law as jurors because of their color, though they are citizens, and may be in other respects fully qualified, is practically a brand upon them, affixed by the law, an assertion of their inferiority, and a stimulant to that race prejudice which is an impediment to securing to individuals of the race that equal justice which the law aims to secure to all others. The right to a trial by jury is guaranteed to every citizen of West Virginia by the Constitution of that state, and the constitution of juries is a very essential part of the protection such a mode of trial is intended to secure. The very idea of a jury is a body of men composed of the peers or equals of the person whose rights it is selected or summoned to determine, that is, of his neighbors, fellows, associates, persons having the same legal status in society as that which he holds. Blackstone, in his commentaries, says, "The right of trial by jury, or the country, is a trial by the peers of every Englishman, and is the grand bulwark of his liberties, and is secured to him by the Great Charter. It is also guarded by statutory enactments intended to make impossible what Mr. Bentham called packing juries. It is well known that prejudices often exist against particular classes in the community, which sway the judgment of jurors, and which therefore operate in some cases to deny to persons of those classes the full enjoyment of that protection which others enjoy. Prejudice in a local community is held to be a reason for a change of venue. The framers of the constitutional amendment must have known full well the existence of such prejudice and its likelihood to continue against the manumitted slaves and their race, and that knowledge was doubtless a motive that led to the amendment. By their manumission and citizenship, the colored race became entitled to the equal protection of the laws of the states in which they resided, and the apprehension that through prejudice they might be denied that equal protection, that is, that there might be discrimination against them, was the inducement to bestow upon the national government the power to enforce the provision that no state shall deny to them the equal protection of the laws. Without the apprehended existence of prejudice, that portion of the amendment would have been unnecessary, and it might have been left to the states to extend equality of protection. In view of these considerations, it is hard to see why the statute of West Virginia should not be regarded as discriminating against a colored man when he is put upon trial for an alleged criminal offense against the state. It is not easy to comprehend how it can be said that while every white man is entitled to a trial by a jury selected from persons of his own race or color, or rather, selected without discrimination against his color, and a Negro is not, the latter is equally protected by the law with the former. Is not protection of life and liberty against race or color prejudice a right, a legal right, under the constitutional amendment? And how can it be maintained that compelling a colored man to submit to a trial for his life by a jury drawn from a panel from which the state has expressly excluded every man of his race because of color alone, however well qualified in other respects, is not a denial to him of equal legal protection? We do not say that within the limits from which it is not excluded by the amendment, a state may not prescribe the qualifications of its jurors, and in so doing make discriminations. It may confine the selection to males, to freeholders, to citizens, to persons within certain ages, or to persons having educational qualifications. We do not believe the 14th Amendment was ever intended to prohibit this. Looking at its history, it is clear it had no such purpose. Its aim was against discrimination because of race or color. As we have said more than once, its design was to protect an emancipated race and to strike down all possible legal discriminations against those who belonged to it. To quote further, "In giving construction to any of these articles, amendments, it is necessary to keep the main purpose steadily in view. It is so clearly a provision for that race and that emergency that a strong race would be necessary for its application to any other. We are not now called upon to affirm or deny that it had other purposes. The 14th Amendment makes no attempt to enumerate the rights it designed to protect. It speaks in general terms and those are as comprehensive as possible. Its language is prohibitory, but every prohibition implies the existence of rights and immunities, prominent among which is an immunity from inequality of legal protection, either for life, liberty, or property. Any state action that denies this immunity to a colored man is in conflict with the Constitution. Concluding, therefore, that the statute of West Virginia, discriminating in the selection of jurors, as it does, against Negroes because of their color, amounts to a denial of the equal protection of the laws to a colored man when he is put upon trial for an alleged offense against the state. It remains only to be considered whether the power of Congress to enforce the provisions of the 14th Amendment by appropriate legislation is sufficient to justify the enactment of Section 641 of the revised statutes. A right or an immunity, whether created by the Constitution or only guaranteed by it, even without any express delegation of power, may be protected by Congress. So in United States v. Reese, it was said by the Chief Justice of this court, rights and immunities created by or dependent upon the Constitution of the United States can be protected by Congress. The form and manner of the protection may be such as Congress in the legitimate exercise of its legislative discretion shall provide. These may be varied to meet the necessities of the particular right to be protected, but there is express authority to protect the rights and immunities referred to in the 14th Amendment and to enforce observance of them by appropriate congressional legislation. And one very efficient and appropriate mode of extending such protection and securing to a party the enjoyment of the right or immunity is a law providing for the removal of his case from a state court, in which the right is denied by the state law, into a federal court, where it will be upheld. This is an ordinary mode of protecting rights and immunities conferred by the federal Constitution and laws. Section 641 is such a provision. It enacts that when any civil suit or criminal prosecution is commenced in any state court for any cause whatsoever against any person who is denied or cannot enforce in the judicial tribunals of the state or in the part of the state where such prosecution is pending, any right secured to him by any law providing for the equal civil rights of citizens of the United States or of all persons within the jurisdiction of the United States, such suit or prosecution may, upon the petition of such defendant, filed in said state court at any time before the trial or final hearing of the case, stating the facts and verified by oath, be removed before trial into the next Circuit Court of the United States to be held in the district where it is pending. This act plainly has reference to sections 1977 and 1978 of the statutes which partially enumerate the rights and immunities intended to be guaranteed by the Constitution. The first of which declares that all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property, as is enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind, and to no other. This act puts in the form of a statute what had been substantially ordained by the constitutional amendment. It was a step towards enforcing the constitutional provisions. Section 641 was an advanced step, fully warranted, we think, by the 5th section of the 14th Amendment. We have heretofore considered and affirmed the constitutional power of Congress to authorize the removal from state courts into the circuit courts of the United States before trial of criminal prosecutions for alleged offenses against the laws of the state, when the defense presents a federal question or when a right under the federal Constitution or laws is involved. It is unnecessary now to repeat what we there said, that the petition of the plaintiff in error, filed by him in the state court before the trial of his case, made a case for removal into the federal circuit court under Section 641 is very plain. If, by the constitutional amendment and Section 1977 of the revised statutes, he was entitled to immunity from discrimination against him in the selection of jurors, because of their color, as we have endeavored to show that he was. It set forth sufficient facts to exhibit a denial of that immunity and a denial by the statute law of the state. There was error, therefore, in proceeding to the trial of the indictment against him after his petition was filed, as also in overruling his challenge to the array of the jury and in refusing to quash the panel. The judgment of the Supreme Court of West Virginia will be reversed and the case remitted with instructions to reverse the judgment of the Circuit Court of Ohio County, and it is so ordered. End of Strauder v. West Virginia, an opinion of the United States Supreme Court. Yick Wo v. Hopkins. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Yick Wo v. Hopkins, an opinion of the United States Supreme Court. Decided on May 10, 1886. Please note, this reading includes a reading of the syllabus, followed by a reading of the Supreme Court's unanimous opinion. For ease of listening, this reading omits legal citations found within the text of the court's opinion. These two cases, Yick Wo v. Hopkins and Wo Lee v. Hopkins, were argued as one and depend upon precisely the same state of facts, the first coming here upon a writ of error to the Supreme Court of the State of California, the second on appeal from the Circuit Court of the United States for that district. The plaintiff in error, Yick Wo, on August 24, 1885, petitioned the Supreme Court of California for the writ of habeas corpus, alleging that he was illegally deprived of his personal liberty by the defendant as sheriff of the city and county of San Francisco. The sheriff made return to the writ that he held the petitioner in custody by virtue of a sentence of the Police Judge's Court No. 2 of the city and county of San Francisco, whereby he was found guilty of a violation of certain ordinances of the Board of Supervisors of that county, and adjudged to pay a fine of $10 and, in default of payment, be imprisoned in the county jail at the rate of 1 day for each $1 of fine until said fine should be satisfied, and a commitment in consequence of non-payment of said fine. The ordinances for the violation of which he had been found guilty are set out as follows. Order number 1569, passed May 26, 1880, prescribing the kind of buildings in which laundries may be located. The people of the city and county of San Francisco do ordain as follows. Section 1. It shall be unlawful, from and after the passage of this order, for any person or persons to establish, maintain, or carry on a laundry within the corporate limits of the city and county of San Francisco, without having first obtained the consent of the Board of Supervisors, except the same be located in a building constructed either of brick or stone. Section 2. It shall be unlawful for any person to erect, build, or maintain, or cause to be erected, built, or maintained, over or upon the roof of any building now erected, or which may hereafter be erected, within the limits of said city and county, any scaffolding, without first obtaining the written permission of the Board of Supervisors, which permit shall state fully for what purpose said scaffolding is to be erected and used, and such scaffolding shall not be used for any other purpose than that designated in such permit. Section 3. Any person who shall violate any of the provisions of this order shall be deemed guilty of a misdemeanor, and upon conviction thereof shall be punished by a fine of not more than $1,000, or by imprisonment in the county jail not more than 6 months, or by both such fine and imprisonment. Order number 1587, passed July 28, 1880. The following section. Section 68. It shall be unlawful, from and after the passage of this order, for any person or persons to establish, maintain, or carry on a laundry within the corporate limits of the city and county of San Francisco without having first obtained the consent of the Board of Supervisors, except the same may be located in a building constructed either of brick or stone. The following facts are also admitted on the record. That petitioner is a native of China and came to California in 1861 and is still a subject of the Emperor of China. That he has been engaged in the laundry business in the same premises and building for 22 years last past. That he had a license from the Board of Fire Wardens dated March 3rd, 1884, from which it appeared that the above described premises have been inspected by the Board of Fire Wardens, and upon such inspection, said board found all proper arrangements for carrying on the business, that the stoves, washing and drying apparatus, and the appliances for heating smoothing irons are in good condition, and that their use is not dangerous to the surrounding property from fire, and that all proper precautions have been taken to comply with the provisions of Order Number 1617, defining the fire limits of the city and county of San Francisco, and making regulations concerning the erection and use of buildings in said city and county, and of Order Number 1670, prohibiting the kindling, maintenance, and use of open fire in houses. That he had certificate from the health officer that the same premises had been inspected by him, and that he found that they were properly and sufficiently drained, and that all proper arrangements for carrying on the business of a laundry without injury to the sanitary condition of the neighborhood had been complied with. That the city license of the petitioner was in force and expired October 1st, 1885, and that the petitioner applied to the Board of Supervisors June 1st, 1885, for consent of said board to maintain and carry on his laundry, but that said board on July 1st, 1885, refused said consent. It is also admitted to be true, as alleged in the petition, that on February 24th, 1880, there were about 320 laundries in the city and county of San Francisco, of which about 240 were owned and conducted by subjects of China, and of the whole number, 320, about 310 were constructed of wood, the same material that constitutes 9/10 of the houses in the city of San Francisco. The capital thus invested by the subjects of China was not less than $200,000, and they paid annually for rent, license, taxes, gas, and water about $180,000. It is alleged in the petition that your petitioner and more than 150 of his countrymen have been arrested upon the charge of carrying on business without having such special consent, while those who are not subjects of China and who are conducting 80-odd laundries under similar conditions are left unmolested and free to enjoy the enhanced trade and profits arising from this hurtful and unfair discrimination. The business of your petitioners and of those of his countrymen similarly situated is greatly impaired, and in many cases practically ruined, by this system of oppression to one kind of men and favoritism to all others. The statement therein contained as to the arrest, etc., is admitted to be true, with the qualification only that the 80-odd laundries referred to are in wooden buildings without scaffolds on the roofs. It is also admitted that petitioner and 200 of his countrymen, similarly situated, petitioned the Board of Supervisors for permission to continue their business in the various houses which they have been occupying and using for laundries for more than 20 years, and such petitions were denied, and all the petitions of those who were not Chinese, with one exception of Mrs. Mary Meagles, were granted. By Section 11 of Article 11 of the Constitution of California, it is provided that any county, city, town, or township may make and enforce within its limits all such local, police, sanitary, and other regulations as are not in conflict with general laws. By Section 74 of the Act of April 19, 1856, usually known as the Consolidation Act, the Board of Supervisors is empowered, among other things, to provide by regulation for the prevention and summary removal of nuisances to public health, the prevention of contagious diseases, to prohibit the erection of wooden buildings within any fixed limits where the streets shall have been established and graded, to regulate the sale, storage, and use of gunpowder or other explosive or combustible materials and substances, and make all needful regulations for protection against fire, to make such regulations concerning the erection and use of buildings as may be necessary for the safety of the inhabitants. The Supreme Court of California, in the opinion pronouncing the judgment in this case, said, "The Board of Supervisors, under the several statutes conferring authority upon them, has the power to prohibit or regulate all occupations which are against good morals, contrary to public order and decency, or dangerous to the public safety. Clothes washing is certainly not opposed to good morals, or subversive of public order or decency, but when conducted in given localities, it may be highly dangerous to the public safety. Of this fact the supervisors are made the judges, and having taken action in the premises, we do not find that they have prohibited the establishment of laundries, but they have, as they well might do, regulated the places at which they should be established, the character of the buildings in which they are to be maintained, etc. The process of washing is not prohibited by thus regulating the places at which and the surroundings by which it must be exercised." The Order Number 1569 and Section 68 of Order Number 1587 are not in contravention of common right, or unjust, unequal, partial, or oppressive in such sense as authorizes us in this proceeding to pronounce them invalid. After answering the position taken in behalf of the petitioner that the ordinances in question had been repealed, the Court adds, "We have not deemed it necessary to discuss the question in the light of supposed infringement of petitioner's rights under the Constitution of the United States, for the reason that we think the principles upon which contention on that head can be based have in effect been set at rest by the cases of Barbier v. Connolly and Soon-Hing v. Crowley. The writ was accordingly discharged and the prisoner remanded." In the other case, the appellant, Wo Lee, petitioned for his discharge from an alleged illegal imprisonment upon a state of facts shown upon the record precisely similar to that in the case of Yick Wo. In disposing of the application, the learned Circuit Judge Sawyer, in his opinion, after quoting the ordinance in question, proceeded at length as follows: "Thus, in a territory some 10 miles wide by 15 or more miles long, much of it still occupied as mere farming and pasturage lands, and much of it unoccupied sandbanks, in many places without a building within a quarter or half a mile of each other, including the isolated and almost wholly unoccupied Goat Island, the right to carry on this, when properly guarded, harmless and necessary occupation in a wooden building is not made to depend upon any prescribed conditions giving a right to anybody complying with them, but upon the consent or arbitrary will of the Board of Supervisors. In 3/4 of the territory covered by the ordinance, there is no more need of prohibiting or regulating laundries than if they were located in any portion of the farming regions of the state. Hitherto, the regulation of laundries has been limited to the thickly settled portions of the city. Why this unnecessary extension of the limits affected, if not designed to prevent the establishment of laundries, after compulsory removal from their present locations, within practicable reach of the customers or their proprietors? and the uncontradicted petition shows that all Chinese applications are in fact denied, and those of Caucasians granted, thus, in fact, making the discriminations in the administration of the ordinance which its terms permit. The fact that the right to give consent is reserved in the ordinance shows that carrying on the laundry business in wooden buildings is not deemed of itself necessarily dangerous. It must be apparent to every well-informed mind that a fire, properly guarded for laundry purposes in a wooden building, is just as necessary and no more dangerous than a fire for cooking purposes or for warming a house. If the ordinance under consideration is valid, then the Board of Supervisors can pass a valid ordinance preventing the maintenance in a wooden building of a cooking stove, heating apparatus, or a restaurant within the boundaries of the city and county of San Francisco, without the consent of that body, arbitrarily giving or withheld, as their prejudices or other motives may dictate. If it is competent for the Board of Supervisors to pass a valid ordinance prohibiting the inhabitants of San Francisco from following any ordinary, proper, and necessary calling within the limits of the city and county, except at its arbitrary and unregulated discretion and special consent, and it can do so if this ordinance is valid, then it seems to us that there has been a wide departure from the principles that have heretofore been supposed to guard and protect the rights, property, and liberties of the American people. And if by an ordinance, general in its terms and form, like the one in question, by reserving an arbitrary discretion in the enacting body to grant or deny permission to engage in a proper and necessary calling, a discrimination against any class can be made in its execution, thereby evading and in effect nullifying the provision of the national Constitution, then the insertion of provisions to guard the rights of every class and person in that instrument was a vain and futile act. The effect of the execution of this ordinance in the manner indicated in the record would seem to be necessarily to close up the many Chinese laundries now existing, or compel their owners to pull down their present buildings and reconstruct of brick or stone, or to drive them outside the city and county of San Francisco to the adjoining counties, beyond the convenient reach of the customers, either of which results would be little short of absolute confiscation of the large amount of property shown to be now and to have been for a long time invested in these occupations. If this would not be depriving such parties of their property without due process of law, it would be difficult to say what would effect that prohibited result. The necessary tendency, if not the specific purpose, of this ordinance and of enforcing it in the manner indicated in the record is to drive out of business all the numerous small laundries, especially those owned by Chinese, and give a monopoly of the business to the large institutions established and carried on by means of large associated Caucasian capital. If the facts appearing on the face of the ordinance, on the petition and return, and admitted in the case, and shown by the notorious public and municipal history of the times, indicate a purpose to drive out the Chinese laundrymen, and not merely to regulate the business for the public safety, does it not disclose a case of violation of the provisions of the 14th Amendment to the National Constitution and of the treaty between the United States and China in more than one particular? If this means prohibition of the occupation and a destruction of the business and property of the Chinese laundrymen in San Francisco, as it seems to us this must be the effect of executing the ordinance, and not merely the proper regulation of the business, then there is discrimination and a violation of other highly important rights secured by the 14th Amendment and the treaty. That it does mean prohibition as to the Chinese, it seems to us must be apparent to every citizen of San Francisco who has been here long enough to be familiar with the course of an active and aggressive branch of public opinion and of public notorious events. Can a court be blind to what must be necessarily known to every intelligent person in the state? But, in deference to the decision of the Supreme Court of California in the case of Yick Wo, and contrary to his own opinion as thus expressed, the circuit judge discharged the writ and remanded the prisoner. Mr. Justice Matthews delivered the opinion of the court. In the case of the petitioner, brought here by writ of error to the Supreme Court of California, our jurisdiction is limited to the question whether the plaintiff in error has been denied a right in violation of the Constitution, laws, or treaties of the United States. The question whether his imprisonment is illegal under the Constitution and laws of the state is not open to us, and although that question might have been considered in the Circuit Court in the application made to it, and by this Court on appeal from its order, yet judicial propriety is best consulted by accepting the judgment of the state court upon the points involved in that inquiry. That, however, does not preclude this court from putting upon the ordinances of the supervisors of the county and city of San Francisco an independent construction for the determination of the question whether the proceedings under these ordinances and in enforcement of them are in conflict with the Constitution and laws of the United States necessarily involves the meaning of the ordinances, which for that purpose we are required to ascertain and adjudge. We are consequently constrained at the outset to differ from the Supreme Court of California upon the real meaning of the ordinances in question. That court considered these ordinances as vesting in the Board of Supervisors a not unusual discretion in granting or withholding their assent to the use of wooden buildings as laundries, to be exercised in reference to the circumstances of each case with a view to the protection of the public against the dangers of fire. We are not able to concur in that interpretation of the power conferred upon the supervisors. There is nothing in the ordinances which points to such a regulation of the business of keeping and conducting laundries. They seem intended to confer, and actually to confer, not a discretion to be exercised upon a consideration of the circumstances of each case, but a naked and arbitrary power to give or withhold consent, not only as to places, but as to persons, so that if an applicant for such consent, being in every way a competent and qualified person, and having complied with every reasonable condition demanded by any public interest, should, failing to obtain the requisite consent of the supervisors to the prosecution of his business, apply for redress by the judicial process of mandamus to require the supervisors to consider and act upon his case, it would be a sufficient answer for them to say that the law had conferred upon them authority to withhold their assent without reason and without responsibility. The power given to them is not confided to their discretion in the legal sense of that term, but is granted to their mere will. It is purely arbitrary and acknowledges neither guidance nor restraint. This erroneous view of the ordinances in question led the Supreme Court of California into the further error of holding that they were justified by the decisions of this court in the cases of Barbier v. Connolly and Soon Hing v. Crowley. In both of these cases, the ordinance involved was simply a prohibition to carry on the washing and ironing of clothes in public laundries and washhouses within certain prescribed limits of the city and county of San Francisco, from 10 o'clock at night until 6 o'clock in the morning of the following day. This provision was held to be purely a police regulation, within the competency of any municipality possessed of the ordinary powers belonging to such bodies. A necessary measure of precaution in a city composed largely of wooden buildings, like San Francisco, in the application of which there was no invidious discrimination against any one within the prescribed limits, all persons engaged in the same business being treated alike and subject to the same restrictions, and entitled to the same privileges under similar conditions. For these reasons, that ordinance was adjudged not to be within the prohibitions of the 14th Amendment to the Constitution of the United States, which, it was said in the first case cited, undoubtedly intended not only that there should be no arbitrary deprivation of life or liberty, or arbitrary spoliation of property, but that equal protection and security should be given to all under like circumstances in the enjoyment of their personal and civil rights, that all persons should be equally entitled to pursue their happiness and acquire and enjoy property, that they should have like access to the courts of the country for the protection of their persons and property, the prevention and redress of wrongs, and the enforcement of contracts, that no impediment should be interposed to the pursuits of any one, except as applied to the same pursuits by others under like circumstances, that no greater burdens should be laid upon one than are laid upon others in the same calling and condition, and that in the administration of criminal justice no different or higher punishment should be imposed upon one than such as is prescribed to all for like offenses. Class legislation, discriminating against some and favoring others, is prohibited, but legislation which, in carrying out a public purpose, is limited in its application, if within the sphere of its operation it affects alike all persons similarly situated, is not within the amendment. The ordinance drawn in question in the present case is of a very different character. It does not prescribe a rule and conditions for the regulation of the use of property for laundry purposes to which all similarly situated may conform. It allows, without restriction, the use for such purposes of buildings of brick or stone, but as to wooden buildings, constituting nearly all those in previous use, it divides the owners or occupiers into two classes, not having respect to their personal character and qualifications for the business, nor the situation and nature and adaptation of the buildings themselves, but merely by an arbitrary line, on one side of which are those who are permitted to pursue their industry by the mere will and consent of the supervisors, and on the other those from whom that consent is withheld at their mere will and pleasure. And both classes are alike only in this, that they are tenants at will, under the supervisors of their means of living. The ordinance therefore also differs from the not unusual case where discretion is lodged by law in public officers or bodies to grant or withhold licenses to keep taverns, or places for the sale of spirituous liquors, and the like, when one of the conditions is that the applicant shall be a fit person for the exercise of the privilege, because in such cases the fact of fitness is submitted to the judgment of the officer, and calls for the exercise of a discretion of a judicial nature. The rights of the petitioners, as affected by the proceedings of which they complain, are not less because they are aliens and subjects of the Emperor of China. By the third article of the treaty between this government and that of China, concluded November 17, 1880, it is stipulated, if Chinese laborers, or Chinese of any other class, now either permanently or temporarily residing in the territory of the United States, meet with ill treatment at the hands of any other persons, the government of the United States will exert all its powers to devise measures for their protection, and to secure to them the same rights, privileges, immunities, and exemptions as may be enjoyed by the citizens or subjects of the most favored nation, and to which they are entitled by treaty. The 14th Amendment to the Constitution is not confined to the protection of citizens. It says, "Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction an equal protection of the laws." These provisions are universal in their application to all persons within the territorial jurisdiction, without regard to any differences of race, of color, or of nationality. And the equal protection of the laws is a pledge of the protection of equal laws. It is accordingly enacted by Section 1977 of the Revised Statutes that all persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property, as is enjoyed by white citizens, and shall be subject to like punishments, pains, penalties, taxes, licenses, and exactions of every kind, and to no other. The questions we have to consider and decide in these cases, therefore, are to be treated as involving the rights of every citizen of the United States equally, with those of the strangers and aliens who now invoke the jurisdiction of the court. It is contended on the part of the petitioners that the ordinances for violations of which they are severally sentenced to imprisonment are void on their face, as being within the prohibitions of the 14th Amendment, and, in the alternative, if not so, that they are void by reason of their administration, operating unequally, so as to punish in the present petitioners what is permitted to others as lawful, without any distinction of circumstances, an unjust and illegal discrimination, it is claimed, which, though not made expressly by the ordinances, is made possible by them. When we consider the nature and the theory of our institutions of government, the principles upon which they are supposed to rest, and review the history of their development, we are constrained to conclude that they do not mean to leave room for the play and action of purely personal and arbitrary power. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. But in our system, while sovereign powers are delegated to the agencies of government, sovereignty itself remains with the people, by whom and for whom all government exists and acts, and the law is the definition and limitation of power. It is indeed quite true that there must always be lodged somewhere, and in some person or body, the authority of final decision, and in many cases of mere administration, the responsibility is purely political, no appeal lying except to the ultimate tribunal of the public judgment, exercised either in the pressure of opinion or by means of the suffrage. But the fundamental rights to life, liberty, and the pursuit of happiness, considered as individual possessions, are secured by those maxims of constitutional law which are the monuments showing the victorious progress of the race in securing to men the blessings of civilization under the reign of just and equal laws, so that, in the famous language of the Massachusetts Bill of Rights, the government of the Commonwealth may be a government of laws and not of men. For the very idea that one man may be compelled to hold his life, or the means of living, or any material right essential to the enjoyment of life, at the mere will of another, seems to be intolerable in any country where freedom prevails, as being the essence of slavery itself. There are many illustrations that might be given of this truth, which would make manifest that it was self-evident in the light of our system of jurisprudence. The case of the political franchise of voting is one. Though not regarded strictly as a natural right, but as a privilege merely conceded by society, according to its will, under certain conditions, nevertheless it is regarded as a fundamental political right because preservative of all rights. In reference to that right, it was declared by the Supreme Judicial Court of Massachusetts, in Capon v. Foster, in the words of Chief Justice Shaw, that in all cases where the Constitution has conferred a political right or privilege, and where the Constitution has not particularly designated the manner in which that right is to be exercised, it is clearly within the just and constitutional limits of the legislative power to adopt any reasonable and uniform regulations in regard to the time and mode of exercising that right, which are designed to secure and facilitate the exercise of such right in a prompt, orderly, and convenient manner. Nevertheless, such a construction would afford no warrant for such an exercise of legislative power as, under the pretense and color of regulating, should subvert or injuriously restrain the right itself. It has accordingly been held generally in the states that whether the particular provisions of an act of legislation establishing means for ascertaining the qualifications of those entitled to vote, and making previous registration in lists of such, a condition precedent to the exercise of the right, were or were not reasonable regulations, and accordingly valid or void, was always open to inquiry as a judicial question. The same principle has been more freely extended to the quasi-legislative acts of inferior municipal bodies, in respect to which it is an ancient jurisdiction of judicial tribunals to pronounce upon the reasonableness and consequent validity of their bylaws. In respect to these, it was the doctrine that every bylaw must be reasonable, not inconsistent with the charter of the corporation, nor with any statute of Parliament, nor with the general principles of the common law of the land, particularly those having relation to the liberty of the subject or the rights of private property. Accordingly, in the case of State v. Cincinnati Gas, Light, and Coke Company, an ordinance of the City Council purporting to fix the price to be charged for gas under an authority of law giving discretionary power to do so, was held to be bad if passed in bad faith, fixing an unreasonable price for the fraudulent purpose of compelling the gas company to submit to an unfair appraisement of their works. And a similar question, very pertinent to the one in the present cases, was decided by the Court of Appeals of Maryland in the case of City of Baltimore versus Radek. In that case, the defendant had erected and used a steam engine in the prosecution of his business as a carpenter and box maker in the City of Baltimore, under a permit from the mayor and city council, which contained a condition that the engine was to be removed after 6 months' notice to that effect from the mayor. After such notice and refusal to conform to it, a suit was instituted to recover the penalty provided by the ordinance, to restrain the prosecution of which a bill in equity was filed. The court holding the opinion that there may be a case in which an ordinance passed under grants of power like those we have cited is so clearly unreasonable, so arbitrary, oppressive, or partial, as to raise the presumption that the legislature never intended to confer the power to pass it, and to justify the courts in interfering and setting it aside as a plain abuse of authority. It proceeds to speak with regard to the ordinance in question in relation to the use of steam engines as follows. It does not profess to prescribe regulations for their construction, location, or use, nor require such precautions and safeguards to be provided by those who own and use them as are best calculated to render them less dangerous to life and property. Nor does it restrain their use in box factories and other similar establishments within certain defined limits, not in any other way attempt to promote their safety and security without destroying their usefulness. But it commits to the unrestrained will of a single public officer the power to notify every person who now employs a steam engine in the prosecution of any business in the City of Baltimore to cease to do so, and by providing compulsory fines for every day's disobedience of such notice and order of removal, renders his power over the use of steam in that city practically absolute, so that he may prohibit its use altogether. But if he should not choose to do this, but only to act in particular cases, there is nothing in the ordinance to guide or control his action. It lays down no rules by which its impartial execution can be secured, or partiality and oppression prevented. It is clear that giving and enforcing these notices may, and quite likely will, bring ruin to the business of those against whom they are directed, while others, from whom they are withheld, may be actually benefited by what is thus done to their neighbors. And when we remember that this action of non-action may proceed from enmity or prejudice, from partisan zeal or animosity, from favoritism and other improper influences and motives easy of concealment and difficult to be detected and exposed, it becomes unnecessary to suggest or comment upon the injustice capable of being wrought under cover of such a power, for that becomes apparent to every one who gives to the subject a moment's consideration. In fact, an ordinance which clothes a single individual with such power hardly falls within the domain of law, and we are constrained to pronounce it inoperative and void. This conclusion, and the reasoning on which it is based, are deductions from the face of the ordinance as to its necessary pendency and ultimate actual operation. In the present cases, we are not obliged to reason from the probable to the actual, and pass upon the validity of the ordinance complained of, as tried merely by the opportunities which their terms afford, of unequal and unjust discrimination in their administration. For the cases present the ordinance in actual operation, and the facts shown establish an administration directed so exclusively against a particular class of persons as to warrant and require the conclusion that, whatever may have been the intent of the ordinances as adopted, they are applied by the public authorities charged with their administration, and thus representing the state itself, with a mind so unequal and oppressive as to amount to a practical denial by the state of that equal protection of the laws which is secured to the petitioners, as to all other persons, by the broad and benign provisions of the 14th Amendment to the Constitution of the United States. Though the law itself be fair on its face and impartial in appearance, yet if it is applied and administered by public authority with an evil eye and an unequal hand, so as practically to make unjust and illegal discriminations between persons in similar circumstances material to their rights, the denial of equal justice is still within the prohibition of the Constitution. This principle of interpretation has been sanctioned by this court in Henderson v. Mayor of New York, Chai Looney v. Freeman, Ex parte Virginia, Neal v. Delaware, and Sun Hing v. Crowley. The present cases, as shown by the facts disclosed in the record, are within this class. It appears that both petitioners have complied with every requisite deemed by the law, or by the public officers charged with its administration, necessary for the protection of neighboring property from fire, or as a precaution against injury to the public health. No reason whatever, except the will of the supervisors, is assigned why they should not be permitted to carry on, in the accustomed manner, their harmless and useful occupation, on which they depend for a livelihood. And while this consent of the supervisors is withheld from them and from 200 others who have also petitioned, all of whom happen to be Chinese subjects, 80 others, not Chinese subjects, are permitted to carry on the same business under similar conditions. The fact of this discrimination is admitted. No reason for it is shown, and the conclusion cannot be resisted that no reason for it exists except hostility to the race and nationality to which the petitioners belong, and which, in the eye of the law, is not justified. The discrimination is therefore illegal, and the public administration which enforces it is a denial of the equal protection of the laws and a violation of the 14th Amendment of the Constitution. The imprisonment of the petitioners is therefore illegal, and they must be discharged. To this end, the judgment of the Supreme Court of California in the case of Yick Wo and that of the Circuit Court of the United States for the District of California in the case of Wo Lee are severally reversed and the cases remanded each to the proper court with directions to discharge the petitioners from custody and imprisonment. End of Yick Wo v. Hopkins, an opinion of the United States Supreme Court. Part 1 of Plessy v. Ferguson. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Plessy v. Ferguson, an opinion of the United States Supreme Court. Decided on May 18, 1896. Please note, Part 1 is a reading of the opinion of the court only. For ease of listening, this reading omits legal citations and footnotes found within the text of the court's opinion. Mr. Justice Brown delivered the opinion of the court. This case turns upon the constitutionality of an act of the General Assembly of the State of Louisiana, passed in 1890, providing for separate railway carriages for the white and colored races. The first section of the statute enacts that all railway companies carrying passengers in their coaches in this state shall provide equal but separate accommodations for the white and colored races by providing 2 or more passenger coaches for each passenger train, or by dividing the passenger coaches by a partition so as to secure separate accommodations, provided that this section shall not be construed to apply to street railroads. No person or persons shall be permitted to occupy seats in coaches other than the ones assigned to them, on account of the race they belong to. By the second section, it was enacted that the officers of such passenger trains shall have power and are hereby required to assign each passenger to the coach or compartment used for the race to which such passenger belongs. Any passenger insisting on going into a coach or compartment to which by race he does not belong shall be liable to a fine of $25, or in lieu thereof to imprisonment for a period of not more than 20 days in the parish prison. And any officer of any railroad insisting on assigning a passenger to a coach or compartment other than the one set aside for the race to which said passenger belongs shall be liable to a fine of $25, or in lieu thereof to imprisonment for a period of not more than 20 days in the parish prison. And should any passenger refuse to occupy the coach or compartment to which he or she is assigned by the officer of such railway, said officer shall have power to refuse to carry such passenger on his train, and for such refusal neither he nor the railway company which he represents shall be liable for damages in any of the courts of the state. The third section provides penalties for the refusal or neglect of the officers, directors, conductors, and employees of railway companies to comply with the Act, with the proviso that nothing in this Act shall be construed as applying to nurses attending children of the other race. The fourth section is immaterial. The information filed in the criminal district court charged, in substance, that Plessy, being a passenger between two stations within the state of Louisiana, was assigned by officers of the company to the coach used for the race to which he belonged, but he insisted upon going into a coach used by the race to which he did not belong. Neither in the information nor plea was his particular race or color averred. The petition for the writ of prohibition averred that petitioner was 7/8 Caucasian and 1/8 African blood, that the mixture of colored blood was not discernible in him, and that he was entitled to every right, privilege, and immunity secured to citizens of the United States of the white race, and that upon such theory he took possession of a vacant seat in a coach where passengers of the white race were accommodated, and was ordered by the conductor to vacate said coach and take a seat in another assigned to persons of the colored race, and having refused to comply with such demand, he was forcibly ejected with the aid of a police officer and imprisoned in the parish jail to answer a charge of having violated the above act. The constitutionality of this act is attacked upon the ground that it conflicts both with the 13th Amendment of the Constitution abolishing slavery and the 14th Amendment, which prohibits certain restrictive legislation on the part of the states. Number 1. That it does not conflict with the 13th Amendment, which abolished slavery and involuntary servitude except as a punishment for crime, is too clear for argument. Slavery implies involuntary servitude, a state of bondage, the ownership of mankind as a chattel, or at least the control of the labor and services of one man for the benefit of another, and the absence of a legal right to the disposal of his own person, properties, and services. This amendment was said in the slaughterhouse cases to have been intended primarily to abolish slavery, as it had been previously known in this country, and that it equally forbade Mexican peonage or the Chinese coolie trade when they amounted to slavery or involuntary servitude, and that the use of the word servitude was intended to prohibit the use of all forms of involuntary slavery of whatever class or name. It was intimated, however, in that case, that this amendment was regarded by the statesmen of that day as insufficient to protect the colored race from certain laws which had been enacted in the Southern states, imposing upon the colored race onerous disabilities and burdens, and curtailing their rights in the pursuit of life, liberty, and property to such an extent that their freedom was of little value, and that the 14th Amendment was devised to meet this exigency. So, too, in the civil rights cases, it was said that the act of a mere individual, the owner of an inn, a public conveyance, or place of amusement, refusing accommodations to colored people, cannot be justly regarded as imposing any badge of slavery or servitude upon the applicant, but only as involving an ordinary civil injury properly cognizable by the laws of the state, and presumably subject to redress by those laws until the contrary appears. It would be running the slavery question into the ground, said Mr. Justice Bradley, to make it apply to every act of discrimination which a person may see fit to make as to the guests he will entertain, or as to the people he will take into his coach or cab or car, or admit to his concert or theater, or deal with in other matters of intercourse or business. A statute which implies merely a legal distinction between the white and colored races, a distinction which is founded in the color of the two races, and which must always exist so long as white men are distinguished from the other race by color, has no tendency to destroy the legal equality of the two races, or reestablish a state of involuntary servitude. Indeed, we do not understand that the 13th Amendment is strenuously relied upon by the plaintiff in error in this connection. Number 2. By the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are made citizens of the United States and of the state wherein they reside, and the states are forbidden from making or enforcing any law which shall abridge the privileges or immunities of citizens of the United States, or shall deprive any person of life, liberty, or property without due process of law, or deny to any person within their jurisdiction the equal protection of the laws. The proper construction of this amendment was first called to the attention of this court in the slaughterhouse cases, which involved, however, not a question of race, but one of exclusive privileges. The case did not call for any expression of opinion as to the exact rights it was intended to secure to the colored race, but it was said generally that its main purpose was to establish the citizenship of the Negro, to give definitions of citizenship of the United States and of the states, and to protect from the hostile legislation of the states the privileges and immunities of citizens of the United States, as distinguished from those of citizens of the states. The object of the amendment was undoubtedly to enforce the absolute equality of the two races before the law. But, in the nature of things, it could not have been intended to abolish distinctions based upon color, or to enforce social, as distinguished from political, equality, or a commingling of the two races upon terms unsatisfactory to either. Laws permitting and even requiring their separation in places where they are liable to be brought into contact do not necessarily imply the inferiority of either race to the other, and have been generally, if not universally, recognized as within the competency of the state legislatures in the exercise of their police power. The most common instance of this is connected with the establishment of separate schools for white and colored children, which have been held to be a valid exercise of the legislative power even by courts of states where the political rights of the colored race have been longest and most earnestly enforced. One of the earliest of these cases is that of Roberts v. City of Boston, which the Supreme Judicial Court of Massachusetts held that the General School Committee of Boston had power to make provision for the instruction of colored children in separate schools established exclusively for them, and to prohibit their attendance upon the other schools. The great principle, said Chief Justice Shaw, advanced by the learned and eloquent advocate for the plaintiff, Mr. Charles Sumner, is that by the Constitution and laws of Massachusetts, all persons, without distinction of age or sex, birth or color, origin or condition, are equal before the law. But when this great principle comes to be applied to the actual and various conditions of persons in society, it will not warrant the assertion that men and women are legally clothed with the same civil and political powers, and that children and adults are legally to have the same functions and be subject to the same treatment, but only that the rights of all, as they are settled and regulated by law, are equally entitled to the paternal consideration and protection of the law for their maintenance and security. It was held that the powers of the committee extended to the establishment of separate schools for children of different ages, sexes, and colors, and that they might also establish special schools for poor and neglected children who have become too old to attend the primary school and yet have not acquired the rudiments of learning to enable them to enter the ordinary schools. Similar laws have been enacted by Congress under its general power of legislation over the District of Columbia, as well as by the legislatures of many of the states, and have been generally, if not uniformly, sustained by the courts. Laws forbidding the intermarriage of the two races may be said in a technical sense to interfere with the freedom of contract, and yet have been universally recognized as within the police power of the state. The distinction between laws interfering with the political equality of the Negro and those requiring the separation of the two races in schools, theaters, and railway carriages has been frequently drawn by this court. Thus, in Strauder v. West Virginia, it was held that a law of West Virginia limiting to white male persons 21 years of age and citizens of the state the right to sit upon juries was a discrimination which implied a legal inferiority in civil society, which lessened the security of the right of the colored race, and was a step towards reducing them to a condition of servility. Indeed, the right of a colored man that, in the selection of jurors to pass upon his life, liberty, and property, there shall be no exclusion of his race, and no discrimination against them because of color, has been asserted in a number of cases. So, where the laws of a particular locality or the charter of a particular railway corporation has provided that no person shall be excluded from the cars on account of color, we have held that this meant that persons of color should travel in the same car as white ones, and that the enactment was not satisfied by the company providing cars assigned exclusively to people of color, though they were as good as those which they assigned exclusively to white persons. Upon the other hand, where a statute of Louisiana required those engaged in the transportation of passengers among the states to give to all persons traveling within that state, upon vessels employed in that business, equal rights and privileges in all parts of the vessel, without distinction on account of race or color, and subjected to an action for damages, the owner of such a vessel who excluded colored persons on account of their color from the cabins set aside by him for the use of whites, it was held to be, so far as it applied to interstate commerce, unconstitutional and void. The court in this case, however, expressly disclaimed that it had anything whatever to do with the statute as a regulation of internal commerce, or affecting anything else than commerce among the states. In the civil rights cases, it was held that an act of Congress entitling all persons within the jurisdiction of the United States to the full and equal enjoyment of the accommodations, advantages, facilities, and privileges of inns, public conveyances on land or water, theaters, and other places of public amusement, and made applicable to citizens of every race and color, regardless of any previous condition of servitude, was unconstitutional and void, upon the ground that the 14th Amendment was prohibitory upon the states only, and the legislation authorized to be adopted by Congress for enforcing it was not direct legislation on matters respecting which the states were prohibited from making or enforcing certain laws or doing certain acts, but was corrective legislation, such as might be necessary or proper for counteracting and redressing the effect of such laws or acts. In delivering the opinion of the court, Mr. Justice Bradley observed that the 14th Amendment does not invest Congress with power to legislate upon subjects that are within the domain of state legislation, but to provide modes of relief against state legislation or state action of the kind referred to. It does not authorize Congress to create a code of municipal law for the regulation of private rights, but to provide modes of redress against the operation of state laws and the action of state officers, executive or judicial, when these are subversive of the fundamental rights specified in the amendment. Positive rights and privileges are undoubtedly secured by the 14th Amendment, but they are secured by way of prohibition against state laws and state proceedings affecting those rights and privileges, and by power given to Congress to legislate for the purpose of carrying such prohibition into effect. And such legislation must necessarily be predicated upon such supposed state laws or state proceedings and be directed to the correction of their operation and effect. Much nearer, and indeed almost directly in point, is the case of the Louisville N.O.T. Railway Company versus State, wherein the railway company was indicted for a violation of a statute of Mississippi, enacting that all railroads carrying passengers should provide equal but separate accommodations for the white and colored races by providing 2 or more passenger cars for each passenger train, or by dividing the passenger cars by a partition so as to secure separate accommodations. The case was presented in a different aspect from the one under consideration, inasmuch as it was an indictment against the railway company for failing to provide the separate accommodations. But the question considered was the constitutionality of the law. In that case, the Supreme Court of Mississippi had held that the statute applied solely to commerce within the state, and that being the construction of the state statute by its highest court was accepted as conclusive. If it be a matter, said the court, respecting commerce wholly within a state, and not interfering with commerce between the states, then obviously there is no violation of the Commerce Clause of the Federal Constitution. No question arises under this section as to the power of the state to separate in different compartments interstate passengers, or affect in any manner the privileges and rights of such passengers. All that we can consider is whether the state has the power to require that railroad trains within her limits shall have separate accommodations for the 2 races. That, affecting only commerce within the state, is no invasion of the power given to Congress by the Commerce Clause. A like course of reasoning applies to the case under consideration, since the Supreme Court of Louisiana, in the case of State versus Judge, held that the statute in question did not apply to interstate passengers, but was confined in its application to passengers traveling exclusively within the borders of the state. The case was decided largely upon the authority of Louisville N.O.T. Railway Company versus State and affirmed by this court. In the present case, no question of interference with interstate commerce can possibly arise, since the East Louisiana Railway appears to have been purely a local line, with both its termini within the state of Louisiana. Similar statutes for the separation of the 2 races upon public conveyances were held to be constitutional in Railroad versus Miles, Day versus Owen, Railway Company versus Williams, Railroad Company versus Wells, Railroad Company versus Benson, the Sioux, Logwood versus Railroad Company, McGuinn versus Forbes, People versus King, Houck versus Railway Company, Hurd versus Railroad Company. While we think the enforced separation of the races as applied to the internal commerce of the state neither abridges the privileges or immunities of the colored man, deprives him of his property without due process of law, nor denies him the equal protection of the laws within the meaning of the 14th Amendment, we are not prepared to say that the conductor, in assigning passengers to the coaches according to their race, does not act at his peril, or that the provision of the 2nd section of the Act that denies to the passenger compensation and damages for a refusal to receive him into the coach in which he properly belongs is a valid exercise of the legislative power. Indeed, we understand it to be conceded by the state's attorney that such part of the Act as exempts from liability the railway company and its officers is unconstitutional. The power to assign to a particular coach obviously implies the power to determine to which race the passenger belongs, as well as the power to determine who, under the laws of the particular state, is to be deemed a white and who a colored person. This question, though indicated in the brief of the plaintiff in error, does not properly arise upon the record in this case, since the only issue made is as to the unconstitutionality of the Act, so far as it requires the railway to provide separate accommodations, and the conductor to assign passengers according to their race. It is claimed by the plaintiff in error that, in any mixed community, the reputation of belonging to the dominant race, in this instance the white race, is property, in the same sense that a right of action or of inheritance is property. Conceding this to be so for the purposes of this case, we are unable to see how this statute deprives him of, or in any way affects his right to, such property. If he be a white man and assigned to a colored coach, he may have his action for damages against the company for being deprived of his so-called property. Upon the other hand, if he be a colored man and be so assigned, he has been deprived of no property, since he is not lawfully entitled to the reputation of being a white man. In this connection, it is also suggested by the learned counsel for the plaintiff in error that the same argument that will justify the state legislature in requiring railways to provide separate accommodations for the two races will also authorize them to require separate cars to be provided for people whose hair is of a certain color, or who are aliens, or who belong to certain nationalities, or to enact laws requiring colored people to walk upon one side of the street and white people upon the other, or requiring white men's houses to be painted white and colored men's black, or their vehicles or business signs to be of different colors, upon the theory that one side of the street is as good as the other, or that a house or vehicle of one color is as good as one of another color. The reply to all this is that every exercise of the police power must be reasonable and extend only to such laws as are enacted in good faith for the promotion of the public good, and not for the annoyance or oppression of a particular class. Thus, in Yick Wo versus Hopkins, it was held by this court that a municipal ordinance of the city of San Francisco to regulate the carrying on of public laundries within the limits of the municipality violated the provisions of the Constitution of the United States if it conferred upon the municipal authorities arbitrary power at their own will and without regard to discretion in the legal sense of the term, to give or withhold consent as to persons or places without regard to the competency of the persons applying or the propriety of the places selected for the carrying on of the business. It was held to be a covert attempt on the part of the municipality to make an arbitrary and unjust discrimination against the Chinese race. While this was the case of a municipal ordinance, a like principle has been held to apply to acts of a state legislature passed in the exercise of the police power. So far, then, as a conflict with the 14th Amendment is concerned, the case reduces itself to the question whether the statute of Louisiana is a reasonable regulation. And with respect to this, there must necessarily be a large discretion on the part of the legislature. In determining the question of reasonableness, it is at liberty to act with reference to the established usages, customs, and traditions of the people, and with a view to the promotion of their comfort and the preservation of the public peace and good order. Gauged by this standard, we cannot say that a law which authorizes or even requires the separation of the two races in public conveyances is unreasonable, or more obnoxious to the 14th Amendment than the acts of Congress requiring separate schools for colored children in the District of Columbia, the constitutionality of which does not seem to have been questioned, or the corresponding acts of state legislatures. We consider the underlying fallacy of the plaintiff's argument to consist in the assumption that the enforced separation of the two races stamps the colored race with a badge of inferiority. If this be so, it is not by reason of anything found in the act, but solely because the colored race chooses to put that construction upon it. The argument necessarily assumes that if, as has been more than once the case, and is not unlikely to be so again, the colored race should become the dominant power in the state legislature and should enact a law in precisely similar terms, it would thereby regulate the white race to an inferior position. We imagine that the white race, at least, would not acquiesce in this assumption. The argument also assumes that social prejudices may be overcome by legislation and that equal rights cannot be secured to the Negro except by an enforced commingling of the two races. We cannot accept this proposition. If the two races are to meet upon terms of social equality, it must be the result of natural affinities, a mutual appreciation of each other's merits, and a voluntary consent of individuals. As was said by the Court of Appeals of New York in People v. Gallagher, this end can neither be accomplished nor promoted by laws which conflict with the general sentiment of the community upon whom they are designed to operate. When the government, therefore, has secured to each of its citizens equal rights before the law, and equal opportunities for improvement and progress, it has accomplished the end for which it was organized, and performed all the functions respecting social advantages with which it is endowed. Legislation is powerless to eradicate racial instincts, or to abolish distinctions based upon physical differences, and the attempt to do so can only result in accentuating the difficulties of the present situation. If the civil and political rights of both races be equal, one cannot be inferior to the other civilly or politically. If one race be inferior to the other socially, the Constitution of the United States cannot put them upon the same plane. It is true that the question of the proportion of colored blood necessary to constitute a colored person, as distinguished from a white person, is one upon which there is a difference of opinion in the different states. Some holding that any visible admixture of black blood stamps the person as belonging to the colored race, others that it depends upon the preponderance of blood, and still others that the predominance of white blood must only be in the proportion of 3/4. But these are questions to be determined under the laws of each state, and are not properly put in issue in this case. Under the allegations of his petition, it may undoubtedly become a question of importance whether, under the laws of Louisiana, the petitioner belongs to the white or colored race. The judgment of the court below is therefore affirmed. End of Part 1. Part 2 of Plessy v. Ferguson. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Plessy v. Ferguson. An opinion of the United States Supreme Court. Decided on May 18, 1896. Please note, Part 2 is a reading of Justice Harlan's dissent. For ease of listening, this reading omits legal citations and footnotes found within the text of the opinion. Mr. Justice Harlan, dissenting. By the Louisiana statute, the validity of which is here involved, all railway companies other than street railroad companies carrying passengers in that state are required to have separate but equal accommodations for white and colored persons by providing 2 or more passenger coaches for each passenger train, or by dividing the passenger coaches by a partition so as to secure separate accommodations. Under this statute, no colored person is permitted to occupy a seat in a coach assigned to white persons, nor any white person to occupy a seat in a coach assigned to colored persons. The managers of the railroad are not allowed to exercise any discretion in the premises, but are required to assign each passenger to some coach or compartment set apart for the exclusive use of his race. If a passenger insists upon going into a coach or compartment not set apart for persons of his race, he is subject to be fined or to be imprisoned in the parish jail. Penalties are prescribed for the refusal or neglect of the officers, directors, conductors, and employees of railroad companies to comply with the provisions of the Act. Only nurses attending children of the other race are excepted from the operation of the statute. No exception is made of colored attendants traveling with adults. A white man is not permitted to have his colored servant with him in the same coach, even if his condition of health requires the constant personal assistance of such servant. If a colored maid insists upon riding in the same coach with a white woman whom she has been employed to serve, and who may need her personal attention while traveling, she is subject to be fined or imprisoned for such an exhibition of zeal in the discharge of duty. While there may be in Louisiana persons of different races who are not citizens of the United States, the words in the Act, white and colored races, necessarily include all citizens of the United States of both races residing in that state, so that we have before us a state enactment that compels, under penalties, the separation of the 2 races in railroad passenger coaches, and makes it a crime for a citizen of either race to enter a coach that has been assigned to citizens of the other race. Thus, the state regulates the use of public highway by citizens of the United States solely upon the basis of race. However apparent the injustice of such legislation may be, we have only to consider whether it is consistent with the Constitution of the United States. That a railroad is a public highway, and that the corporation which owns or operates it is in the exercise of public functions, is not at this day to be disputed. Mr. Justice Nelson, speaking for this court in New Jersey Steam Navigation Company versus Merchants Bank, said that a common carrier was in the exercise of a sort of public office and has public duties to perform, from which he should not be permitted to exonerate himself without the assent of the parties concerned. Mr. Justice Strong, delivering the judgment of this court in Allcott versus Supervisors, said that railroads, though constructed by private corporations and owned by them, are public highways. Has been the doctrine of nearly all the courts ever since such conveyances for passage and transportation have had any existence. Very early, the question arose whether a state's right of eminent domain could be exercised by a private corporation created for the purpose of constructing a railroad. Clearly, it could not, unless taking land for such a purpose by such an agency is taking land for public use. The right of eminent domain nowhere justifies taking property for a private use. Yet, it is a doctrine universally accepted that a state legislature may authorize a private corporation to take land for the construction of such a road, making compensation to the owner. What else does this doctrine mean if not that building a railroad, though it be built by a private corporation, is an act done for a public use? So, in Township of Pine Grove versus Talcott, though the corporation, a railroad company, was private, its work was public, as much so as if it were to be constructed by the state. So, in Inhabitants of Worcester versus Western Railroad Corporation, the establishment of that great thoroughfare is regarded as a public work, established by public authority, intended for the public use and benefit, the use of which is secured to the whole community, and constitutes, therefore, like a canal, turnpike, or highway, a public easement. It is true that the real and personal property necessary to the establishment and management of the railroad is vested in the corporation, but it is in trust for the public. In respect of civil rights common to all citizens, the Constitution of the United States does not, I think, permit any public authority to know the race of those entitled to be protected in the enjoyment of such rights. Every true man has pride of race, and under appropriate circumstances, when the rights of others, his equals before the law, are not to be affected, it is his privilege to express such pride and to take such action based upon it as to him seems proper. But I deny that any legislative body or judicial tribunal may have regard to the race of citizens when the civil rights of those citizens are involved. Indeed, such legislation as that here in question is inconsistent not only with that equality of rights which pertains to citizenship, national and state, but with the personal liberty enjoyed by everyone within the United States. The 13th Amendment does not permit the withholding or the deprivation of any right necessarily inhering in freedom. It not only struck down the institution of slavery as previously existing in the United States, but it prevents the imposition of any burdens or disabilities that constitute badges of slavery or servitude. It decreed universal civil freedom in this country. This court has so adjudged. But that amendment having been found inadequate to the protection of the rights of those who had been in slavery, it was followed by the 14th Amendment, which added greatly to the dignity and glory of American citizenship and to the security of personal liberty by declaring that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside, and that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. These two amendments, if enforced according to their true intent and meaning, will protect all the civil rights that pertain to freedom and citizenship. Finally, and to the end, that no citizen should be denied, on account of his race, the privilege of participating in the political control of his country. It was declared by the 15th Amendment that the right of citizens of the United States to vote shall not be denied or abridged by the United States or by any state on account of race, color, or previous condition of servitude. These notable additions to the fundamental law were welcomed by the Friends of Liberty throughout the world. They removed the race line from our governmental systems. They had, as this court has said, a common purpose, namely to secure to a race recently emancipated, a race that through many generations have been held in slavery, all the civil rights that the superior race enjoy. They declared, in legal effect, this court has further said, that the law in the states shall be the same for the black as for the white, that all persons, whether colored or white, shall stand equal before the laws of the states. And in regard to the colored race, for whose protection the amendment was primarily designated, that no discrimination shall be made against them by law because of their color. We also said, the words of the amendment, it is true, are prohibitory, but they contain a necessary implication of a positive immunity or right, most valuable to the colored race, the right to exemption from unfriendly legislation against them, distinctly as colored, exemption from legal discriminations implying inferiority in civil society, lessening the security of their enjoyment of the rights which others enjoy, and discriminations which are steps towards reducing them to the condition of a subject race. It was, consequently, adjudged that a state law that excluded citizens of the colored race from juries because of their race, however well qualified in other respects to discharge the duties of jurymen, was repugnant to the 14th Amendment. At the present term, referring to the previous adjudications, this court declared that, underlying all of those decisions is the principle that the Constitution of the United States, in its present form, forbids, so far as civil and political rights are concerned, discrimination by the general government or the states against any citizen because of his race. All citizens are equal before the law. The decisions referred to show the scope of the recent amendments of the Constitution. They also show that it is not within the power of a state to prohibit colored persons, because of their race, from participating as jurors in the administration of justice. It was said in argument that the statute of Louisiana does not discriminate against either race, but prescribes a rule applicable alike to white and colored citizens. But this argument does not meet the difficulty. Everyone knows that the statute in question had its origin in the purpose, not so much to exclude white persons from railroad cars occupied by blacks, as to exclude colored people from coaches occupied by or assigned to white persons. Railroad corporations of Louisiana did not make discrimination among whites in the matter of accommodation for travelers. The thing to accomplish was, under the guise of giving equal accommodation for whites and blacks, to compel the latter to keep to themselves while traveling in railroad passenger coaches. No one would be so wanting in candor as to assert the contrary. The fundamental objection, therefore, to the statute is that it interferes with the personal freedom of citizens. Personal liberty, it has been well said, consists in the power of locomotion, of changing situation, or removing one's person to whatsoever places one's own inclination may direct, without imprisonment or restraint, unless by due course of law. If a white man and a black man choose to occupy the same public conveyance on a public highway, it is their right to do so, and no government, proceeding alone on grounds of race, can prevent it without infringing the personal liberty of each. It is one thing for railroad carriers to furnish, or to be required by law to furnish, equal accommodations for all whom they are under a legal duty to carry. It is quite another thing for government to forbid citizens of the white and black races from traveling in the same public conveyance, and to punish officers of railroad companies for permitting persons of the two races to occupy the same passenger coach. If a state can prescribe as a rule of civil conduct that whites and blacks shall not travel as passengers in the same railroad coach? Why may it not so regulate the use of the streets of its cities and towns as to compel white citizens to keep on one side of a street and black citizens to keep on the other? Why may it not upon like grounds punish whites and blacks who ride together in streetcars or in open vehicles on a public road or street? Why may it not require sheriffs to assign whites to one side of a courtroom and blacks to the other? And why may it not also prohibit the commingling of the two races in the galleries of legislative halls or in public assemblages convened for the consideration of the political questions of the day? Further, if this statute of Louisiana is consistent with the personal liberty of citizens, why may not the state require the separation in railroad coaches of native and naturalized citizens of the United States, or of Protestants and Roman Catholics? The answer given at the argument to these questions was that regulations of the kind they suggest would be unreasonable and could not, therefore, stand before the law. Is it meant that the determination of questions of legislative power depends upon the inquiry whether the statute whose validity is questioned is, in the judgment of the courts, a reasonable one, taking all the circumstances into consideration? A statute may be unreasonable merely because a sound public policy forbade its enactment, but I do not understand that the courts have anything to do with the policy or expediency of legislation. A statute may be valid and yet, upon grounds of public policy, may well be characterized as unreasonable. Mr. Sedgwick correctly states the rule when he says that, the legislative intention being clearly ascertained, the courts have no other duty to perform than to execute the legislative will, without any regard to their views as to the wisdom or justice of the particular enactment. There is a dangerous tendency in these latter days to enlarge the functions of the courts by means of judicial interference with the will of the people as expressed by the legislature. Our institutions have the distinguishing characteristic that the three departments of government are coordinate and separate. Each must keep within the limits defined by the Constitution, and the courts best discharge their duty by executing the will of the law-making power, constitutionally expressed, leaving the results of legislation to be dealt with by the people through their representatives. Statutes must always have a reasonable construction. Sometimes they are to be construed strictly, sometimes literally, in order to carry out the legislative will. But, however construed, the intent of the legislature is to be respected if the particular statute in question is valid, although the courts, looking at the public interests, may conceive the statute to be both unreasonable and impolitic. If the power exists to enact a statute, that ends the matter so far as the courts are concerned. The adjudged cases in which statutes have been held to be void because unreasonable are those in which the means employed by the legislature were not at all germane to the end to which the legislature was competent. The white race deems itself to be the dominant race in this country, and so it is in prestige, in achievements, in education, in wealth, and in power. So, I doubt not, it will continue to be for all time, if it remains true to its great heritage and holds fast to the principles of constitutional liberty. But in view of the Constitution, in the eye of the law, there is in this country no superior, dominant, ruling class of citizens. There is no caste here. Our Constitution is colorblind, and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his surroundings or of his color when his civil rights, as guaranteed by the supreme law of the land, are involved. It is therefore to be regretted that this high tribunal, the final expositor of the fundamental law of the land, has reached the conclusion that it is competent for a state to regulate the enjoyment by citizens of their civil rights solely upon the basis of race. In my opinion, the judgment this day rendered will, in time, prove to be quite as pernicious as the decision made by this tribunal in the Dred Scott case. It was adjudged in that case that the descendants of Africans who were imported into this country and sold as slaves were not included nor intended to be included under the word citizens in the Constitution, and could not claim any of the rights and privileges which that instrument provided for and secured to citizens of the United States. That, at the time of the adoption of the Constitution, they were considered as a subordinate and inferior class of beings, who had been subjugated by the dominant race, and, whether emancipated or not, yet remained subject to their authority, and had no rights or privileges but such as those who held the power and the government might choose to grant them. The recent amendments of the Constitution, it was supposed, had eradicated these principles from our institutions, but it seems that we have yet, in some of the states, a dominant race, a superior class of citizens, which assumes to regulate the enjoyment of civil rights common to all citizens upon the basis of race. The present decision, it may well be apprehended, will not only stimulate aggressions more or less brutal and irritating upon the admitted rights of colored citizens, but will encourage the belief that it is possible, by means of state enactments, to defeat the beneficent purposes which the people of the United States had in view when they adopted the recent amendments of the Constitution, by one of which the blacks of this country were made citizens of the United States and of the states in which they respectfully reside, and whose privileges and immunities as citizens the states are forbidden to abridge. 60 millions of whites are in no danger from the presence here of 8 millions of blacks. The destinies of the two races in this country are indissolubly linked together, and the interests of both require that the common government of all shall not permit the seeds of race hate to be planted under the sanction of law. What can more certainly arouse race hate, what more certainly create and perpetuate a feeling of distrust between these races, than state enactments which, in fact, proceed on the ground that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens? That, as all will admit, is the real meaning of such legislation as was enacted in Louisiana. The sure guarantee of the peace and security of each race is the clear, distinct, unconditional recognition by our governments, national and state, of every right that inheres in civil freedom, and of the equality before the law of all citizens of the United States, without regard to race. State enactments regulating the enjoyment of civil rights upon the basis of race, and cunningly devised to defeat legitimate results of the war under the pretense of recognizing equality of rights, can have no other result than to render permanent peace impossible, and to keep alive a conflict of races, the continuance of which must do harm to all concerned. This question is not met by the suggestion that social equality cannot exist between the white and black races in this country. That argument, if it can be properly regarded as one, is scarcely worthy of consideration, for social equality no more exists between two races when traveling in a passenger coach or a public highway than when members of the same races sit by each other in a streetcar or in the jury box, or stand or sit with each other in a political assembly, or when they use in common the streets of a city or town, or when they are in the same room for the purpose of having their names placed on the registry of voters, or when they approach the ballot box in order to exercise the high privilege of voting. There is a race so different from our own that we do not permit those belonging to it to become citizens of the United States. Persons belonging to it are, with few exceptions, absolutely excluded from our country. I allude to the Chinese race. But by the statute in question, a Chinaman can ride in the same passenger coach with white citizens of the United States, while citizens of the black race in Louisiana, many of whom perhaps risk their lives for the preservation of the Union, who are entitled by law to participate in the political control of the state and nation, who are not excluded by law or by reason of their race from public stations of any kind, or who have all the legal rights that belong to white citizens, are yet declared to be criminals, liable to imprisonment, if they ride in a public coach occupied by citizens of the white race. It is scarcely just to say that a colored citizen should not object to occupying a public coach assigned to his own race. He does not object, nor perhaps would he object to separate coaches for his race, if his rights under the law were recognized. But he does object, and he ought never to cease objecting, that citizens of the white and black races can be adjudged criminals because they sit or claim the right to sit in the same public coach on a public highway. The arbitrary separation of citizens on the basis of race while they are on a public highway is a badge of servitude wholly inconsistent with the civil freedom and the equality before the law established by the Constitution. It cannot be justified upon any legal grounds. If evils will result from the commingling of the two races upon public highways established for the benefit of all, they will be infinitely less than those that will surely come from state legislation regulating the enjoyment of civil rights upon the basis of race. We boast of the freedom enjoyed by our people above all other peoples, but it is difficult to reconcile that boast with a state of the law which practically puts the brand of servitude and degradation upon a large class of our fellow citizens, our equals before the law. The thin disguise of equal accommodations for passengers in railroad coaches will not mislead anyone, nor atone for the wrong this day done. The result of the whole matter is that while this court has frequently adjudged, and at the present term has recognized the doctrine that a state cannot, consistently with the Constitution of the United States, prevent white and black citizens having the required qualifications for jury service from sitting in the same jury box, it is now solemnly held that a state may prohibit white and black citizens from sitting in the same passenger coach on a public highway, or may require that they be separated by a partition when in the same passenger coach. May it not now be reasonably expected that astute men of the dominant race, who affect to be disturbed at the possibility that the integrity of the white race may be corrupted, or that its supremacy will be imperiled by contact on public highways with black people, will endeavor to procure statutes requiring white and black jurors to be separated in the jury box by a partition, and that, upon retiring from the courtroom to consult as to their verdict, such partition, if it be a movable one, shall be taken to their consultation room and set up in such way as to prevent black jurors from coming too close to their brother jurors of the white race. If the partition used in the courtroom happens to be stationary, provision could be made for screens with openings through which jurors of the two races could confer as to their verdict without coming into personal contact with each other. I cannot see but that, according to the principles this day announced, such state legislation, although conceived in hostility to and enacted for the purpose of humiliating citizens of the United States of a particular race, would be held to be consistent with the Constitution. I do not deem it necessary to review the decisions of state courts to which reference was made in argument. Some, and the most important of them, are wholly inapplicable, because rendered prior to the adoption of the last amendments of the Constitution, when colored people had very few rights which the dominant race felt obliged to respect. Others were made at a time when public opinion in many localities was dominated by the institution of slavery, when it would not have been safe to do justice to the black man, and when, so far as the rights of blacks were concerned, race prejudice was practically the supreme law of the land. Those decisions cannot be guides in the era introduced by the recent amendments of the Supreme Law, which established universal civil freedom, gave citizenship to all born or naturalized in the United States and residing here, obliterated the race line from our systems of governments, national and state, and placed our free institutions upon the broad and sure foundation of the equality of all men before the law. I am of opinion that the state of Louisiana is inconsistent with the personal liberty of citizens, white and black, in that state, and hostile to both the spirit and letter of the Constitution of the United States. If laws of like character should be enacted in the several states of the Union, the effect would be in the highest degree mischievous. Slavery as an institution tolerated by law would, it is true, have disappeared from our country, but there would remain a power in the states, by sinister legislation, to interfere with the full enjoyment of the blessings of freedom, to regulate civil rights common to all citizens upon the basis of race, and to place in a condition of legal inferiority a large body of American citizens, now constituting a part of the political community, called the people of the United States, for whom and by whom, through representatives, our government is administered. Such a system is inconsistent with the guarantee given by the Constitution to each state of a republican form of government, and may be stricken down by congressional action, or by the courts in the discharge of their solemn duty to maintain the supreme law of the land. Anything in the Constitution or laws of any state to the contrary notwithstanding. For the reason stated, I am constrained to withhold my assent from the opinion and judgment of the majority. End of Part 2. End of Plessy versus Ferguson. An opinion of the United States Supreme Court. Missouri ex relatione Gaines versus Canada. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Missouri ex relatione Gaines versus Canada. An opinion of the United States Supreme Court. Decided on December 12, 1938. Please note, this is a reading of the opinion of the court only. This reading does not include the syllabus or the separate opinion of Justice McReynolds. For ease of listening, this reading omits legal citations found within the text of the court's opinion and footnotes. Mr. Chief Justice Hughes delivered the opinion of the court. Petitioner Lloyd Gaines, a Negro, was refused admission to the School of Law of the State University of Missouri, asserting that this refusal constituted a denial by the state of the equal protection of the laws in violation of the 14th Amendment of the Federal Constitution. Petitioner brought this action for mandamus to compel the curators of the university to admit him. On final hearing, an alternative writ was quashed and a peremptory writ was denied by the Circuit Court. The Supreme Court of the state affirmed the judgment. We granted certiorari. Petitioner is a citizen of Missouri. In August 1935, he was graduated with the degree of Bachelor of Arts at the Lincoln University, an institution maintained by the state of Missouri for the higher education of Negroes. That university has no law school. Upon the filing of his application for admission to the law school of the University of Missouri, the registrar advised him to communicate with the president of Lincoln University, and the latter directed petitioner's attention to Section 9622 of the Revised Statutes of Missouri, providing as follows. Section 9622. May arrange for attendance at university of any adjacent state tuition fees. Pending the full development of the Lincoln University, the Board of Curators shall have the authority to arrange for the attendance of Negro residents of the state of Missouri at the university of any adjacent state to take any course or to study any subjects provided for at the State University of Missouri, and which are not taught at the Lincoln University, and to pay the reasonable tuition fees for such attendance, provided that, whenever the Board of Curators deem it advisable, they shall have the power to open any necessary school or department. Petitioner was advised to apply to the State Superintendent of Schools for aid under that statute. It was admitted on the trial that petitioner's work and credits at the Lincoln University would qualify him for admission to the School of Law of the University of Missouri if he were found otherwise eligible. He was refused admission upon the ground that it was contrary to the Constitution, laws, and public policy of the state to admit a Negro as a student in the University of Missouri. It appears that there are schools of law in connection with the state universities of 4 adjacent states, Kansas, Nebraska, Iowa, and Illinois, where non-resident Negroes are admitted. The clear and definite conclusions of the state court in construing the pertinent state legislation narrow the issue. The action of the curators, who are representatives of the state in the management of the state university, must be regarded as state action. The state constitution provides that separate free public schools shall be established for the education of children of African descent, and by statute, separate high school facilities are supplied for colored students equal to those provided for white students. While there is no express constitutional provision requiring that the white and Negro races be separated for the purpose of higher education, the state court, on a comprehensive review of the state statutes, held that it was intended to separate the white and Negro races for that purpose also. Referring in particular to Lincoln University, the court deemed it to be clear that the legislature intended to bring the Lincoln University up to the standard of the University of Missouri and give to the whites and Negroes an equal opportunity for higher education, the whites at the University of Missouri and the Negroes at Lincoln University. Further, the court concluded that the provisions of Section 9622, above quoted, to the effect that Negro residents may attend the university of any adjacent state with their tuition paid, pending the full development of Lincoln University, made it evident that the legislature did not intend that Negroes and whites should attend the same university in the state. In that view, it necessarily followed that the curators of the University of Missouri acted in accordance with the policy of the state in denying petitioner admission to its school of law upon the sole ground of his race. In answering petitioner's contention that this discrimination constituted a denial of his constitutional right, the state court has fully recognized the obligation of the state to provide Negroes with advantages for higher education substantially equal to the advantages afforded to white students. The state has sought to fulfill that obligation by furnishing equal facilities in separate schools, a method the validity of which has been sustained by our decisions. Respondents' counsel have appropriately emphasized the special solicitude of the state for the higher education of Negroes as shown in the establishment of Lincoln University, a state institution well conducted on a plane with the University of Missouri so far as the offered courses are concerned. It is said that Missouri is a pioneer in that field and is the only state in the Union which has established a separate university for Negroes on the same basis as the state university for white students. But commendable as is that action, the fact remains that instruction in law for Negroes is not now afforded by the state, either at Lincoln University or elsewhere within the state, and that the state excludes Negroes from the advantages of the law school it has established at the University of Missouri. It is manifest this discrimination, if not relieved by the provisions we shall presently discuss, would constitute a denial of equal protection. That was the conclusion of the Court of Appeals of Maryland in circumstances substantially similar in that aspect. If there appeared that the state of Maryland had undertaken the function of education in the law, but had omitted students of one race from the only adequate provision made for it, and omitted them solely because of their color, that if those students were to be offered equal treatment in the performance of the function, they must at present be admitted to the one school provided. A provision for scholarships to enable Negroes to attend colleges outside the state, mainly for the purpose of professional studies, was found to be inadequate, and the question whether with aid in any amount it is sufficient to send the Negroes outside the state for legal education, the Court of Appeals found it unnecessary to discuss. Accordingly, a writ of mandamus to admit the applicant was issued to the officers, and regents of the University of Maryland as the agents of the state entrusted with the conduct of that institution. The Supreme Court of Missouri in the instant case has distinguished the decision in Maryland upon the grounds, number 1, that in Missouri, but not in Maryland, there is a legislative declaration of a purpose to establish a law school for Negroes at Lincoln University whenever necessary or practical, and number 2, that pending the establishment of such a school, adequate provision has been made for the legal education of Negro students in recognized schools outside of the state. As to the first ground, it appears that the policy of establishing a law school at Lincoln University has not yet ripened into an actual establishment, and it cannot be said that a mere declaration of purpose, still unfulfilled, is enough. The provision for legal education at Lincoln is at present entirely lacking. Respondents' counsel urge that if, on the date when petitioner applied for admission to the University of Missouri, he had instead applied to the curators of Lincoln University, it would have been their duty to establish a law school. That this agency of the state to which he should have applied was specifically charged with the mandatory duty to furnish him what he seeks. We do not read the opinion of the Supreme Court as construing the state statute to impose such a mandatory duty, as the argument seems to assert. The state court quoted the language of Section 9618, set forth in the margin, making it the mandatory duty of the Board of Curators to establish a law school in Lincoln University whenever necessary and practicable in their opinion. This qualification of their duty, explicitly stated in the statute, manifestly leaves it to the judgment of the curators to decide when it will be necessary and practicable to establish a law school, and the state court so construed the statute. Emphasizing the discretion of the curators, the court said, "The statute was enacted in 1921. Since its enactment, no Negro, not even appellant, has applied to Lincoln University for a law education. This fact demonstrates the wisdom of the legislature in leaving it to the judgment of the Board of Curators to determine when it would be necessary or practicable to establish a law school for Negroes at Lincoln University. Pending that time, adequate provision is made for the legal education of Negroes in the university of some adjacent state, as heretofore pointed out." The state court has not held that it would have been the duty of the curators to establish a law school at Lincoln University for the petitioner on his application. Their duty, as the court defined it, would have been either to supply a law school at Lincoln University as provided in Section 9618, or to furnish him the opportunity to obtain his legal training in another state as provided in Section 9622. Thus, the law left the curators free to adopt the latter course. The state court has not ruled or intimated that their failure or refusal to establish a law school for a very few students, still less for one student, would have been an abuse of the discretion with which the curators were entrusted. And apparently, it was because of that discretion and of the postponement which its exercise in accordance with the terms of the statute would entail until necessity and practicability appeared, that the state court considered and upheld as adequate the provision for the legal education of Negroes who were citizens of Missouri in the university of adjacent states. We may put on one side respondents' contention that there were funds available at Lincoln University for the creation of a law department, and the suggestions with respect to the number of instructors who would be needed for that purpose and the cost of supplying them. The president of Lincoln University did not advert to the existence or prospective use of funds for that purpose when he advised petitioner to apply to the state superintendent of schools for aid under Section 9622. At best, the evidence to which argument as to available funds is addressed admits of conflicting inferences, and the decision of the state court did not hinge on any such matter. In the light of its ruling, we must regard the question whether the provision for the legal education in other states of Negroes resident in Missouri is sufficient to satisfy the constitutional requirement of equal protection as the pivot upon which this case turns. The state court stresses the advantages that are afforded by the law schools of the adjacent states, Kansas, Nebraska, Iowa, and Illinois, which admit non-resident Negroes. The court considered that these were schools of high standing, where one desiring to practice law in Missouri can get as sound, comprehensive, valuable legal education as in the University of Missouri, that the system of education in the former is the same as that in the latter, and is designed to give the students a basis for the practice of law in any state where the Anglo-American system of law obtains, that the law school of the University of Missouri does not specialize in Missouri law, and that the course of study and the case books used in the 5 schools are substantially identical. Petitioner insists that for one intending to practice in Missouri, there are special advantages in attending a law school there, both in relation to the opportunities for the particular study of Missouri law and for the observation of the local courts, and also in view of the prestige of the Missouri Law School among the citizens of the state, his prospective clients. Proceeding with its examination of relative advantages, the state court found that the difference in distances to be traveled afforded no substantial ground of complaint, and that there was an adequate appropriation to meet the full tuition fees which petitioner would have to pay. We think that these matters are beside the point. The basic consideration is not as to what sort of opportunities other states provide, or whether they are as good as those in Missouri, but as to what opportunities Missouri itself furnishes to white students and denies to Negroes, solely upon the ground of color. The admissibility of laws separating the races in the enjoyment of privileges afforded by the state rests solely upon the equality of the privileges which the laws give to the separated groups within the state. The question here is not of a duty of the state to supply legal training, or of the quality of the training which it does supply, but of its duty, when it provides such training, to furnish it to the residents of the state upon the basis of an equality of right. By the operation of the laws of Missouri, a privilege has been created for white law students which is denied to Negroes by reason of their race. The white resident is afforded legal education within the state. The Negro resident, having the same qualifications, is refused it there and must go outside the state to obtain it. That is a denial of the equality of legal right to the enjoyment of the privilege which the state has set up, and the provision for the payment of tuition fees in another state does not remove the discrimination. The equal protection of the laws is a pledge of the protection of equal laws. Manifestly, the obligation of the state to give the protection of equal laws can be performed only where its laws operate, that is, within its own jurisdiction. It is there that the equality of legal right must be maintained. That obligation is imposed by the Constitution upon the states severally, as governmental entities, each responsible for its own laws, establishing the rights and duties of persons within its borders. It is an obligation the burden of which cannot be cast by one state upon another, and no state can be excused from performance by what another state may do or fail to do. That separate responsibility of each state within its own sphere is of the essence of statehood maintained under our dual system. It seems to be implicit in respondents' argument that if other states did not provide courses for legal education, it would nevertheless be the constitutional duty of Missouri, when it supplied such courses for white students, to make equivalent provision for Negroes. But that plain duty would exist because it rested upon the state independently of the action of other states. We find it impossible to conclude that what otherwise would be an unconstitutional discrimination with respect to the legal right to the enjoyment of opportunities within the state can be justified by requiring resort to opportunities elsewhere. That resort may mitigate the inconvenience of the discrimination, but cannot serve to validate it. Nor can we regard the fact that there is but a limited demand in Missouri for the legal education of Negroes as excusing the discrimination in favor of whites. We had occasion to consider a cognate question in the case of McCabe versus Atchison, Topeka, and Santa Fe Railway Company. There, the argument was advanced in relation to the provision by a carrier of sleeping cars, dining, and chair cars, that the limited demand by Negroes justified the state in permitting the furnishing of such accommodations exclusively for white persons. We found that argument to be without merit. It made, we said, the constitutional right depend upon the number of persons who may be discriminated against, whereas the essence of the constitutional right is that it is a personal one, whether or not particular facilities shall be provided may doubtless be conditioned upon there being a reasonable demand therefor. But if facilities are provided, substantial equality of treatment of persons traveling under like conditions cannot be refused. It is the individual who is entitled to the equal protection of the laws, and if he is denied by a common carrier, acting in the matter under the authority of a state law, a facility or convenience in the course of his journey, which under substantially the same circumstances is furnished to another traveler, he may properly complain that his constitutional privilege has been invaded. Here, petitioner's right was a personal one. It was as an individual that he was entitled to the equal protection of the laws, and the state was bound to furnish him within its borders facilities for legal education substantially equal to those which the state there offered for persons of the white race, whether or not other Negroes sought the same opportunity. It is urged, however, that the provision for tuition outside the state is a temporary one, that it is intended to operate merely pending the establishment of a law department for Negroes at Lincoln University. While in that sense the discrimination may be termed temporary, it may nevertheless continue for an indefinite period by reason of the discretion given to the curators of Lincoln University, and the alternative of arranging for tuition in other states, as permitted by the state law as construed by the state court, so long as the curators find it unnecessary and impracticable to provide facilities for the legal instruction of Negroes within the state. In that view, we cannot regard the discrimination as excused by what is called its temporary character. We do not find that the decision of the state court turns on any procedural question. The action was for mandamus, but it does not appear that the remedy would have been deemed inappropriate if the asserted federal right had been sustained. In that situation, the remedy by mandamus was found to be a proper one in University of Maryland v. Murray. In the instant case, the state court did note that petitioner had not applied to the management of Lincoln University for legal training, but, as we have said, the state court did not rule that it would have been the duty of the curators to grant such an application, but on the contrary took the view, as we understand it, that the curators were entitled under the state law to refuse such an application and, in its stead, to provide for petitioner's tuition in an adjacent state. That conclusion presented the federal question as to the constitutional adequacy of such a provision, while equal opportunity for legal training within the state was not furnished. And this federal question the state court entertained and passed upon. We must conclude that in so doing the court denied the federal right which petitioner set up, and the question as to the correctness of that decision is before us. We are of the opinion that the ruling was error, and the petitioner was entitled to be admitted to the law school of the state university in the absence of other and proper provision for his legal training within the state. The judgment of the Supreme Court of Missouri is reversed, and the cause is remanded for further proceedings not inconsistent with this opinion. It is so ordered, reversed, and remanded. End of Missouri ex relatione Gaines versus Canada, an opinion of the United States Supreme Court. Lane versus Wilson. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Lane versus Wilson, an opinion of the United States Supreme Court, decided on May 22, 1939. Please note, this is a reading of the opinion of the court only. For ease of listening, this reading omits legal citations found within the text of the court's opinion and footnotes. Mr. Justice Frankfurter delivered the opinion of the court. The case is here on certiorari to review the judgment of the Circuit Court of Appeals for the 10th Circuit, affirming that of the United States District Court for the Eastern District of Oklahoma, entered upon a directed verdict in favor of the defendants. The action was one for $5,000 damages brought under Section 1979 of the revised statutes by a colored citizen claiming discriminatory treatment resulting from electoral legislation of Oklahoma in violation of the 15th Amendment. Certiorari was granted because of the importance of the question and an asserted conflict with the decision in Guin v. United States. The Constitution under which Oklahoma was admitted into the Union regulated the suffrage by Article 3, whereby its qualified electors were to be citizens of the state who are over the age of 21 years, with disqualifications in the case of felons, paupers, and lunatics. Soon after its admission, the suffrage provisions of the Oklahoma Constitution were radically amended by the addition of a literacy test, from which white voters were in effect relieved through the operation of a grandfather clause. The clause was stricken down by this court as violative of the prohibition against discrimination on account of race, color, or previous condition of servitude of the 15th Amendment. This outlawry occurred on June 21, 1915. In the meantime, the Oklahoma general election of 1914 had been based on the offending grandfather clause. After the invalidation of that clause, a special session of the Oklahoma legislature enacted a new scheme for registration as a prerequisite to voting. Section 4 of this statute was obviously directed towards the consequences of the decision in Guin v. United States. Those who had voted in the general election of 1914 automatically remained qualified voters. The new registration requirements affected only others. These had to apply for registration between April 30th, 1916 and May 11th, 1916, if qualified at that time, with an extension to June 30th, 1916, given only to those absent from the county during such period of time or prevented by sickness or unavoidable misfortune from registering within such time. The crux of the present controversy is the validity of this registration scheme, with its dividing line between white citizens who had voted under the grandfather clause immunity prior to Guin v. United States and citizens who were outside it, and the not more than 12 days as the normal period of registration for the theretofore prescribed class. The petitioner, a colored citizen of Oklahoma, who was the plaintiff below and will hereafter be referred to as such, sued 3 county election officials for declining to register him on October 17, 1934. He was qualified for registration in 1916, but did not then get on the registration list. The evidence is in conflict whether he presented himself in that year for registration, and if so, under what circumstances registration was denied him. The fact is that plaintiff did not get on the register in 1916. Under the terms of the statute, he thereby permanently lost the right to register and hence the right to vote. The central claim of plaintiff is that of the unconstitutionality of Section 5654. The defendants joined issue on this claim and further insisted that if there had been illegality in a denial of the plaintiff's right to registration, his proper recourse was to the courts of Oklahoma. The district court took the case from the jury, and its action was affirmed by the Circuit Court of Appeals. It found no proof of discrimination against Negroes in the administration of Section 5654 and denied that the legislation was in conflict with the 15th Amendment. The defendants urged 2 bars to the plaintiff's recovery. Apart from the constitutional validity of Section 5654, they say that on the plaintiff's own assumption of its invalidity, there is no Oklahoma statute under which he could register, and therefore no right to registration has been denied. Secondly, they argue that the state procedure for determining claims of discrimination must be employed before invoking a federal judiciary. These contentions will be considered first, for the disposition of a constitutional question must be reserved to the last. The first objection derives from a misapplication of Giles v. Harris. In that case, a bill in equity was brought by a colored man on behalf of himself and on behalf of more than 5,000 Negroes, citizens of the county of Montgomery, Alabama, similarly situated, which in effect asked the federal court to supervise the voting in that state by officers of the court. What this court called a new and extraordinary situation was found strikingly to reinforce the argument that equity cannot undertake now, any more than it has in the past, to enforce political rights. Apart from this traditional restriction upon the exercise of equitable jurisdiction, there was another difficulty in Giles v. Harris. The plaintiff there was in effect asking for specific performance of his right under Alabama electoral legislation. This presupposed the validity of the legislation under which he was claiming, but the whole theory of his bill was the invalidity of this legislation. Naturally enough, this court took his claim at its face value and found no legislation on the basis of which specific performance could be decreed. This case is very different from Giles v. Harris, the difference having been explicitly foreshadowed by Giles v. Harris itself. In that case, this court declared, "We are not prepared to say that an action at law could not be maintained on the facts alleged in the bill. That is precisely the basis of the present action, brought under the following appropriate legislation of Congress to enforce the 15th Amendment. Every person who, under color of any statute of any state, subjects or causes to be subjected any citizen of the United States within the jurisdiction thereof to the deprivation of any rights, privileges, or immunities secured by the Constitution and laws shall be liable to the party injured in an action at law." The 15th Amendment secures freedom from discrimination on account of race in matters affecting the franchise. Whosoever, under color of any statute, subjects another to such discrimination, thereby deprives him of what the 15th Amendment secures, and under Section 1979 becomes liable to the party injured in an action at law. The theory of the plaintiff's action is that the defendants, acting under color of Section 5654, did discriminate against him because that section inherently operates discriminatorily. If this claim is sustained, his right to sue under revised statute Section 1979 follows. The basis of this action is inequality of treatment, though under color of law, not denial of the right to vote. The other preliminary objection to the maintenance of this action is likewise untenable. To vindicate his present grievance, the plaintiff did not have to pursue whatever remedy may have been open to him in the state courts. Normally, the state legislative process, sometimes exercised through administrative powers conferred on state courts, must be completed before resort to the federal courts can be had. But the state procedure open for one in the plaintiff's situation, Section 5654, has all the indicia of a conventional judicial proceeding and does not confer upon the Oklahoma courts any of the discretionary or initiatory functions that are characteristic of administrative agencies. Barring only exceptional circumstances or explicit statutory requirements, resort to a federal court may be had without first exhausting the judicial remedies of state courts. We therefore cannot avoid passing on the merits of plaintiff's constitutional claims. The reach of the 15th Amendment against contrivances by a state to thwart equality in the enjoyment of the right to vote by citizens of the United States, regardless of race or color, has been amply expounded by prior decisions. The amendment nullifies sophisticated as well as simple-minded modes of discrimination. It hits onerous procedural requirements which effectively handicap exercise of the franchise by the colored race, although the abstract right to vote may remain unrestricted as to race. When in Guin v. United States, the Oklahoma Grandfather Clause was found violative of the 15th Amendment, Oklahoma was confronted with the serious task of devising a new registration system consonant with her own political ideas, but also consistent with the federal Constitution. We are compelled to conclude, however reluctantly, that the legislation of 1916 partakes too much of the infirmity of the Grandfather Clause to be able to survive. Section 5652 of the Oklahoma statutes makes registration a prerequisite to voting. By Section 5654 and 5659, all citizens who were qualified to vote in 1916 but had not voted in 1914 were required to register, save in the exceptional circumstances between April 30th and May 11th, 1916, and in default of such registration were perpetually disenfranchised. Exemption from this onerous provision was enjoyed by all who had registered in 1914. But this registration was held under the statute which was condemned in the Guin case. Unfair discrimination was thus retained by automatically granting voting privileges for life to the white citizens whom the constitutional grandfather clause had sheltered, while subjecting colored citizens to a new burden. The practical effect of the 1916 legislation was to accord to the members of the Negro race who had been discriminated against in the outlawed registration system of 1914 not more than 12 days within which to reassert constitutional rights, which this court found in the Guin case to have been improperly taken from them. We believe that the opportunity thus given Negro voters to free themselves from the effects of discrimination to which they should never have been subjected was too cabined and confined. The restrictions imposed must be judged with reference to those for whom they were designed. It must be remembered that they were dealing with a body of citizens lacking the habits and traditions of political independence and otherwise living in circumstances which do not encourage initiative and enterprise. To be sure, in exceptional cases, a supplemental period was available, but the narrow basis of the supplemental registration, the very brief normal period of relief for the persons and purposes in question, practical difficulties of which the record in this case gives glimpses, inevitable in the administration of such strict registration provisions, leaves no escape from the conclusion that the means chosen as substitutes for the invalidated grandfather clause were themselves invalid under the 15th Amendment. They operated unfairly against the very class on whose behalf the protection of the Constitution was here successfully invoked. The judgment of the Circuit Court of Appeals must, therefore, be reversed, and the cause remanded to the District Court for further proceedings in accordance with this opinion. Reversed and remanded. End of Lane v. Wilson, an opinion of the United States Supreme Court. Skinner v. State of Oklahoma, ex relatione Williamson. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Skinner v. State of Oklahoma, ex relatione Williamson, an opinion of the United States Supreme Court. Decided on June 1st, 1942. Please note, this is a reading of the opinion of the court only. This reading does not include Chief Justice Stone's concurrence or Justice Jackson's concurrence. For ease of listening, this reading omits footnotes and legal citations found within the text of the court's opinion. Mr. Justice Douglas delivered the opinion of the court. This case touches a sensitive and important area of human rights. Oklahoma deprives certain individuals of a right which is basic to the perpetuation of a race, the right to have offspring. Oklahoma has decreed the enforcement of its law against petitioner, overruling his claim that it violated the 14th Amendment. Because that decision raised grave and substantial constitutional questions, we granted the petition for certiorari. The statute involved is Oklahoma's Habitual Criminal Sterilization Act. That act defines a habitual criminal as a person who, having been convicted 2 or more times for crimes amounting to felonies involving moral turpitude either in an Oklahoma court or in a court of any other state, is thereafter convicted of such a felony in Oklahoma and is sentenced to a term of imprisonment in an Oklahoma penal institution. Machinery is provided for the institution by the Attorney General of a proceeding against such a person in the Oklahoma courts for a judgment that such person shall be rendered sexually sterile. Notice, an opportunity to be heard, and the right to a jury trial are provided. The issues triable in such a proceeding are narrow and confined. If the court or jury finds that the defendant is a habitual criminal and that he may be rendered sexually sterile without detriment to his or her general health, then the court shall render judgment to the effect that said defendant be rendered sexually sterile by the operation of a vasectomy in case of a male and of a salpingectomy in case of a female. Only one other provision of the Act is material here, and that is Section 195, which provides that offenses arising out of the violation of the prohibitory laws, revenue acts, embezzlement, or political offenses shall not come or be considered within the terms of this Act. Petitioner was convicted in 1926 of the crime of stealing chickens and was sentenced to the Oklahoma State Reformatory. In 1929, he was convicted of the crime of robbery with firearms and was sentenced to the Reformatory. In 1934, he was convicted again of robbery with firearms and was sentenced to the penitentiary. He was confined there in 1935 when the act was passed. In 1936, the Attorney General instituted proceedings against him. Petitioner, in his answer, challenged the act as unconstitutional by reason of the 14th Amendment. A jury trial was had. The court instructed the jury that the crimes of which petitioner had been convicted were felonies involving moral turpitude, and that the only question for the jury was whether the operation of vasectomy could be performed on petitioner without detriment to his general health. The jury found that it could be. A judgment directing that the operation of vasectomy be performed on petitioner was affirmed by the Supreme Court of Oklahoma by a 5-4 decision. Several objections to the constitutionality of the act have been pressed upon us. It is urged that the act cannot be sustained as an exercise of the police power in view of the state of scientific authorities respecting inheritability of criminal traits. It is argued that due process is lacking because under this act, unlike the act upheld in Buck v. Bell, the defendant is given no opportunity to be heard on the issue as to whether he is the probable potential parent of socially undesirable offspring. It is also suggested that the act is penal in character and that the sterilization provided for is cruel and unusual punishment and violative of the 14th Amendment. We pass those points without intimating an opinion on them, for there is a feature of the act which clearly condemns it. That is, its failure to meet the requirements of the Equal Protection Clause of the 14th Amendment. We do not stop to point out all of the inequalities in this act. A few examples will suffice. In Oklahoma, grand larceny is a felony. Larceny is grand larceny when the property taken exceeds $20 in value. Embezzlement is punishable in the manner prescribed for feloniously stealing property of the value of that embezzled. Hence, he who embezzles property worth more than $20 is guilty of a felony. A clerk who appropriates over $20 from his employer's till and a stranger who steals the same amount are thus both guilty of felonies. If the latter repeats his act and is convicted 3 times, he may be sterilized. But the clerk is not subject to the pains and penalties of the act, no matter how large his embezzlements nor how frequent his convictions. A person who enters a chicken coop and steals chickens commits a felony, and he may be sterilized if he is thrice convicted. If, however, he is a bailee of the property and fraudulently appropriates it, he is an embezzler. Hence, no matter how habitual his proclivities for embezzlement are, and no matter how often his conviction, he may not be sterilized. Thus, the nature of the two crimes is intrinsically the same, and they are punishable in the same manner. Furthermore, the line between them follows close distinctions, distinctions comparable to those highly technical ones which shape the common law as to trespass or taking. There may be larceny by fraud rather than embezzlement, even where the owner of the personal property delivers it to the defendant, if the latter has at that time a fraudulent intention to make use of the possession as a means of converting such property to his own use, and does so convert it. If the fraudulent intent occurs later and the defendant converts the property, he is guilty of embezzlement. Whether a particular act is larceny by fraud or embezzlement thus turns not on the intrinsic quality of the act, but on when the felonious intent arose, a question for the jury under appropriate instructions. It was stated in Buck v. Bell that the claim that state legislation violates the Equal Protection Clause of the 14th Amendment is the usual last resort of constitutional arguments. Under our constitutional system, the states in determining the reach and scope of particular legislation need not provide abstract symmetry. They may mark and set apart the classes and types of problems according to the needs and as dictated or suggested by experience. It was in that connection that Mr. Justice Holmes, speaking for the court in Bain Peanut Company v. Pinson, stated, "We must remember that the machinery of government would not work if it were not allowed a little play in its joints." Only recently we reaffirmed the view that the Equal Protection Clause does not prevent the legislature from recognizing degrees of evil by our ruling in Tigner v. Texas, that the Constitution does not require things which are different in fact or opinion to be treated in law as though they were the same. Thus, if we had here only a question as to a state's classification of crimes, such as embezzlement or larceny, no substantial federal question would be raised. For a state is not constrained in the exercise of its police power to ignore experience which marks a class of offenders or a family of offenses for special treatment, nor is it prevented by the Equal Protection Clause from confining its restrictions to those classes of cases where the need is deemed to be clearest. As stated in Buck v. Bell, the law does all that is needed when it does all that it can, indicates a policy, applies it to all within the lines, and seeks to bring within the lines all similarly situated so far and so fast as its means allow. But the instant legislation runs afoul of the Equal Protection Clause, though we give Oklahoma that large deference which the rule of the foregoing cases requires. We are dealing here with legislation which involves one of the basic civil rights of man. Marriage and procreation are fundamental to the very existence and survival of the race. The power to sterilize, if exercised, may have subtle, far-reaching, and devastating effects. In evil or reckless hands, it can cause races or types which are inimical to the dominant group to wither and disappear. There is no redemption for the individual whom the law touches. Any experiment which the state conducts is to his irreparable injury. He is forever deprived of a basic liberty. We mention these matters not to re-examine the scope of the police power of the states. We advert to them merely in emphasis of our view that strict scrutiny of the classification which a state makes in a sterilization law is essential, lest unwittingly or otherwise invidious discriminations are made against groups or types of individuals in violation of the constitutional guarantee of just and equal laws. The guarantee of equal protection of the laws is a pledge of the protection of equal laws. When the law lays an unequal hand on those who have committed intrinsically the same quality of offense and sterilizes one and not the other, it has made an invidious discrimination as if it had selected a particular race or nationality for oppressive treatment. Sterilization of those who have thrice committed grand larceny, with immunity for those who are embezzlers, is a clear, pointed, unmistakable discrimination. Oklahoma makes no attempt to say that he who commits larceny by trespass or trick or fraud has biologically inheritable traits which he who commits embezzlement lacks. Oklahoma's line between larceny by fraud and embezzlement is determined, as we have noted, with reference to the time when the fraudulent intent to convert the property to the taker's own use arises. We have not the slightest basis for inferring that line has any significance in eugenics, nor that the inheritability of criminal traits follows the neat legal distinctions which the law has marked between those two offenses. In terms of fines and imprisonment, the crimes of larceny and embezzlement rate the same under the Oklahoma Code. Only when it comes to sterilization are the pains and penalties of the law different. Equal protection clause would indeed be a formula of empty words if such conspicuously artificial lines could be drawn. In Buck v. Bell, the Virginia statute was upheld, though it applied only to feeble-minded persons in institutions of the state. But it was pointed out that, so far as the operations enable those who otherwise must be kept confined to be returned to the world, and thus open the asylum to others, the equality aimed at will be more nearly reached. Here there is no such saving feature. Embezzlers are forever free. Those who steal or take in other ways are not. If such a classification were permitted, the technical common law concept of a trespass, based on distinctions which are very largely dependent upon history for explanation, could readily become a rule of human genetics. It is true that the Act has a broad severability clause, but we will not endeavor to determine whether its application would solve the equal protection difficulty. The Supreme Court of Oklahoma sustained the Act without reference to the severability clause. We have, therefore, a situation where the Act, as construed and applied to petitioner, is allowed to perpetuate the discrimination which we have found to be fatal. Whether the severability clause would be so applied as to remove this particular constitutional objection is a question which may be more appropriately left for adjudication by the Oklahoma court. That is re-emphasized here by our uncertainty as to what excision, if any, would be made as a matter of Oklahoma law. It is by no means clear whether, if any excision were made, this particular constitutional difficulty might be solved by enlarging on the one hand or contracting on the other the class of criminals who might be sterilized. Reversed. End of Skinner v. State of Oklahoma, ex relatione Williamson, an opinion of the United States Supreme Court. Smith v. Allwright. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Smith v. Allwright, an opinion of the United States Supreme Court. Decided on April 3, 1944. Please note, this is a reading of the opinion of the court only. This reading does not include Justice Roberts' dissent. For ease of listening, this reading omits footnotes and legal citations found within the text of the court's opinion. Mr. Justice Reed delivered the opinion of the court. This writ of certiorari brings here for review a claim for damages in the sum of $5,000 on the part of petitioner, a Negro citizen of the 48th Precinct of Harris County, Texas, for the refusal of respondents' election and associate election judges, respectively, of that precinct, to give petitioner a ballot or to permit him to cast a ballot in the primary election of July 27, 1940, for the nomination of Democratic candidates for the United States Senate and House of Representatives and governor and other state officers. The refusal is alleged to have been solely because of the race and color of the proposed voter. The actions of respondents are said to violate Sections 31 and 43 of Title 8 of the United States Code in that petitioner was deprived of rights secured by Sections 2 and 4 of Article 1 and the 14th, 15th, and 17th Amendments to the United States Constitution. The suit was filed in the District Court of the United States for the Southern District of Texas, which had jurisdiction under Judicial Code Section 24, subsection 14. The District Court denied the relief sought, and the Circuit Court of Appeals quite properly affirmed its action on the authority of Grovey v. Townsend. We granted the petition for certiorari to resolve a claimed inconsistency between the decision in the Grovey case and that of United States v. Classic. The state of Texas, by its constitution and statutes, provides that every person, if certain other requirements are met which are not here in issue, qualified by residence in the district or county, shall be deemed a qualified elector. Primary elections for United States senators, congressmen, and state officers are provided for by Chapters 12 and 13 of the statutes. Under these chapters, the Democratic Party was required to hold the primary, which was the occasion of the alleged wrong to petitioner. A summary of the state statutes regulating primaries appears in the footnote. These nominations are to be made by the qualified voters of the party. The Democratic Party of Texas is held by the Supreme Court of that state to be a voluntary association, protected by Section 27 of the Bill of Rights, Article 1, Constitution of Texas, from interference by the state except that, in the interest of fair methods and fair expression by their members of their preferences in the selection of their nominees, the state may regulate such elections by proper laws. That court stated further, since the right to organize and maintain a political party is one guaranteed by the Bill of Rights of this state, it necessarily follows that every privilege essential or reasonably appropriate to the exercise of that right is likewise guaranteed, including, of course, the privilege of determining the policies of the party and its membership. Without the privilege of determining the policy of political association and its membership, the right to organize such an association would be a mere mockery. We think these rights, that is, the right to determine the membership of a political party and to determine its policies, of necessity, are to be exercised by the state convention of such party and cannot, under any circumstances, be conferred upon a state or governmental agency. The Democratic Party on May 24, 1932, in a state convention, adopted the following resolution, which has not since been amended, abrogated, annulled, or avoided. Be it resolved that all white citizens of the state of Texas who are qualified to vote under the Constitution and laws of the state shall be eligible to membership in the Democratic Party and, as such, entitled to participate in its deliberations. It was by virtue of this resolution that the respondents refused to permit the petitioner to vote. Texas is free to conduct her elections and limit her electorate as she may deem wise, save only as her action may be affected by the prohibitions of the United States Constitution or in conflict with powers delegated to and exercised by the national government. The 14th Amendment forbids a state from making or enforcing any law which abridges the privileges or immunities of citizens of the United States, and the 15th Amendment specifically interdicts any denial or abridgment by a state of the right of citizens to vote on account of color. Respondents appeared in the District Court and the Circuit Court of Appeals and defended on the ground that the Democratic Party of Texas is a voluntary organization, with members banded together for the purpose of selecting individuals of the group representing the common political beliefs as candidates in the general election. As such a voluntary organization, it was claimed, the Democratic Party is free to select its own membership and limit to whites participation in the party primary. Such action, the answer asserted, does not violate the 14th, 15th, or 17th Amendment, as officers of government cannot be chosen at primaries, and the amendments are applicable only to general elections where governmental officers are actually elected. Primaries, it is said, are political party affairs, handled by party, not governmental officers. No appearance for respondents is made in this court. Arguments presented here by the Attorney General of Texas and the chairman of the State Democratic Executive Committee of Texas, as amici curiae, urged substantially the same grounds as those advanced by the respondents. The right of a Negro to vote in the Texas primary has been considered heretofore by this court. The first case was Nixon v. Herndon. At that time, 1924, the Texas statute afterwards declared, "In no event shall a Negro be eligible to participate in a Democratic Party primary election in the state of Texas." Nixon was refused the right to vote in a Democratic primary and brought a suit for damages against the election officers. It was urged to this court that the denial of the franchise violated his constitutional rights under the 14th and 15th Amendments. Without consideration of the 15th, this court held that the action of Texas in denying the ballot to Negroes by statute was in violation of the Equal Protection Clause of the 14th Amendment and reversed the dismissal of the suit. The legislature of Texas reenacted the article, but gave the State Executive Committee of a party the power to prescribe the qualifications of its members for voting or other participation. This article remains in the statutes. The State Executive Committee of the Democratic Party adopted a resolution that white Democrats, and none other, might participate in the primaries of that party. Nixon was refused again the privilege of voting in a primary and again brought suit for damages by virtue of Section 31, Title 8 of the United States Code. This court again reversed the dismissal of the suit for the reason that the committee action was deemed to be state action and invalid as discriminatory under the 14th Amendment. The test was said to be whether the committee operated as representative of the state in the discharge of the state's authority. The question of the inherent power of a political party in Texas, without restraint by any law to determine its own membership, was left open. In Grovey v. Townsend, this court had before it another suit for damages for the refusal in a primary of a county clerk, a Texas officer with only public functions to perform, to furnish petitioner, a Negro, an absentee ballot. The refusal was solely on the ground of race. This case differed from Nixon v. Condon in that a state convention of the Democratic Party had passed the resolution of May 24, 1932, hereinbefore quoted. It was decided that the determination by the state convention of the membership of the Democratic Party made a significant change from a determination by the executive committee. The former was party action, voluntary in character. The latter, as had been held in the Condon case, was action by authority of the state. The managers of the primary election were therefore declared not to be state officials in such sense that their action was state action. A state convention of a party was said not to be an organ of the state. This court went on to announce that to deny a vote in a primary was a mere refusal of party membership with which the state need have no concern, while for a state to deny a vote in a general election on the ground of race or color violated the Constitution. Consequently, there was found no ground for holding that the county clerk's refusal of a ballot because of racial ineligibility for party membership denied the petitioner any right under the 14th or 15th Amendments. Since Grovey v. Townsend and prior to the present suit, no case from Texas involving primary elections has been before this court. We did decide, however, United States v. Classic. We there held that Section 4 of Article 1 of the Constitution authorized Congress to regulate primary as well as general elections, where the primary is, by law, made an integral part of the election machinery. Consequently, in the Classic case, we upheld the applicability to frauds in a Louisiana primary of Sections 19 and 20 of the Criminal Code. Thereby, corrupt acts of election officers were subjected to congressional sanctions because that body had power to protect rights of federal suffrage secured by the Constitution in primary as in general elections. This decision depended, too, on the determination that under the Louisiana statutes, the primary was a part of the procedure for choice of federal officials. By this decision, the doubt as to whether or not such primaries were a part of elections subject to federal control, which had remained unanswered since Newberry v. United States, was erased. The Nixon cases were decided under the Equal Protection Clause of the 14th Amendment without a determination of the status of the primary as a part of the electoral process. The exclusion of Negroes from the primaries by action of the state was held invalid under that amendment. The fusing by the classic case of the primary and general elections into a single instrumentality for choice of officers has a definite bearing on the permissibility under the Constitution of excluding Negroes from primaries. This is not to say that the classic case cuts directly into the rationale of Grovey v. Townsend. This latter case was not mentioned in the opinion. Classic bears upon Grovey v. Townsend not because exclusion of Negroes from primaries is any more or less state action by reason of the unitary character of the electoral process, but because the recognition of the place of the primary in the electoral scheme makes clear that state delegation to a party of the power to fix the qualifications of primary elections is delegation of a state function that may make the party's action the action of the state. When Grovey v. Townsend was written, the court looked upon the denial of a vote in a primary as a mere refusal by a party of party membership. As the Louisiana statutes for holding primaries are similar to those of Texas, our ruling in Classic as to the unitary character of the electoral process calls for a re-examination as to whether or not the exclusion of Negroes from a Texas party primary was state action. The statutes of Texas relating to primaries and the resolution of the Democratic Party of Texas extending the privileges of membership to white citizens only are the same in substance and effect today as they were when Grovey v. Townsend was decided by a unanimous court. The question as to whether the exclusionary action of the party was the action of the state persists as the determinative factor. In again entering upon consideration of the inference to be drawn as to state action from a substantially similar factual situation, it should be noted that Grovey v. Townsend upheld exclusion of Negroes from primaries through the denial of party membership by a party convention. A few years before, this court refused approval of exclusion by the state executive committee of the party. A different result was reached on the theory that the committee action was state authorized and the convention action was unfettered by statutory control. Such a variation in the result from so slight a change in form influences us to consider anew the legal validity of the distinction which has resulted in barring Negroes from participating in the nominations of candidates of the Democratic Party in Texas. Other precedents of this court forbid the abridgment of the right to vote. It may now be taken as a postulate that the right to vote in such a primary for the nomination of candidates without discrimination by the state, like the right to vote in a general election, is a right secured by the Constitution. By the terms of the 15th Amendment, that right may not be abridged by any state on account of race. Under our Constitution, the great privilege of the ballot may not be denied a man by the state because of his color. We are thus brought to an examination of the qualifications for Democratic primary electors in Texas to determine whether state action or private action has excluded Negroes from participation. Despite Texas's decision that the exclusion is produced by private or party action, federal courts must for themselves appraise the facts leading to that conclusion. It is only by the performance of this obligation that a final and uniform interpretation can be given to the Constitution, the supreme law of the land. Texas requires electors in a primary to pay a poll tax. Every person who does so pay, and who has the qualifications of age and residence, is an acceptable voter for the primary, as appears above in the summary of the statutory provisions set out in Note 6. Texas requires by the law the election of the county officers of a party. These compose the County Executive Committee. The county chairmen so selected are members of the District Executive Committee and choose the chairman for the district. Precinct primary election officers are named by the County Executive Committee. Statutes provide for the election by the voters of precinct delegates to the county convention of a party and the selection of delegates to the district and state conventions by the county convention. The state convention selects the state executive committee, No convention may place in platform or resolution any demand for specific legislation without endorsement of such legislation by the voters in a primary. Texas thus directs the selection of all party officers. Primary elections are conducted by the party under state statutory authority. The County Executive Committee selects precinct election officials, and the county, district, or state executive committees, respectively, canvass the returns. These party committees, or the state convention, certify the party's candidates to the appropriate officers for inclusion on the official ballot for the general election. No name which has not been so certified may appear upon the ballot for the general election as a candidate of a political party. No other name may be printed on the ballot which has not been placed in nomination by qualified voters who must take oath that they did not participate in a primary for the selection of a candidate for the office for which the nomination is made. The state courts are given exclusive original jurisdiction of contested elections and of mandamus proceedings to compel party officers to perform their statutory duties. We think that the statutory system for the selection of party nominees for inclusion on the general election ballot makes the party which is required to follow these legislative directions an agency of the state insofar as it determines the participants in a primary election. The party takes its character as a state agency from the duties imposed upon it by state statutes. The duties do not become matters of private law because they are performed by a political party. The plan of the Texas primary follows substantially that of Louisiana, with the exception that in Louisiana, the state pays the cost of the primary, while Texas assesses the cost against candidates. In numerous instances, the Texas statutes fix or limit the fee to be charged. Whether paid directly by the state or through state requirements, it is state action which compels. When primaries become a part of the machinery for choosing officials, state and national as they have here, the same tests to determine the character of discrimination or abridgment should be applied to the primary as are applied to the general election. If the state requires a certain electoral procedure, prescribes a general election ballot made up of party nominees so chosen, and limits the choice of the electorate in general elections for state offices, practically speaking, to those whose names appear on such a ballot, it endorses, adopts, and enforces the discrimination against Negroes practiced by a party entrusted by Texas law with the determination of the qualifications of participants in the primary. This is state action within the meaning of the 15th Amendment. The United States is a constitutional democracy. Its organic law grants to all citizens a right to participate in the choice of elected officials without restriction by any state because of race. This grant to the people of the opportunity for choice is not to be nullified by a state through casting its electoral process in a form which permits a private organization to practice racial discrimination in the election. Constitutional rights would be of little value if they could be thus indirectly denied. The privilege of membership in a party may be, as this court said in Grovey v. Townsend, no concern of a state. But when, as here, that privilege is also the essential qualification for voting in a primary to select nominees for a general election, the state makes the action of the party the action of the state. In reaching this conclusion, we are not unmindful of the desirability of continuity of decision in constitutional questions. However, when convinced of former error, this court has never felt constrained to follow precedent. In constitutional questions where correction depends upon amendment and not upon legislative action, this court throughout its history has freely exercised its power to re-examine the basis of its constitutional decisions. This has long been accepted practice, and this practice has continued to this day. This is particularly true when the decision believed erroneous is the application of a constitutional principle rather than an interpretation of the Constitution to extract the principle itself. Here we are applying, contrary to the recent decision in Grovey v. Townsend, the well-established principle of the 15th Amendment, forbidding the abridgment by a state of a citizen's right to vote. Grovey v. Townsend is overruled. Judgment reversed. End of Smith v. Allwright, an opinion of the United States Supreme Court. Part 1 of Korematsu v. United States. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Korematsu v. United States. An opinion of the United States Supreme Court, Part 1. Decided on December 18, 1944. Please note, Part 1 is a reading of the opinion of the court only. This reading does not include a reading of Justice Frankfurter's concurrence, Justice Roberts' dissent, Justice Murphy's dissent, or Justice Jackson's dissent. For ease of listening, this reading omits footnotes and legal citations found within the text of the court's opinion. Mr. Justice Black delivered the opinion of the court. The petitioner, an American citizen of Japanese descent, was convicted in a federal district court for remaining in San Leandro, California, a military area, contrary to Civilian Exclusion Order No. 34 of the Commanding General of the Western Command, United States Army, which directed that after May 9, 1942, all persons of Japanese ancestry should be excluded from that area. No question was raised as to petitioner's loyalty to the United States. The Circuit Court of Appeals affirmed, and the importance of the constitutional question involved caused us to grant certiorari. It should be noted, to begin with, that all legal restrictions which curtail the civil rights of a single racial group are immediately suspect. That is not to say that all such restrictions are unconstitutional. It is to say that courts must subject them to the most rigid scrutiny. Pressing public necessity may sometimes justify the existence of such restrictions. Racial antagonism never can. In the instant case, prosecution of the petitioner was begun by information charging violation of an act of Congress of March 21, 1942, which provides that whoever shall enter, remain in, leave, or commit any act in any military area or military zone prescribed under the authority of an executive order of the President, by the Secretary of War, or by any military commander designated by the Secretary of War, contrary to the restrictions applicable to any such area or zone, or contrary to the order of the Secretary of War, or any such military commander, shall, if it appears that he knew or should have known of the existence and extent of the restrictions or order, and that his act was in violation thereof, be guilty of a misdemeanor, and upon conviction shall be liable to a fine of not to exceed $5,000, or to imprisonment for not more than 1 year, or both, for each offense. Exclusion Order No. 34, which the petitioner knowingly and admittedly violated, was one of a number of military orders and proclamations, all of which were substantially based upon Executive Order No. 9066. That order, issued after we were at war with Japan, declared that the successful prosecution of the war requires every possible protection against espionage and against sabotage to national defense material, national defense premises, and national defense utilities. One of the series of orders and proclamations, a curfew order, which, like the exclusion order here, was promulgated pursuant to Executive Order 9066, subjected all persons of Japanese ancestry in prescribed West Coast military areas to remain in their residences from 8 p.m. to 6 a.m. As is the case with the exclusion order here, that prior curfew order was designed as a protection against espionage and against sabotage. In Kiyoshi Hirabayashi v. United States, we sustained a conviction obtained for violation of the curfew order. The Hirabayashi conviction and this one thus rest on the same 1942 Congressional Act and the same basic executive and military orders, all of which orders were aimed at the twin dangers of espionage and sabotage. The 1942 Act was attacked in the Hirabayashi case as an unconstitutional delegation of power. It was contended that the curfew order and other orders on which it rested were beyond the war powers of the Congress, the military authorities, and of the President as Commander-in-Chief of the Army. And finally, that to apply the curfew order against none but citizens of Japanese ancestry amounted to a constitutionally prohibited discrimination solely on account of race. To these questions, we gave the serious consideration which their importance justified. We upheld the curfew order as an exercise of the power of the government to take steps necessary to prevent espionage and sabotage in an area threatened by Japanese attack. In the light of the principles we announced in the Hirabayashi case, we are unable to conclude that it was beyond the war power of Congress and the executive to exclude those of Japanese ancestry from the West Coast war area at the time they did. True, exclusion from the area in which one's home is located is a far greater deprivation than constant confinement to the home from 8 p.m. to 6 a.m. Nothing short of apprehension by the proper military authorities of the gravest imminent danger to the public safety can constitutionally justify either. But exclusion from a threatened area, no less than curfew, has a definite and close relationship to the prevention of espionage and sabotage. The military authorities, charged with the primary responsibility of defending our shores, concluded that curfew provided inadequate protection and ordered exclusion. They did so, as pointed out in our Hirabayashi opinion, in accordance with congressional authority to the military to say who should and who should not remain in the threatened areas. In this case, the petitioner challenges the assumptions upon which we rested our conclusions in the Hirabayashi case. He also urges that by May 1942, when Order Number 34 was promulgated, all danger of Japanese invasion of the West Coast had disappeared. After careful consideration of these contentions, we are compelled to reject them. Here, as in the Hirabayashi case, we cannot reject as unfounded the judgment of the military authorities and of Congress that there were disloyal members of that population whose number and strength could not be precisely and quickly ascertained. We cannot say that the war-making branches of the government did not have ground for believing that in a critical hour such persons could not readily be isolated and separately dealt with, and constituted a menace to the national defense and safety, which demanded that prompt and adequate measures be taken to guard against it. Like curfew, exclusion of those of Japanese origin was deemed necessary because of the presence of an unascertained number of disloyal members of the group, most of whom we have no doubt were loyal to this country. It was because we could not reject the finding of the military authorities that it was impossible to bring about an immediate segregation of the disloyal from the loyal that we sustained the validity of the curfew order as applying to the whole group. In the instant case, temporary exclusion of the entire group was rested by the military on the same ground. The judgment that exclusion of the whole group was for the same reason, a military imperative, answers the contention that the exclusion was in the nature of group punishment based on antagonism to those of Japanese origin. That there were members of the group who retained loyalties to Japan has been confirmed by investigations made subsequent to the exclusion. Approximately 5,000 American citizens of Japanese ancestry refused to swear unqualified allegiance to the United States and to renounce allegiance to the Japanese emperor, and several thousand evacuees requested repatriation to Japan. We uphold the exclusion order as of the time it was made and when the petitioner violated it. In doing so, we are not unmindful of the hardships imposed by it upon a large group of American citizens. But hardships are part of war, and war is an aggregation of hardships. All citizens alike, both in and out of uniform, feel the impact of war in greater or lesser measure. Citizenship has its responsibilities as well as its privileges, and in time of war, the burden is always heavier. Compulsory exclusion of large groups of citizens from their homes, except under circumstances of direst emergency and peril, is inconsistent with our basic governmental institutions. But when under conditions of modern warfare, our shores are threatened by hostile forces, the power to protect must be commensurate with the threatened danger. It is argued that on May 30th, 1942, the date the petitioner was charged with remaining in the prohibited area, there were conflicting orders outstanding, forbidding him both to leave the area and to remain there. Of course, a person cannot be convicted for doing the very thing which it is a crime to fail to do. But the outstanding orders here contained no such contradictory commands. There was an order issued March 27, 1942, which prohibited petitioner and others of Japanese ancestry from leaving the area, but its effect was specifically limited in time until and to the extent that a future proclamation or order should so permit or direct. That future order, the one for violation of which petitioner was convicted, was issued May 3, 1942, and it did direct exclusion from the area of all persons of Japanese ancestry before 12 o'clock noon, May 9th. Furthermore, it contained a warning that all such persons found in the prohibited area would be liable to punishment under the March 21, 1942 Act of Congress. Consequently, the only order in effect touching the petitioner's being in the area on May 30, 1942, the date specified in the information against him, was the May 3rd order, which prohibited his remaining there, and it was that same order which he stipulated in his trial that he had violated, knowing of its existence. There is therefore no basis for the argument that on May 30, 1942, he was subject to punishment under the March 27th and May 3rd orders, whether he remained in or left the area. It does appear, however, that on May 9th, the effective date of the exclusion order, the military authorities had already determined that the evacuation should be effected by assembling together and placing under guard all those of Japanese ancestry at central points designated as assembly centers in order to ensure the orderly evacuation and resettlement of Japanese voluntarily migrating from Military Area Number 1 to restrict and regulate such migration. And on May 19, 1942, 11 days before the time petitioner was charged with unlawfully remaining in the area, Civilian Restrictive Order Number 1 provided for detention of those of Japanese ancestry in assembly or relocation centers. It is now argued that the validity of the exclusion order cannot be considered apart from the orders requiring him, after departure from the area, to report and to remain in an assembly or relocation center. The contention is that we must treat these separate orders as one and inseparable, that for this reason, if detention in the assembly or relocation center would have illegally deprived the petitioner of his liberty, the exclusion order and his conviction under it cannot stand. We are thus being asked to pass at this time upon the whole subsequent detention program in both assembly and relocation centers, although the only issues framed at the trial related to petitioners remaining in the prohibited area in violation of the exclusion order. Had petitioner here left the prohibited area and gone to an assembly center, we cannot say either as a matter of fact or law that his presence in that center would have resulted in his detention in a relocation center. Some who did report to the assembly center were not sent to relocation centers, but were released upon condition that they remain outside the prohibited zone until the military orders were modified or lifted. This illustrates that they pose different problems and may be governed by different principles. The lawfulness of one does not necessarily determine the lawfulness of the others. This is made clear when we analyze the requirements of the separate provisions of the separate orders. These separate requirements were that those of Japanese ancestry, number 1, depart from the area. Number 2, report to and temporarily remain in an assembly center. Number 3, go under military control to a relocation center, there to remain for an indeterminate period until released conditionally or unconditionally by the military authorities. Each of these requirements, it will be noted, impose distinct duties in connection with the separate steps in a complete evacuation program. Had Congress directly incorporated into one act the language of these separate orders and provided sanctions for their violations, disobedience of any one would have constituted a separate offense. There is no reason why violations of these orders, insofar as they were promulgated pursuant to congressional enactment, should not be treated as separate offenses. The Endo cases graphically illustrates the difference between the validity of an order to exclude and the validity of a detention order after exclusion has been effected. Since the petitioner has not been convicted of failing to report or to remain in an assembly or relocation center, we cannot in this case determine the validity of those separate provisions of the order. It is sufficient here for us to pass upon the order which petitioner violated. To do more would be to go beyond the issues raised and to decide momentous questions not contained within the framework of the pleadings or the evidence in this case. It will be time enough to decide the serious constitutional issues which petitioner seeks to raise when an assembly or relocation order is applied or is certain to be applied to him, and we have its terms before us. Some of the members of the court are of the view that evacuation and detention in an assembly center were inseparable. After May 3, 1942, the date of exclusion order number 34, Korematsu was under compulsion to leave the area not as he would choose, but via an assembly center. The assembly center was conceived as a part of the machinery for group evacuation. The power to exclude includes the power to do it by force if necessary, and any forcible measure must necessarily entail some degree of detention or restraint, whatever method of removal is selected. But whichever view is taken, it results in holding that the order under which petitioner was convicted was valid. It is said that we are dealing here with the case of imprisonment of a citizen in a concentration camp solely because of his ancestry, without evidence or inquiry concerning his loyalty and good disposition toward the United States. Our task would be simple, our duty clear, were this a case involving the imprisonment of a loyal citizen in a concentration camp because of racial prejudice, regardless of the true nature of the assembly and relocation centers, and we deem it unjustifiable to call them concentration camps, with all the ugly connotations that term implies. We are dealing specifically with nothing but an exclusion order. To cast this case into outlines of racial prejudice without reference to the real military dangers which were presented merely confuses the issue. Korematsu was not excluded from the military area because of hostility to him or his race. He was excluded because we are at war with the Japanese Empire, because the properly constituted military authorities feared an invasion of our West Coast and felt constrained to take proper security measures because they decided that the military urgency of the situation demanded that all citizens of Japanese ancestry be segregated from the West Coast temporarily, and finally, because Congress, reposing its confidence in this time of war in our military leaders, as inevitably it must, determined that they should have the power to do just this. There was evidence of disloyalty on the part of some. The military authorities considered that the need for action was great and time was short. We cannot, by availing ourselves of the calm perspective of hindsight, now say that at that time these actions were unjustified. Affirmed. End of Part 1. Part 2 of Korematsu v. United States. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Korematsu v. United States. An opinion of the United States Supreme Court, Part 2. Decided on December 18, 1944. Please note, Part 2 is a reading of Mr. Justice Roberts' dissent. This reading does not include a reading of the court's opinion, Justice Frankfurter's concurrence, Justice Murphy's dissent, or Justice Jackson's dissent. For ease of listening, this reading omits footnotes and legal citations found within the text of the court's opinion. I dissent because I think the indisputable facts exhibit a clear violation of constitutional rights. This is not a case of keeping people off the streets at night, as was Kiyoshi Hirabayashi v. United States, nor a case of temporary exclusion of a citizen from an area for his own safety or that of the community, nor a case of offering him an opportunity to go temporarily out of an area where his presence might cause danger to himself or to his fellows. On the contrary, it is the case of convicting a citizen as a punishment for not submitting to imprisonment in a concentration camp based on his ancestry and solely because of his ancestry, without evidence or inquiry concerning his loyalty and good disposition towards the United States. If this be a correct statement of the facts disclosed by this record, and facts of which we take judicial notice, I need hardly labor the conclusion that constitutional rights have been violated. The government's argument and the opinion of the court, in my judgment, erroneously divide that which is single and indivisible, and thus make the case appear as if the petitioner violated a military order sanctioned by act of Congress, which excluded him from his home by refusing voluntarily to leave, and so knowingly and intentionally defying the order and the act of Congress. The petitioner, a resident of San Leandro, Alameda County, California, is a native of the United States of Japanese ancestry who, according to the uncontradicted evidence, is a loyal citizen of the nation. A chronological recitation of events will make it plain that the petitioner's supposed offense did not, in truth, consist in his refusal voluntarily to leave the area which included his home in obedience to the order excluding him therefrom. Critical attention must be given to the dates and sequence of events. December 8, 1941, the United States declared war on Japan. February 19, 1942, the President issued Executive Order Number 9066, which, after stating the reason for issuing the order as protection against espionage and against sabotage to national defense material, national defense premises, and national defense utilities, provided that certain military commanders might, in their discretion, prescribe military areas and define their extent from which any or all persons may be excluded, and with respect to which the right of any person to enter, remain in, or leave shall be subject to whatever restrictions the military commander may impose in his discretion. February 20th, 1942, Lieutenant General DeWitt was designated military commander of the Western Defense Command, embracing the westernmost states of the Union, about 1/4 of the total area of the nation. March 2nd, 1942. General DeWitt promulgated Public Proclamation No. 1, which recites that the entire Pacific coast is particularly subject to attack, to attempted invasion, and, in connection therewith, is subject to espionage and acts of sabotage. It states that, as a matter of military necessity, certain military areas and zones are established known as Military Areas Numbers 1 and 2. It adds that such persons or classes of persons, as the situation may require, will, by subsequent orders, be excluded from all of Military Area Number 1 and from certain zones in Military Area Number 2. Subsequent proclamations were made which, together with Proclamation Number 1, included in such areas and zones all of California, Washington, Oregon, Idaho, Montana, Nevada, and Utah, and the southern portion of Arizona. The orders required that if any person of Japanese, German, or Italian ancestry resided in Area Number 1 desired to change his habitual residence, he must execute and deliver to the authorities a change of residence notice. San Leandro, the city of petitioner's residence, lies in Military Area Number 1. On March 2, 1942, the petitioner, therefore, had noticed that, by executive order, the President, to prevent espionage and sabotage, had authorized the military to exclude him from certain areas and to prevent his entering or leaving certain areas without permission. He was on notice that his home city had been included by military order in Area Number 1, and he was on notice further that, at some time in the future, the military commander would make an order for the exclusion of certain persons, not described or classified, from various zones, including that in which he lived. March 21, 1942, Congress enacted that anyone who knowingly shall enter, remain in, leave, or commit any act in any military area or military zone prescribed by any military commander, contrary to the restrictions applicable to any such area or zone, or contrary to the order of any such military commander, shall be guilty of a misdemeanor. This is the act under which the petitioner was charged. March 24, 1942, General DeWitt instituted the curfew for certain areas within his command by an order the validity of which was sustained in Hirabayashi v. United States. March 24, 1942, General DeWitt began to issue a series of exclusion orders relating to specified areas. March 27, 1942, by Proclamation Number 4, the General recited that it is necessary, in order to provide for the welfare and to ensure the orderly evacuation and resettlement of Japanese voluntarily migrating from Military Area Number 1, to restrict and regulate such migration, and ordered that, as of March 29, 1942, all alien Japanese and persons of Japanese ancestry who are within the limits of Military Area Number 1 be and they are hereby prohibited from leaving that area for any purpose until, and to the extent that, a future proclamation or order of this headquarters shall so permit or direct. No order had been made excluding the petitioner from the area in which he lived. By Proclamation Number 4, he was, after March 29, 1942, confined to the limits of Area Number 1. If the Executive Order Number 9066 and the Act of Congress meant what they said, to leave that area in the face of Proclamation Number 4 would be to commit a misdemeanor. May 3, 1942, General DeWitt issued Civilian Exclusion Order Number 34, providing that after 12 o'clock, May 8, 1942, all persons of Japanese ancestry, both alien and non-alien, were to be excluded from a described portion of Military Area Number 1, which included the county of Alameda, California. The order required a responsible member of each family and each individual living alone to report, at a time set, at a civil control station for instructions to go to an assembly center, and added that any person failing to comply with the provisions of the order who was found in the described area after the date set would be liable to prosecution under the Act of March 21, 1942. It is important to note that the order, by its express terms, had no application to persons within the bounds of an established assembly center pursuant to instructions from this headquarters. The obvious purpose of the orders made, taken together, was to drive all citizens of Japanese ancestry into assembly centers within the zones of their residence under pain of criminal prosecution. The predicament in which the petitioner thus found himself was this: he was forbidden by military order to leave the zone in which he lived. He was forbidden by military order after a date fixed to be found within that zone unless he were in an assembly center located in that zone. General DeWitt's report to the Secretary of War concerning the program of evacuation and relocation of Japanese makes it entirely clear, if it were necessary to refer to that document, and in the light of the above recitation, I think it is not, that an assembly center was a euphemism for a prison. No person within such a center was permitted to leave except by military order. In the dilemma that he dare not remain in his home or voluntarily leave the area without incurring criminal penalties, and that the only way he could avoid punishment was to go to an assembly center and submit himself to military imprisonment, the petitioner did nothing. June 12, 1942, an information was filed in the District Court for Northern California charging a violation of the Act of March 21, 1942, in that petitioner had knowingly remained within the area covered by Exclusion Order Number 34. A demurrer to the information having been overruled, the petitioner was tried under a plea of not guilty and convicted. Sentence was suspended and he was placed on probation for 5 years. We know, however, in the light of the foregoing recitation, that he was at once taken into military custody and lodged in an assembly center. We further know that on March 18, 1942, the President had promulgated Executive Order Number 9102, establishing the War Relocation Authority, under which so-called relocation centers, a euphemism for concentration camps, were established pursuant to a cooperation between the military authorities of the Western Defense Command and the Relocation Authority, and that the petitioner has been confined either in an assembly center within the zone in which he had lived, or has been removed to a relocation center where, as the facts disclosed in Ex parte Mitsuye Endo demonstrate, he was illegally held in custody. The government has argued this case as if the only order outstanding at the time the petitioner was arrested and informed against was Exclusion Order Number 34, ordering him to leave the area in which he resided, which was the basis of the information against him. That argument has evidently been effective. The opinion refers to the Hirabayashi case to show that this court has sustained the validity of a curfew order in an emergency. The argument then is that exclusion from a given area of danger, while somewhat more sweeping than a curfew regulation, is of the same nature, a temporary expedient made necessary by a sudden emergency. This, I think, is a substitution of a hypothetical case. I might agree with the court's disposition of the hypothetical case. The liberty of every American citizen freely to come and to go must frequently, in the face of sudden danger, be temporarily limited or suspended. The civil authorities must often resort to the expedient of excluding citizens temporarily from a locality. The drawing of fire lines in the case of a conflagration, the removal of persons from the area where a pestilence has broken out, are familiar examples. If the exclusion worked by Exclusion Order Number 34 were of that nature, the Hirabayashi case would be authority for sustaining it. But the facts above recited, and those set forth in Ex parte Mitsuye Endo, show that the exclusion was but a part of an overall plan for forcible detention. This case cannot, therefore, be decided on any such narrow ground as the possible validity of a temporary exclusion order under which the residents of an area are given an opportunity to leave and go elsewhere in their native land outside the boundaries of a military area. To make the case turn on any such assumption is to shut our eyes to reality. As I have said above, the petitioner, prior to his arrest, was faced with two diametrically contradictory orders given sanction by the Act of Congress of March 21, 1942. The earlier of those orders made him a criminal if he left the zone in which he resided. The later made him a criminal if he did not leave. I had supposed that if a citizen was constrained by two laws, or two orders having the force of law, and obedience to one would violate the other, to punish him for violation of either would deny him due process of law. And I had supposed that under these circumstances a conviction for violating one of the orders could not stand. We cannot shut our eyes to the fact that had the petitioner attempted to violate Proclamation No. 4 and leave the military area in which he lived, he would have been arrested and tried and convicted for violation of Proclamation No. 4. The two conflicting orders, one which commanded him to stay and the other which commanded him to go, were nothing but a cleverly devised trap to accomplish the real purpose of the military authority, which was to lock him up in a concentration camp. The only course by which the petitioner could avoid arrest and prosecution was to go to that camp, according to instructions to be given him when he reported at a civil control center. We know that is the fact. Why should we set up a figmentary and artificial situation instead of addressing ourselves to the actualities of the case? These stark realities are met by the suggestion that it is lawful to compel an American citizen to submit to illegal imprisonment on the assumption that he might, after going to the assembly center, apply for his discharge by suing out a writ of habeas corpus, as was done in the Endo case. The answer, of course, is that where he was subject to two conflicting laws, he was not bound, in order to escape violation of one of the other, to surrender his liberty for any period. Nor will it do to say that the detention was a necessary part of the process of evacuation, and so we are here concerned only with the validity of the latter. Again, it is a new doctrine of constitutional law that one indicted for disobedience to an unconstitutional statute may not defend on the ground of the invalidity of the statute, but must obey it, though he knows it is no law, and after he has suffered the disgrace of conviction and lost his liberty by sentence, then and not before, seek from within prison walls to test the validity of the law. Moreover, it is beside the point to rest decision in part on the fact that the petitioner, for his own reasons, wished to remain in his home. If, as is the fact, he was constrained so to do, it is indeed a narrow application of constitutional rights to ignore the order which constrained him, in order to sustain his conviction for violation of another contradictory order. I would reverse the judgment of conviction. End of Part 2. Part 3 of Korematsu v. United States. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Korematsu v. United States. An opinion of the United States Supreme Court, Part 3. Decided on December 18, 1944. Please note, Part 3 is a reading of Mr. Justice Murphy's dissent. This reading does not include a reading of the court's opinion, Justice Frankfurter's concurrence, Justice Roberts' dissent, or Justice Jackson's dissent. For ease of listening, this reading omits footnotes, and legal citations found within the text of the court's opinion. This exclusion of all persons of Japanese ancestry, both alien and non-alien, from the Pacific Coast area on a plea of military necessity in the absence of martial law ought not to be approved. Such exclusion goes over the very brink of constitutional power and falls into the ugly abyss of racism. In dealing with matters relating to the prosecution and progress of a war, we must accord great respect and consideration to the judgments of the military authorities who are on the scene and who have full knowledge of the military facts. The scope of their discretion must, as a matter of necessity and common sense, be wide, and their judgments ought not to be overruled lightly by those whose training and duties ill-equip them to deal intelligently with matters so vital to the physical security of the nation. At the same time, however, it is essential that there be definite limits to military discretion, especially where martial law has not been declared. Individuals must not be left impoverished of their constitutional rights on a plea of military necessity that has neither substance nor support. Thus, like other claims conflicting with the asserted constitutional rights of the individual, the military claim must subject itself to the judicial process of having its reasonableness determined and its conflicts with other interests reconciled. What are the allowable limits of military discretion, and whether or not they have been overstepped in a particular case, are judicial questions. The judicial test of whether the government, on a plea of military necessity, can validly deprive an individual of any of his constitutional rights is whether the deprivation is reasonably related to a public danger that is so immediate, imminent, and impending as not to admit of delay and not to permit the intervention of ordinary constitutional processes to alleviate the danger. Civilian Exclusion Order No. 34, banishing from a prescribed area of the Pacific Coast all persons of Japanese ancestry, both alien and non-alien, clearly does not meet that test. Being an obvious racial discrimination, the order deprives all those within its scope of the equal protection of the laws as guaranteed by the Fifth Amendment. It further deprives these individuals of their constitutional rights to live and work where they will, to establish a home where they choose, and to move about freely. In excommunicating them without benefit of hearings, this order also deprives them of all of their constitutional rights to procedural due process. Yet no reasonable relation to an immediate, imminent, and impending public danger is evident to support this racial restriction, which is one of the most sweeping and complete deprivations of constitutional rights in the history of this nation in the absence of martial law. It must be conceded that the military and naval situation in the spring of 1942 was such as to generate a very real fear of invasion of the Pacific Coast, accompanied by fears of sabotage and espionage in that area. The military command was therefore justified in adopting all reasonable means necessary to combat these dangers. In adjudging the military action taken in light of the then apparent dangers, we must not erect too high or too meticulous standards. It is necessary only that the action have some reasonable relation to the removal of the dangers of invasion, sabotage, and espionage. But the exclusion, either temporarily or permanently, of all persons with Japanese blood in their veins has no such reasonable relation. And that relation is lacking because the exclusion order necessarily must rely for its reasonableness upon the assumption that all persons of Japanese ancestry may have a dangerous tendency to commit sabotage and espionage and to aid our Japanese enemy in other ways. It is difficult to believe that reason, logic, or experience could be marshaled in support of such an assumption. That this forced exclusion was the result, in good measure, of this erroneous assumption of racial guilt rather than bona fide military necessity, is evidenced by the commanding general's final report on the evacuation from the Pacific Coast area. In it, he refers to all individuals of Japanese descent as subversive, as belonging to an enemy race, whose racial strains are undiluted, and as constituting over 112,000 potential enemies at large today along the Pacific coast. In support of this blanket condemnation of all persons of Japanese descent, however, no reliable evidence is cited to show that such individuals were generally disloyal or had generally so conducted themselves in this way as to constitute a special menace to defense installations or war industries, or had otherwise, by their behavior, furnished reasonable ground for their exclusion as a group. Justification for the exclusion is sought instead mainly upon questionable racial and sociological grounds not ordinarily within the realm of expert military judgment, supplemented by certain semi-military conclusions drawn from an unwarranted use of circumstantial evidence. Individuals of Japanese ancestry are condemned because they are said to be a large, unassimilated, tightly knit racial group, bound to an enemy nation by strong ties of race, culture, custom, and religion. They are claimed to be given to emperor-worshipping ceremonies and to dual citizenship. Japanese language schools and allegedly pro-Japanese organizations are cited as evidence of possible group disloyalty, together with facts as to certain persons being educated and residing at length in Japan. It is intimated that many of these individuals deliberately resided adjacent to strategic points, thus enabling them to carry into execution a tremendous program of sabotage on a mass scale should any considerable number of them have been inclined to do so. The need for protective custody is also asserted. The report refers without identity to numerous incidents of violence, as well as to other admittedly unverified or cumulative incidents. From this, plus certain other events not shown to have been connected with the Japanese Americans, it is concluded that the situation was fraught with danger to the Japanese population itself, and that the general public was ready to take matters into its own hands. Finally, it is intimated, though not directly charged or proved, that persons of Japanese ancestry were responsible for 3 minor isolated shellings and bombings of the Pacific Coast area, as well as for unidentified radio transmissions and night signaling. The main reasons relied upon by those responsible for the forced evacuation, therefore, do not prove a reasonable relation between the group characteristics of Japanese Americans and the dangers of invasion, sabotage, and espionage. The reasons appear instead to be largely an accumulation of much of the misinformation, half-truths, and insinuations that for years have been directed against Japanese Americans by people with racial and economic prejudices, the same people who have been among the foremost advocates of the evacuation. A military judgment based upon such racial and sociological considerations is not entitled to the great weight ordinarily given the judgments based upon strictly military considerations. Especially is this so when every charge relative to race, religion, culture, geographical location, and legal and economic status has been substantially discredited by independent studies made by experts in these matters. The military necessity which is essential to the validity of the evacuation order thus resolves itself into a few intimations that certain individuals actively aided the enemy, from which it is inferred that the entire group of Japanese Americans could not be trusted to be or remain loyal to the United States. No one denies, of course, that there were some disloyal persons of Japanese descent on the Pacific coast who did all in their power to aid their ancestral land. Similar disloyal activities have been engaged in by many persons of German, Italian, and even more pioneer stock in our country. But to infer that examples of individual disloyalty prove group disloyalty and justify discriminatory action against the entire group is to deny that under our system of law, individual guilt is the sole basis for deprivation of rights. Moreover, this inference, which is at the very heart of the evacuation orders, has been used in support of the abhorrent and despicable treatment of minority groups by the dictatorial tyrannies which this nation is now pledged to destroy. To give constitutional sanction to that inference in this case, however well-intentioned, may have been the military command on the Pacific coast, is to adopt one of the cruelest of the rationales used by our enemies to destroy the dignity of the individual and to encourage and open the door to discriminatory actions against other minority groups in the passions of tomorrow. No adequate reason is given for the failure to treat these Japanese Americans on an individual basis by holding investigations and hearings to separate the loyal from the disloyal, as was done in the case of persons of German and Italian ancestry. It is asserted merely that the loyalties of this group were unknown and time was of the essence. Yet nearly 4 months elapsed after Pearl Harbor before the first exclusion order was issued. Nearly 8 months went by until the last order was issued, and the last of these subversive persons was not actually removed until almost 11 months had elapsed. Leisure and deliberation seem to have been more of the essence than speed, and the fact that conditions were not such as to warrant a declaration of martial law adds strength to the belief that the factors of time and military necessity were not as urgent as they have been represented to be. Moreover, there was no adequate proof that the Federal Bureau of Investigation and the military and naval intelligence services did not have the espionage and sabotage situation well in hand during this long period. Nor is there any denial of the fact that not one person of Japanese ancestry was accused or convicted of espionage or sabotage after Pearl Harbor while they were still free, a fact which is some evidence of the loyalty of the vast majority of these individuals and of the effectiveness of the established methods of combating these evils. It seems incredible that under these circumstances, it would have been impossible to hold loyalty hearings for the mere 112,000 persons involved, or at least for the 70,000 American citizens, especially when a large part of this number represented children and elderly men and women. Any inconvenience that may have accompanied an attempt to conform to procedural due process cannot be said to justify violations of constitutional rights of individuals. I dissent, therefore, from this legalization of racism. Racial discrimination in any form and in any degree has no justifiable part whatever in our democratic way of life. It is unattractive in any setting, but it is utterly revolting among a free people who have embraced the principles set forth in the Constitution of the United States. All residents of this nation are kin in some way by blood or culture to a foreign land, yet they are primarily and necessarily a part of the new and distinct civilization of the United States. They must accordingly be treated at all times as the heirs of the American experiment and as entitled to all the rights and freedoms guaranteed by the Constitution. End of Part 3. Part 4 of Korematsu v. United States. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Korematsu v. United States. An opinion of the United States Supreme Court. Part 4. Decided on December 18th, 1944. Please note, Part 4 is a reading of Mr. Justice Jackson's dissent. This reading does not include a reading of the court's opinion, Justice Frankfurter's concurrence, Justice Roberts' dissent, or Justice Murphy's dissent. For ease of listening, this reading omits footnotes and legal citations found within the text of the court's opinion. Korematsu was born on our soil, of parents born in Japan. The Constitution makes him a citizen of the United States by nativity and a citizen of California by residence. No claim is made that he is not loyal to this country. There is no suggestion that, apart from the matter involved here, he is not law-abiding and well-disposed. Korematsu, however, has been convicted of an act not commonly a crime. It consists merely of being present in the state whereof he is a citizen, near the place where he was born, and where all his life he has lived. Even more unusual is the series of military orders which made this conduct a crime. They forbid such a one to remain, and they also forbid him to leave. They were so drawn that the only way Korematsu could avoid violation was to give himself up to the military authority. This meant submission to custody, examination, and transportation out of the territory, to be followed by indeterminate confinement in detention camps. A citizen's presence in the locality, however, was made a crime only if his parents were of Japanese birth. Had Korematsu been one of 4, the others being, say, a German alien enemy, an Italian alien enemy, and a citizen of American-born ancestors, convicted of treason but out on parole, only Korematsu's presence would have violated the order. The difference between their innocence and his crime would result not from anything he did, said, or thought different than they, but only in that he was born of a different racial stock. Now, if any fundamental assumption underlies our system, it is that guilt is personal and not inheritable. Even if all of one's antecedents had been convicted of treason, the Constitution forbids its penalties to be visited upon him, for it provides that no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. But here is an attempt to make an otherwise innocent act a crime merely because this prisoner is the son of parents as to whom he had no choice and belongs to a race from which there is no way to resign. If Congress in peacetime legislation should enact such a criminal law, I should suppose this court would refuse to enforce it. But the law which this prisoner is convicted of disregarding is not found in any act of Congress, but in a military order. Neither the act of Congress nor the executive order of the President, nor both together, would afford a basis for this conviction. It rests on the orders of General DeWitt, and it is said that if the military commander had reasonable military grounds for promulgating the orders, they are constitutional and become law, and the court is required to enforce them. There are several reasons why I cannot subscribe to this doctrine. It would be impracticable and dangerous idealism to expect or insist that each specific military command in an area of probable operations will conform to conventional tests of constitutionality. When an area is so beset that it must be put under military control at all, the paramount consideration is that its measures be successful rather than legal. The armed services must protect a society, not merely its constitution. The very essence of the military job is to marshal physical force, to remove every obstacle to its effectiveness, to give it every strategic advantage. Defense measures will not, and often should not, be held within the limits that bind civil authority in peace. No court can require such a commander in such circumstances to act as a reasonable man. He may be unreasonably cautious and exacting. Perhaps he should be. But a commander in temporarily focusing the life of a community on defense is carrying out a military program. He is not making law in the sense the courts know the term. He issues orders, and they may have a certain authority as military commands, although they may be very bad as constitutional law. But if we cannot confine military expedients by the Constitution, neither would I distort the Constitution to approve all that the military may deem expedient. This is what the court appears to be doing, whether consciously or not. I cannot say from any evidence before me that the orders of General DeWitt were not reasonably expedient military precautions, nor could I say that they were. But even if they were permissible military procedures, I deny that it follows that they are constitutional. If, as the court holds, it does follow, then we may as well say that any military order will be constitutional and have done with it. The limitation under which courts always will labor in examining the necessity for a military order are illustrated by this case. How does the court know that these orders have a reasonable basis in necessity? No evidence whatever on that subject has been taken by this or any other court. There is sharp controversy as to the credibility of the DeWitt report. So the court, having no real evidence before it, has no choice but to accept General DeWitt's own unsworn, self-serving statement, untested by any cross-examination, that what he did was reasonable. And thus it will always be when courts try to look into the reasonableness of a military order. In the very nature of things, military decisions are not susceptible of intelligent judicial appraisal. They do not pretend to rest on evidence, but are made on information that often would not be admissible and on assumptions that could not be proved. Information in support of an order could not be disclosed to courts without danger that it would reach the enemy. Neither can courts act on communications made in confidence. Hence, courts can never have any real alternative to accepting the mere declaration of the authority that issued the order that it was reasonably necessary from a military viewpoint. Much is said of the danger to liberty from the Army program for deporting and detaining these citizens of Japanese extraction. But a judicial construction of the Due Process Clause that will sustain this order is a far more subtle blow to liberty than the promulgation of the order itself. A military order, however unconstitutional, is not apt to last longer than the military emergency. Even during that period, a succeeding commander may revoke it all. But once a judicial opinion rationalizes such an order to show that it conforms to the Constitution, or rather rationalizes the Constitution to show that the Constitution sanctions such an order, the court for all time has validated the principle of racial discrimination in criminal procedure and of transplanting American citizens. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward plausible claim of an urgent need. Every repetition embeds that principle more deeply in our law and thinking and expands it to new purposes. All who observe the work of courts are familiar with what Judge Cardoza described as the tendency of a principle to expand itself to the limit of its logic. A military commander may overstep the bounds of constitutionality, and it is an incident. But if we review and approve, that passing incident becomes the doctrine of the Constitution. There it has a generative power of its own, and all that it creates will be in its own image. Nothing better illustrates this danger than does the court's opinion in this case. It argues that we are bound to uphold the conviction of Korematsu because we upheld one in Hirabayashi v. United States, when we sustained these orders insofar as they applied a curfew requirement to a citizen of Japanese ancestry. I think we should learn something from that experience. In that case, we were urged to consider only that curfew feature, that being all that technically was involved, because it was the only count necessary to sustain Hirabayashi's conviction and sentence. We yielded, and the Chief Justice guarded the opinion as carefully as language will do. He said, "Our investigation here does not go beyond the inquiry whether, in the light of all the relevant circumstances preceding and attending their promulgation, the challenged orders and statute afforded a reasonable basis for the action taken in imposing the curfew. We decide only the issue as we have defined it. We decide only that the curfew order as applied, and at the time it was applied, was within the boundaries of the war power. And again, it is unnecessary to consider whether or to what extent such findings would support orders differing from the curfew order. However, in spite of our limiting words, we did validate a discrimination on the basis of ancestry for mild and temporary deprivation of liberty. Now the principle of racial discrimination is pushed from support of mild measures to very harsh ones, and from temporary deprivations to indeterminate ones. And the precedent which it is said requires us to do so is Hirabayashi. The court is now saying that in Hirabayashi, we did decide the very things we there said we were not deciding, because we said that these citizens could be made to stay in their homes during the hours of dark It is said we must require them to leave home entirely, and if that, we are told they may also be taken into custody for deportation, and if that, it is argued they may also be held for some undetermined time in detention camps. How far the principle of this case would be extended before plausible reasons would play out, I do not know. I should hold that a civil court cannot be made to enforce an order which violates constitutional limitations, even if it is a reasonable exercise of military authority. The courts can exercise only the judicial power, can apply only law, and must abide by the Constitution, or they cease to be civil courts and become instruments of military policy. Of course, the existence of a military power resting on force, so vagrant, so centralized, so necessarily heedless of the individual, is an inherent threat to liberty. But I would not lead people to rely on this court for a review that seems to me wholly delusive. The military reasonableness of these orders can only be determined by military superiors. If the people ever let command of the war power fall into irresponsible and unscrupulous hands, the courts wield no power equal to its restraint. The chief restraint upon those who command the physical forces of the country, in the future as in the past, must be their responsibility to the political judgments of their contemporaries and to the moral judgments of history. My duties as a justice, as I see them, do not require me to make a military judgment as to whether General DeWitt's evacuation and detention program was a reasonable military necessity. I do not suggest that the courts should have attempted to interfere with the Army in carrying out its task, but I do not think they may be asked to execute a military expedient that has no place in law under the Constitution. I would reverse the judgment and discharge the prisoner. End of Part 4. End of Korematsu versus United States. An opinion of the United States Supreme Court. Colegrove versus Green. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Colegrove versus Green. An opinion of the United States Supreme Court. Decided on June 10th, 1946. Please note, this is a reading of the opinion of the court only. This reading does not include Justice Rutledge's concurrence or Justice Black's dissent. For ease of listening, this reading omits legal citations and footnotes found within the text of the court's opinion. Mr. Justice Frankfurter delivered the opinion of the court. This case is appropriately here, under Section 266 of the Judicial Code, on direct review of a judgment of the District Court of the Northern District of Illinois, composed of 3 judges, dismissing the complaint of these appellants. Petitioners are 3 qualified voters in Illinois districts which have much larger populations than other Illinois congressional districts. They brought this suit against the Governor, the Secretary of State, and the Auditor of the State of Illinois as members ex officio of the Illinois Primary Certifying Board to restrain them, in effect, from taking proceedings for an election in November 1946 under the provisions of Illinois law governing congressional districts. Formally, the appellees asked for a decree with its incidental relief, declaring these provisions to be invalid because they violated various provisions of the United States Constitution and Section 3 of the Reapportionment Act of August 8, 1911. In that by reason of subsequent changes in population, the congressional districts for the election of representatives in the Congress, created by the Illinois laws of 1901, lacked compactness of territory and approximate equality of population. The District Court, feeling bound by this court's opinion in Wood v. Broom dismissed the bill. The district court was clearly right in deeming itself bound by Wood v. Broom, and we could also dispose of this case on the authority of Wood v. Broom. The legal merits of this controversy were settled in that case, inasmuch as it held that the Reapportionment Act of June 18, 1929, has no requirements as to the compactness, contiguity, and equality in population of districts. The Act of 1929 still governs the districting for the election of representatives. It must be remembered that not only was the legislative history of the matter fully considered in Wood v. Broom, but the question had been elaborately before the court in Smiley v. Holm, Koning v. Flynn, and Carroll v. Becker, argued a few months before Wood v. Broom was decided. Nothing has now been adduced to lead us to overrule what this court found to be the requirements under the Act of 1929. The more so since 7 congressional elections have been held under the Act of 1929 as construed by this court. No manifestation has been shown by Congress even to question the correctness of that which seemed compelling to this court in enforcing the will of Congress in Wood v. Broom. But we also agree with the 4 justices, Brandeis, Stone, Roberts, and Cardozo, who were of opinion that the bill in Wood v. Broom should be dismissed for want of equity. To be sure, the present complaint, unlike the bill in Wood v. Broom, was brought under the Federal Declaratory Judgment Act, which, not having been enacted until 1934, was not available at the time of Wood v. Broom. But that act merely gave the federal courts competence to make a declaration of rights even though no decree of enforcement be immediately asked. It merely permitted a freer movement of the federal courts within the recognized confines of the scope of equity. The Declaratory Judgment Act only provided a new form of procedure for the adjudication of rights in conformity with established equitable principles. And so, the test for determining whether a federal court has authority to make a declaration such as is here asked is whether the controversy would be justiciable in this court if presented in a suit for injunction. We are of opinion that the petitioners ask of this court what is beyond its competence to grant. This is one of those demands on judicial power which cannot be met by verbal fencing about jurisdiction. It must be resolved by considerations on the basis of which this court, from time to time, has refused to intervene in controversies. It has refused to do so because due regard for the effective working of our government revealed this issue to be of a peculiarly political nature and therefore not meet for judicial determination. This is not an action to recover for damage because of the discriminatory exclusion of a plaintiff from rights enjoyed by other citizens. The basis for the suit is not a private wrong, but a wrong suffered by Illinois as a polity. In effect, this is an appeal to the federal courts to reconstruct the electoral process of Illinois in order that it may be adequately represented in the councils of the nation. Because the Illinois legislature has failed to revise its congressional representative districts in order to reflect great changes during more than a generation in the distribution of its population, we are asked to do this, as it were, for Illinois. Of course, no court can affirmatively remap the Illinois districts so as to bring them more in conformity with the standards of fairness for a representative system. At best, we could only declare the existing electoral system invalid. The result would be to leave Illinois undistricted and to bring into operation, if the Illinois legislature chose not to act, the choice of members for the House of Representatives on a statewide ticket. The last stage may be worse than the first. The upshot of judicial action may defeat the vital political principle which led Congress more than 100 years ago to require districting. This requirement, in the language of Chancellor Kent, was recommended by the wisdom and justice of giving, as far as possible, to the local subdivisions of the people of each state a due influence in the choice of representatives, so as not to leave the aggregate minority of the people in a state, though approaching perhaps to a majority, to be wholly overpowered by the combined action of the numerical majority, without any voice whatever in the national councils. Assuming acquiescence on the part of the authorities of Illinois in the selection of its representatives by a mode that defies the direction of Congress for selection by districts, the House of Representatives may not acquiesce. In the exercise of its power to judge the qualifications of its own members, the House may reject a delegation of representatives at large. Nothing is clearer than that this controversy concerns matters that bring courts into immediate and active relations with party contests. From the determination of such issues, this court has traditionally held aloof. It is hostile to a democratic system to involve the judiciary in the politics of the people, and it is not less pernicious if such judicial intervention in an essentially political contest be dressed up in the abstract phrases of the law. The petitioners urge, with great zeal, that the conditions under which they complain are grave evils and offend public morality. The Constitution of the United States gives ample power to provide against these evils, but due regard for the Constitution as a viable system precludes judicial correction. Authority for dealing with such problems resides elsewhere. Article 1, Section 4 of the Constitution provides that the times, places, and manner of holding elections for representative shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations. The short of it is that the Constitution has conferred upon Congress exclusive authority to secure fair representation by the states in the popular House, and left to that House determination whether states have fulfilled their responsibility. If Congress failed in exercising its powers, whereby standards of fairness are offended, the remedy ultimately lies with the people. Whether Congress faithfully discharges its duty or not, the subject has been committed to the exclusive control of Congress, an aspect of government from which the judiciary, in view of what is involved, has been excluded by the clear intention of the Constitution, cannot be entered by the federal courts because Congress may have been in default in exacting from states obedience to its mandate. The one stark fact that emerges from a study of the history of congressional apportionment is its embroilment in politics, in the sense of party contests and party interests. The Constitution enjoins upon Congress the duty of apportioning representatives among the several states according to their respective numbers, yet Congress has at times been heedless of this command and not apportioned according to the requirements of the census. It never occurred to anyone that this court could issue mandamus to compel Congress to perform its mandatory duty to apportion. What might not be done directly by mandamus could not be attained indirectly by injunction. Until 1842, there was the greatest diversity among the states in the manner of choosing representatives because Congress had made no requirement for districting. Congress then provided for the election of representatives by districts. Strangely enough, the power to do so was seriously questioned. It was still doubted by a committee of Congress as late as 1901. In 1850, Congress dropped the requirement. The Reapportionment Act of 1862 required that the districts be of contiguous territory. In 1872, Congress added the requirement of substantial equality of inhabitants. This was reinforced in 1911. But the 1929 Act, as we have seen, dropped these requirements. Throughout our history, whatever may have been the controlling Apportionment Act, The most glaring disparities have prevailed as to the contours and the population of districts. To sustain this action would cut very deep into the very being of Congress. Courts ought not to enter this political thicket. The remedy for unfairness in districting is to secure state legislatures that will apportion properly, or to invoke the ample powers of Congress. The Constitution has many commands that are not enforceable by courts because they clearly fall outside the conditions and purposes that circumscribe judicial action. Thus, on demand of the executive authority of a state, it is the duty of a sister state to deliver up a fugitive from justice. But the fulfillment of this duty cannot be judicially enforced. The duty to see to it that the laws are faithfully executed cannot be brought under legal compulsion. Violation of the great guarantee of a republican form of government in states cannot be challenged in the courts. The Constitution has left the performance of many duties in our governmental scheme to depend on the fidelity of the executive and legislative action, and ultimately on the vigilance of the people in exercising their political rights. Dismissal of the complaint is affirmed. End of Colegrove v. Green, an opinion of the United States Supreme Court. Shelley v. Kraemer. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Kelly Robinson in Birmingham, Alabama. Shelley v. Kraemer, an opinion of the United States Supreme Court. Decided on May 3rd, 1948. Please note, this is a reading of the opinion of the court only. For ease of listening, this reading omits legal citations and footnotes found within the text of the court's opinion. Mr. Chief Justice Vinson delivered the opinion of the court. These cases present for our consideration questions relating to the validity of court enforcement of private agreements, generally described as restrictive covenants, which have as their purpose the exclusion of persons of designated race or color from the basic constitutional issues of obvious importance, have been raised. The first of these cases comes to this court on certiorari to the Supreme Court of Missouri on February 16, 1911. 30 out of a total of 39 owners of property fronting both sides of Labadie Avenue between Taylor Avenue and Cora Avenue in the city of St. Louis signed an agreement which was subsequently recorded, providing in part, the said property is hereby restricted to the use and occupancy for the term of 50 years from this date, so that it shall be a condition all the time and whether recited and referred to as not in subsequent conveyances, and shall attach to the land as a condition precedent to the sale of the same, that hereafter no part of said property or any portion thereof shall be, for said term of 50 years, occupied by any person not of the Caucasian race, it being intended hereby to restrict the use of said property for said period of time against the occupancy as owners or tenants of any portion of said property for resident or other purpose by people of the Negro or Mongolian race. The entire district described in the agreement included 57 parcels of land. The 30 owners who signed the agreement held title to 47 parcels, including the particular parcel involved in this case. At the time the agreement was signed, 5 of the parcels in the district were owned by Negroes. One of those had been occupied by Negro families since 1882, nearly 30 years before the restrictive agreement was executed. The trial court found that owners of 7 out of 9 homes on the south side of Labadie Avenue, within the restricted district and in the immediate vicinity of the premises in question had failed to sign the restrictive agreement in 1911. At the time this action was brought, 4 of the premises were occupied by Negroes and had been so occupied for periods ranging from 23 to 63 years. A 5th parcel had been occupied by Negroes until a year before this suit was instituted. On August 11, 1945, pursuant to a contract of sale, petitioners Shelley, who are Negroes, for valuable consideration received from one Fitzgerald a warranty deed to the parcel in question. The trial court found that petitioners had no actual knowledge of the restrictive agreement at the time of the purchase. On October 9, 1945, respondents, as owners of other property subject to the terms of the restrictive covenant, brought suit in Circuit Court of the City of St. Louis, praying that petitioners Shelley be restrained from taking possession of the property and that judgment be entered divesting title out of petitioner Shelley and revesting title in the immediate grantor or in such other person as the court should direct. The trial court denied the requested relief on the ground that the restrictive agreement upon which respondents based their action had never become final and complete because it was the intention of the parties to that agreement that it was not to become effective until signed by all party owners in the district, and signatures of all the owners had never been obtained. The Supreme Court of Missouri, sitting en banc, reversed and directed the trial court to grant the relief for which respondents had prayed. That court held the agreement effective and concluded that enforcement of its provisions violated no rights guaranteed to petitioners by the federal Constitution. At the time the court rendered its decision, petitioners were occupying the property in question. The second of the cases under consideration comes to this court from the Supreme Court of Michigan. The circumstances presented do not differ materially from the Missouri case. In June 1934, one Ferguson and his wife, who then owned the property located in the city of Detroit, which is involved in this case, executed a contract providing in part, "This property shall not be used or occupied by any person or persons except those of the Caucasian race. It is further agreed that this restriction shall not be effective unless at least 80% of the property fronting on both sides of the street in the block where our land is located is subjected to this or a similar restriction." The agreement provided that the restrictions were to remain in effect until January 1st, 1960. The contract was subsequently recorded, and similar agreements were executed with respect to 80% of the lots in the block in which the property in question is situated. By deed dated November 30th, 1944, petitioners who were found by the trial court to be Negroes acquired title to the property and thereupon entered into its occupancy. On January 30th, 1945, respondents, as owners of the property subject to the terms of the restrictive agreement, brought suit against petitioners in the Circuit Court of Wayne County. After a hearing, the court entered a decree directing petitioners to move from the property within 90 days. Petitioners were further enjoined and restrained from using or occupying the premises in the future. On appeal, the Supreme Court of Michigan affirmed, deciding adversely to petitioners' contentions that they had been denied rights protected by the 14th Amendment. Petitioners have placed primary reliance on their contentions, first raised in the state courts, that judicial enforcement of the restrictive agreements in these cases has violated rights guaranteed to petitioners by the 14th Amendment of the Federal Constitution and acts of Congress passed pursuant to that amendment. Specifically, petitioners urge that they have been denied the equal protection of the laws, deprived of property without due process of law, and have been denied privileges and immunities of citizens of the United States. We pass to a consideration of those issues. Whether the Equal Protection Clause of the 14th Amendment inhibits judicial enforcement by state courts of restrictive covenants based on race or color is a question which this court has not heretofore been called upon to consider. Only 2 cases have been decided by this court which in any way have involved the enforcement of such agreements. The first of these was the case of Corrigan v. Buckley. There, suit was brought in the courts of the District of Columbia to enjoin a threatened violation of certain restrictive covenants relating to land situated in the city of Washington. Relief was granted, and the case was brought here on appeal. It is apparent that that case, which had originated in the federal courts and involved the enforcement of covenants on land located in the District of Columbia, could present no issues under the 14th Amendment, for that amendment by its terms applies only to the states. Nor was the question of the validity of court enforcement of the restrictive covenants under the Fifth Amendment properly before the court, as the opinion of this court specifically recognizes. The only constitutional issue which the appellants had raised in the lower courts, and hence the only constitutional issue before this court on appeal, was the validity of the covenant agreements as such. This court concluded that since the inhibitions of the constitutional provisions invoked apply only to governmental action, as contrasted to action of private individuals, there was no showing that the covenants, which were simply agreements between private property owners, were invalid. Accordingly, the appeal was dismissed for want of a substantial question. Nothing in the opinion of this court, therefore, may properly be regarded as an adjudication on the merits of the constitutional issues presented by these cases, which raise the question of the validity, not of the private agreements as such, but of the judicial enforcement of those agreements. The second of the cases involving racial restrictive covenants was Hansberry v. Lee. In that case, petitioners, white property owners, were enjoined by the state courts from violating the terms of a restrictive agreement. The state Supreme Court had held petitioners bound by an earlier judicial determination in litigation in which petitioners were not parties, upholding the validity of the restrictive agreement, although in fact the agreement had not been signed by the number of owners necessary to make it effective under state law. This court reversed the judgment of the state Supreme Court upon the ground that petitioners had been denied due process of law in being held estopped to challenge the validity of the agreement on the theory accepted by the state court that the earlier litigation in which petitioners did not participate was in the nature of a class suit. In arriving at its result, this court did not reach the issues presented by the cases now under consideration. It is well, at the outset, to scrutinize the terms of the restrictive agreements involved in these cases. In the Missouri case, the covenant declares that no part of the affected property shall be occupied by any person not of the Caucasian race, it being intended hereby to restrict the use of said property against the occupancy as owners or tenants of any portion of said property for resident or other purpose by people of the Negro or Mongolian race. Not only does the restriction seek to prescribe use and occupancy of the affected properties by members of the excluded class, but as construed by the Missouri courts, the agreement requires that title of any person who uses his property in violation of the restriction shall be divested. The restriction of the covenant in the Michigan case seeks to bar occupancy by persons of the excluded class. It provides that this property shall not be used or occupied by any person or persons except those of the Caucasian race. It should be observed that these covenants do not seek to prescribe any particular use of the affected properties. Use of the properties for residential occupancy as such is not forbidden. The restrictions of these agreements rather are directed toward a designated class of persons and seek to determine who may and who may not own or make use of the properties for residential purposes. The excluded class is defined wholly in terms of race or color, simply that and nothing more. It cannot be doubted that among the civil rights intended to be protected from discriminatory state action by the 14th Amendment are the rights to acquire, enjoy, own, and dispose of property. Equality in the enjoyment of property rights was regarded by the framers of that amendment as an essential precondition to the realization of other basic civil rights and liberties which the amendment was intended to guarantee. Thus, Section 1978 of the Revised Statutes, derived from Section 1 of the Civil Rights Act of 1866, which was enacted by Congress while the 14th Amendment was also under consideration, provides All citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. This court has given specific recognition to the same principle. It is likewise clear that restrictions on the right of occupancy of the sort sought to be created by the private agreements in these cases could not be squared with the requirements of the 14th Amendment if imposed by state statute or local ordinance. We do not understand respondents to urge the contrary. In the case of Buchanan v. Worley, a unanimous court declared unconstitutional the provisions of a city ordinance which denied to colored persons the right to occupy houses in blocks in which the greater number of houses were occupied by white persons, and imposed similar restrictions on white persons with respect to blocks in which the greater number of houses were occupied by colored persons. During the course of the opinion in that case, this court stated, "The 14th Amendment and these statutes enacted in furtherance of its purpose operate to qualify and entitle a colored man to acquire property without state legislation discriminating against him solely because of color." In Harmon v. Tyler, a unanimous court, on the authority of Buchanan v. Worley, declared invalid an ordinance which forbade any Negro to establish a home on any property in a white community or any white person to establish a home in a Negro community, except on the written consent of a majority of the persons of the opposite race inhabiting such community or portion of the city to be affected. The precise question before this court in both the Buchanan and Harmon cases involved the rights of white sellers to dispose of their properties free from restrictions as to potential purchasers based on considerations of race or color, but that such legislation is also offensive to the rights of those desiring to acquire and occupy property and barred on grounds of race or color is clear, not only from the language of the opinion in Buchanan v. Worley, but from this court's disposition of the case of City of Richmond v. Deans. There, a Negro barred from the occupancy of certain property by the terms of an ordinance similar to that in the Buchanan case sought injunctive relief in the federal courts to enjoin the enforcement of the ordinance on the grounds that its provisions violated the terms of the 14th Amendment. Such relief was granted, and this court affirmed, finding the citation of Buchanan v. Worley and Harmon v. Tyler sufficient to support its judgment. But the present cases, unlike those just discussed, do not involve action by state legislatures or city councils. Here, the particular patterns of discrimination in the areas in which the restrictions are to operate are determined in the first instance by the terms of agreements among private individuals. Participation of the state consists in the enforcement of the restrictions so defined. The crucial issue with which we are here confronted is whether this distinction removes these cases from the operation of the prohibitory provisions of the 14th Amendment. Since the decision of this court in the civil rights cases, the principle has become firmly embedded in our constitutional law that the action inhibited by the first section of the 14th Amendment is only such action as may fairly be said to be that of the states. That amendment erects no shield against merely private conduct, however discriminatory or wrongful. We conclude, therefore, that the restrictive agreements, standing alone, cannot be regarded as a violation of any rights guaranteed to petitioners by the 14th Amendment, so long as the purposes of those agreements are effectuated by voluntary adherence to their terms. It would appear clear that there has been no action by the state, and the provisions of the amendment have not been violated. But here there was more. These are cases in which the purposes of the agreements were secured only by judicial enforcement by state courts of the restrictive terms of the agreements. The respondents urge that judicial enforcement of private agreements does not amount to state action, or in any event the participation of the state is so attenuated in character as not to amount to state action within the meaning of the 14th Amendment. Finally, it is suggested even if the states in these cases may be deemed to have acted in the constitutional sense, their action did not deprive petitioners of rights guaranteed by the 14th Amendment, we move to a consideration of these matters. That the action of state courts and of judicial officers in their official capacities is to be regarded as action of the state within the meaning of the 14th Amendment is a proposition which has long been established by decisions of this court. That principle was given expression in the earliest cases involving the construction of the terms of the 14th Amendment. Thus, in Commonwealth of Virginia versus Rives, this court stated, "It is doubtless true that a state may act through different agencies, either by its legislative, its executive, or its judicial authorities, and the prohibitions of the amendment extend to all action of the state, denying equal protection of the laws, whether it be action by one of these agencies or by another." In Ex parte Commonwealth of Virginia, the court observed, "A state acts by its legislative, its executive, or its judicial authorities. It can act in no other way." In the civil rights cases, this court pointed out that the amendment makes void state action of every kind, which is inconsistent with the guarantees therein contained and extends to manifestations of state authority in the shape of laws, customs, or judicial or executive proceedings. Language to like effect is employed no less than 18 times during the course of that opinion. Similar expressions giving specific recognition to the fact that judicial action is to be regarded as action on the state for the purposes of the 14th Amendment are to be found in numerous cases which have been more recently decided. In Twining v. New Jersey, the court said, "The judicial act of the highest court of the state in authoritatively construing and enforcing its laws is the act of the state." In Brinkerhoff Ferris Trust and Savings Company v. Hill, the court, through Mr. Justice Brandeis, stated, "The federal guarantee of due process extends to state action through its judicial as well as through its legislative, executive, or administrative branch of government." Further examples of such declarations in the opinions of this court are not lacking. One of the earliest applications of the prohibitions contained in the 14th Amendment to action of state judicial officials occurred in cases in which Negroes had been excluded from jury service in criminal prosecutions by reason of their race or color. These cases demonstrate also the early recognition by this court that state action in violation of the amendment's provisions is equally repugnant to the constitutional commands, whether directed by state statute or taken by a judicial official in the absence of a statute. Thus, in Strauder v. West Virginia, this court declared invalid a state statute restricting jury service to white persons as amounting to a denial of the equal protection of the laws to the colored defendant in that case. In the notice and opportunity to defend, has Ex parte Virginia held that a similar discrimination imposed by the action of a state judge denied rights protected by the amendment, despite the fact that the language of the state statute relating to jury service contained no such restrictions. The action of state courts in imposing penalties or depriving parties of other substantive rights without providing adequate notice and opportunity to defend has, of course, long been regarded as a denial of the due process of law guaranteed by the 14th Amendment. In numerous cases, this court has reversed criminal convictions in state courts for failure of those courts to provide the essential ingredients of a fair hearing. Thus, it has been held that convictions obtained in state courts under the domination of a mob are void. Convictions obtained by coerced confessions, by the use of perjured testimony known by the prosecution to be such, or without the effective assistance of counsel, have also been held to be exertions of state authority in conflict with the fundamental rights protected by the 14th Amendment. But the examples of state judicial action which have been held by this court to violate the amendment's commands are not restricted to situations in which the judicial proceedings were found in some manner to be procedurally unfair. It has been recognized that the action of state courts in enforcing a substantive common law rule formulated by those courts may result in the denial of rights guaranteed by the 14th Amendment, even though the judicial proceedings in such cases may have been in complete accord with the most rigorous conceptions of procedural due process. Thus, in American Federation of Labor versus Swing, enforcement by state courts of the common law policy of the state, which resulted in the restraining of peaceful picketing, was held to be state action of the sort prohibited by the amendment's guarantees of freedom of discussion. In Cantwell versus Connecticut, a conviction in a state court of the common law crime of breach of the peace was, under the circumstances of the case, found to be a violation of the amendment's commands relating to freedom of religion. In Bridges versus California, enforcement of the state's common law rule relating to contempts by publication was held to be state action inconsistent with the prohibitions of the 14th Amendment. The short of the matter is that from the time of the adoption of the 14th Amendment until the present, it has been the consistent ruling of this court that the action of the states to which the amendment has reference includes action of state courts and state judicial officials. Although, in construing the terms of the 14th Amendment, differences have from time to time been expressed as to whether particular types of state action may be said to offend the amendment's prohibitory provisions, it has never been suggested that state court action is immunized from the operation of those provisions simply because the act is that of the judicial branch of the state government. Against this background of judicial construction, extending over a period of some 3/4 of a century, we are called upon to consider whether enforcement by state courts of the restrictive agreements in these cases may be deemed to be the acts of those states, and if so, whether that action has denied these petitioners the equal protection of the laws which the amendment was intended to ensure. We have no doubt that there has been state action in these cases, in the full and complete sense of the phrase. The undisputed facts disclose that petitioners were willing purchasers of property upon which they desired to establish homes. The owners of the properties were willing sellers, and contracts of sale were accordingly consummated. It is clear that, but for the active intervention of the state courts, supported by the full panoply of state power, petitioners would have been free to occupy the properties in question without restraint. These are not cases, as has been suggested, in which the states have merely abstained from action, leaving private individuals free to impose such discriminations as they see fit. Rather, these are cases in which the states have made available to such individuals the full coercive power of government to deny to petitioners, on the grounds of race or color, the enjoyment of property rights in premises which petitioners are willing and financially able to acquire and which the grantors are willing to sell. The difference between judicial enforcement and non-enforcement of the restrictive covenant is the difference to petitioners between being denied rights of property available to other members of the community and being accorded full enjoyment of those rights on an equal footing. The enforcement of the restrictive agreements by the state courts in these cases was directed pursuant to the common law policy of the states as formulated by those courts in earlier decisions. In the Missouri case, enforcement of the covenant was directed in the first instance by the highest court of the state after the trial court had determined the agreement to be invalid for want of the requisite number of signatures. In the Michigan case, the order of enforcement by the trial court was affirmed by the highest state court. The judicial action in each case bears the clear and unmistakable imprimatur of the state. We have noted that previous decisions of this court have established the proposition that judicial action is not immunized from the operation of the 14th Amendment simply because it is taken pursuant to the state's common law policy, nor is the amendment ineffective simply because the particular pattern of discrimination which the state has enforced was defined initially by the terms of a private agreement. State action, as that phrase is understood for the purposes of the 14th Amendment, refers to exertions of state power in all forms. And when the effect of that action is to deny rights subject to the protection of the 14th Amendment, it is the obligation of this court to enforce the constitutional commands. We hold that in granting judicial enforcement of the restrictive agreements in these cases, the states have denied petitioners the equal protection of the laws, and that therefore the action of the state courts cannot stand. We have noted that freedom from discrimination by the states in the enjoyment of property rights was among the basic objectives sought to be effectuated by the framers of the 14th Amendment. That such discrimination has occurred in these cases is clear. Because of the race or color of these petitioners, they have been denied rights of ownership or occupancy enjoyed as a matter of course by other citizens of different race or color. The 14th Amendment declares that all persons, whether colored or white, shall stand equal before the laws of the states, and in regard to the colored race, for whose protection the amendment was primarily designed, that no discrimination shall be made against them by law because of their color. Only recently this court has had occasion to declare that a state law which denied equal enjoyment of property rights to a designated class of citizens of specified race and ancestry was not a legitimate exercise of the state's police power, but violated the guarantee of the equal protection of the laws. Nor may the discriminations imposed by the state courts in these cases be justified as proper exertions of state police power. Respondents urge, however, that since the state courts stand ready to enforce restrictive covenants, excluding white persons from the ownership or occupancy of property covered by such agreements, enforcement of covenants excluding colored persons may not be deemed a denial of equal protection of the laws to the colored persons who are thereby affected. This contention does not bear scrutiny. The parties have directed our attention to no case in which a court, state or federal, has been called upon to enforce a covenant excluding members of the white majority from ownership or occupancy of real property on grounds of race or color. But there are more fundamental considerations. The rights created by the first section of the 14th Amendment are, by its terms, guaranteed to the individual. The rights established are personal rights. It is therefore no answer to these petitioners to say that the courts may also be induced to deny white persons rights of ownership and occupancy on grounds of race or color. Equal protection of the laws is not achieved through indiscriminate imposition of inequalities. Nor do we find merit in the suggestion that property owners who are parties to these agreements are denied equal protection of the laws if denied access to the courts to enforce the terms of restrictive covenants and to assert property rights which the state courts have held to be created by such agreements. The Constitution confers upon no individual the right to demand action by the state, which results in the denial of equal protection of the laws to other individuals. And it would appear beyond question that the power of the state to create and enforce property interests must be exercised within the boundaries defined by the 14th Amendment. The problem of defining the scope of the restrictions which the federal Constitution imposes upon exertions of power by the states has given rise to many of the most persistent and fundamental issues which this court has been called upon to consider. That problem was foremost in the minds of the framers of the Constitution, and since that early day has arisen in a multitude of forms. The task of determining whether the action of a state offends constitutional provisions is one which may not be undertaken lightly. Where, however, it is clear the action of the state violates the terms of the fundamental charter, it is the obligation of this court so to declare. The historical context in which the 14th Amendment became a part of the Constitution should not be forgotten. Whatever else the framers sought to achieve, it is clear that the matter of primary concern was the establishment of equality in the enjoyment of basic civil and political rights, and the preservation of those rights from discriminatory action on the part of the states based on considerations of race or color. 75 years ago, this court announced that the provisions of the amendment are to be construed with this fundamental purpose in mind. Upon full consideration, we have concluded that in these cases, the states have acted to deny petitioners the equal protection of the laws guaranteed by the 14th Amendment. Having so decided, we find it unnecessary to consider whether petitioners have also been deprived of property without due process of law or denied privileges and immunities of citizens of the United States. For the reasons stated, the judgment of the Supreme Court of Missouri and the judgment of the Supreme Court of Michigan must be reversed. Reversed. End of Shelley versus Kraemer, a decision of the United States Supreme Court.